my lord, this suit was directed to appear on 7th July
Hmm.
for witness action of the defendant, my lord.
Yes.
Did not appear, my lord. Kindly fix a date, my lord. My learned friend is here.
But I appear for the defendant in this matter, my lord. On the last occasion, my lord, I had said that I have a witness, and your lordship had directed me, given certain directions upon it. Now, my lord, what has happened is, my lord, this is a very old suit, my lord, 2004 suit, my lord, the incidents of 2001-2, and it was in respect of State Bank of Jaipur and Bikaner, my lord. That has merged with State Bank of India subsequently. My lord, we have not found any documents, my lord, to that effect to say which. So, my lord, if your lordship, my only document which I wanted to bring on record, which though not pleaded in my written statement, was
What is your submission?
But
He wanted to case is to fix for witness action. What is your for the
lordship will
you are for the
kindly-
defendant?
your lordship will kindly in that case not fix it for arguments, not let him start his argument.
So you will not adduce evidence.
We really will not be able to prove anything from our defense, my lord. Only thing is let him prove his case, my lord, and then I'll argue on this.
No, so you will not adduce any evidence. So your witness is closed.
Yes, my lord.
So I will fix the
Kindly,
evidence.
my lord,
I will
record this
record your
submission, my lord.
submission.
Yes, my lord.
I will
Kindly.
record your submission now.
Then in that case, my lord, keep it to be mentioned tomorrow and then record.
Very well, my lord.
Tomorrow fix has to be mentioned.
Very well.
May I
Deeply
have-
Take instruction.
Very
If they will adduce
Yeah.
evidence, then otherwise fix the evidence.
May I have your lordship's kind leave to mention a commercial suit, your lordship? I am mentioning upon notice, your lordship.
For the plaintiff,
The
your lordship.
lordship was pleased to appoint a commissioner to record the evidence of the plaintiff's witness, your lordship. Your lordship, the plaintiff's plaintiff's witness examination in chief is over. I have commenced the cross-examination, but your lordship, there are several objections to marking of such documents as exhibits. Unless your lordship decides on whether at all those documents can be go in and as an exhibit, I cannot proceed with the cross-examination because my scope will be limited excessively. I have already commenced cross-examination, your lordship. I have mentioned it on previous occasion. Before I commenced cross-examination, your lordship was pleased to direct me.
What objection? What
Because your lordship,
the
those
document already disclosed?
documents, certain documents, your lordship, there are two objections are two.
No. The document which you want to rely upon by bringing on record as exhibit by way of exhibit, the
The
document you
plaintiff.
already exhibited.
Yes,
The document is already
Disclosed.
disclosed.
disclose your lordship.
Disclosed, your
Inspection
lordship.
completed
Completed your lordship.
and discuss that affidavit of
No,
admission
admission
denial.
denial not done.
Why?
Because your lordship, it proceeded directly to I am for the defendant, your lordship. It proceeded directly to witness examination. The parties had never approached your lordship for that.
So
There is no admission and
before
denial.
issued that discovery inspection was not done.
No, your lordship.
Lordship,
The
so
discovery inspection is done.
Then
The admission denial, your lordship.
once the
Now, the reason why I'm saying is many of the documents are photocopies, your lordship.
correct,
Your lordship, those cannot go in as an exhibit,
correct.
which is why I'm seeking for marking it for identification. Now, if your lordship is pleased to mark it for identification, I need not cross-examine on those documents at all. But if your lordship feels no, it will remain as exhibit with objection, then I can proceed.
You want to bring the evidence on record.
No, your lordship, the plaintiff's evidence, which I am objecting, your lordship.
the-
You are stating that plaintiff evidence is over. You are cross-examining.
Your lordship, yes, your lordship, the examination in chief.
chief is
I
over your
did not.
lordship.
The reason is this: during the examination in chief, if every day I bring it to your lordship, the commission will be delayed. So I have put in the objections, which I am seeking for your decision, your lordship.
I have not understand what you want to say. Plaintiff evidence is over. Chief is over.
Chief is over.
Chief is over.
Yes, your lordship.
Now you have started crossing. Whatever the document they want, that document has been exhibited, whatever it may
There
be.
I have put in the objections, your lordship,
they
that it cannot, certain documents cannot be marked as an exhibit.
Okay, you have put the objection that
Yes.
document has not been marked exhibit.
Yes, your lordship.
Then what you want now?
Now, your lordship, if unless whether it can be marked, it will be marked as an exhibit.
If you are objected, then how you can say it is to be marked exhibit?
Your lordship,
You have put the axe on your leg.
but the only issue is the learned commissioner does not have power to decide whether it will be marked as an exhibit or not. Unless
Once you objected, commissioner has taken as a expert identification or whatever it or with objection on
Yes.
your objection.
Yes.
Now you want that document is to be exhibited.
whether it be whether that objection will sustain before your
That
lordship.
at the time final hearing it will be decided.
That your lordship, on that my entire cross examination is dependent. Certain documents which are inherently inadmissible.
Sir,
Here your
one
lordship I
thing,
am.
law is clear. If you have objected for some document, you cannot cross examine. You are not able, liable. You are not entitled to cross examine on that document. It is
Yes, your
settled
lordship.
law.
Yes, your
If you have objected for exhibiting any document, and in cross examination you are not entitled to cross examine on that
Very well.
document.
But your lordship, kindly I'll only try to convey this once, your lordship, that documents, there are certain documents which during the cross examination in chief are marked for identification.
Hmm.
Now your lordship, then when it is marked for identification by your lordship, those documents will never go for cross examination.
Correct. That's
But
correct.
later on, if your lordship, I cannot now go for cross examination on those documents.
Correct.
But now once the evidence of the plaintiff's witness is closed,
Correct.
and your lordship feels
Hmm.
thereafter
Hmm.
that no, it ought not to have been marked for
Expert
identification.
identification. Whose objection?
My objection,
Then
your lord.
if you raise the objection and this expert identification, now what the court take the decision that is to be decided during the argument. So you have raised the objection. Now you want to relying upon
Your
the
lordship,
document.
the only classification what I am trying to
What
make is
classification further?
one is exhibits
Yeah,
with
either
objection.
either
That goes to that.
either you say file an application, you withdrawing your objection, then they will recall the plaintiff witness. If the document will be exhibited, then you will cross-examine. This is a procedure I know.
But your lordship, if it would have been before your lordship, and your lordship would have entertained that objection and marked it for identification, then your lordship, this issue wouldn't have arisen.
Why it is the commissioner? It is the expert.
The commissioner, and now the commissioner cannot decide on that, your lordship.
What decide? He already taken as an expert identification on your objection.
Your lordship, it has been marked as exhibit with the objection. That
Exhibit
is that we exhibit with objection. Now the only issue is that
You do
I am
one
only
thing, whatever the file and what are the document, bring here, I will see to that. Let the matter fix on Friday, as to be mentioned.
Friday is your holiday, your lordship. It's the 15th of this month.
Okay, Monday kar do.
Grateful, your lordship.
My lord, may I be permitted to
With
mention
the
matter?
with the minutes of the meeting of the you bring the minutes of the meeting of the commissioner.
Yes, sir.
I will. Grateful.
My lord, may I be permitted to mention a matter? My lord, this is a suit which was instituted in 2021, my lord. My lord, yesterday after the 2 p.m. matter got over, it was at item number 17, my lord. My lord, our counsel on behalf of the plaintiff was on legs, my lord, and the defendant had not appeared. My lord had made this returnable after puja vacations, my lord. My lord, I'm humbly praying if the matter could be taken up in August or September.
That is the problem. Once that court take strict order, next time the advocates to come and mention the matter. When the court was sitting idle, nobody will appear before this court.
My lord, our junior had appeared and
Nobody has appeared.
My lord, a junior had appeared and sought
He is
for a
not
pardon.
able to speak anything.
My lord,
If you send any statue before the court, what the court will do? If you are sending any junior, give the proper instruction what is to be made, what submission is to be made before the court.
I bow down, my lord.
Only because of the statue, the court cannot realize what he want to say. Court has 5 minutes has asked the question to your junior. What you want? My senior is not there. What you want? My senior is not there.
My lord, I most humbly apologize, my lord. My lord, if it could be taken up any day in the month
No,
of August.
I
my
am
lord.
telling all of you, if you are sending, I am not telling that not to send the junior. I welcome the juniors, but the welcome juniors should come with the instruction.
Yes, my lord.
Make some submission. Only by seeing the face of the junior, the court cannot pass any order. Juniors should make some submission. The court is giving opportunity, but the junior is not taking the benefit of that.
My lord.
It's tomorrow.
My lord,
Yes.
can it be kept next month, my lord? Sorry,
Let
next
it come
week,
as a 2 minutes and we'll see what is the stage.
Monday.
Yes.
Lordship's leave, may I mention CSCOM 236 of 2024.
Huh?
This CSCOM 236 of 2024.
Hmm.
This is the Purti fire matter in which the defendant had taken out a subpoena application.
Hmm.
The subpoena
Let
application.
it will come next week. Next week. I already directed my court officer. If you are going to the master and before the master you are raising an objection and coming before this court mentioning the matter.
Lordship, we had
You are
not,
playing the court, playing before the court. You have made a summons before the master, and the master has taken the summons for hearing, and you are telling them no, that you cannot decide. I will mention before the court.
Lordship,
Go, let
if
it
I may-
become
if I
after
may
15
indicate,
days.
It was fallen from the master herself that
No,
she-
there is a report. I have seen the report of the master. Let it become after month.
Both parties give consent, your lordship, master can do it, but if
That's why. That's I'm telling.
they objected, yes.
That's why I'm telling. You're telling before the master. No, I will move before the court. Let you move before the court. No, when the court will find time, I will take the matter.
Much obliged.
But may I have your lordship's leave, my lord, to file the written statement with the department subject to the acceptance of this court.
When you receive the writ of
But
summons.
7th of May, my lord, today we are on 87th day from the date of receipt, my lord. I am taking out an application also.
And you take the back page
Yes,
at the time of hearing.
my lord, that I'll take.
Leave is granted. Leave is granted to file the same in the department, subject to submit, subject to acceptance by the department in course of the day. Yes.
Lordship, I beg to appear on behalf of the plaintiff petitioner, Lordship.
Yes, why it is mentioned?
Lordship, your Lordship was pleased to pass an order on 16 July, Lordship, directing to substitute the legal heirs of the sole plaintiff, Lordship. And Lordship, there is a direction. It's to Lordship, actually, if your Lordship may kindly takes the 16 July order, Lordship, that paragraph 10, the next
Due to the
page, Lordship,
procedure-
the plaintiff is
due to the
directed to file
procedure
amended
filing-
plain within 2 weeks after the substitution is carried out and to serve the copy of the amended plain to the defendant within a week thereafter. Lordship, due to my illness, I was not attending court for a couple of
Whether the department is corrected?
no, Lordship, the department said that to take leave from the court as because there is delay, Lordship.
The plaintiff, the matter is listed as to be mentioned on the prayer made by the counsel for the plaintiff. By an order dated 16 July 2025, this court has directed to record the death of the plaintiff, sole plaintiff,
Sole plaintiff, Lordship.
record the death of the plaintiff and to substitute the legal heirs of the plaintiff as plaintiff 1A and 1B. This court also directed the plaintiff to file amended plaint within a period of 2 weeks after the substitution is carried out. Learned counsel for the plaintiff submitted due to his personal difficulties. The order could not be intimated to the department, and thus the department could not record the death of the plaintiff and make amendment and substituted the legal heirs of the plaintiff.
Lordship, we communicated the order to the department on 31st July.
Due to personal difficulty, counsel for the plaintiff submit that. Submit the baki cut. Submit that due to some personal difficulties, the order dated 16 July 2015 could not be carried out and prayed for extension of time to comply with the order dated 16 July 2025. Okay. In view of the submission made by the counsel for the plaintiff, time to comply with the order dated 16 July 2025 is extended for the period of 2 weeks from date.
Grateful, Lordship. Grateful.
Grateful, my lord. Lordship, item number 2, your lordship, I am for the plaintiff.
Yes, why
Only for your lordship, direction, your lordship, what happened? We tried to serve your lordship the copy of the writ of summons, but it's mentioned your lordship is left. Now the thing is, your lordship, we don't want to take any chance because this particular suit is your lordship order 37 suit. So we want your lordship an alternative your lordship newspaper publication. Otherwise everything will be done and thereafter your lordship they'll come and take this point. Address is left your lordship that door closed without any instruction. Checked your lordship, some of the Supreme Court said the shop closed is a good service. But your lordship,
Tomorrow, then again it will be difficult.
and again your lordship, there is presumption your lordship, section 27 of the general. Lordship, I will make a paper publication.
The matter is listed as to be mentioned on the prayer made by the counsel for the plaintiff. Plaintiff submits that the plaintiff has taken appropriate steps for service of writ of summons upon the defendants. Two defendants. Upon the defendants. But as per the service report dated 29 July 2025, issued by the Deputy Sheriff of Calcutta of this court, it is found that both the ways the writ of summons could not be served, and the writ of summons found that writ of summons could not be served upon the defendants. In the postal receipt, in the postal packet, it is mentioned that addressee closed and left without instruction. Counsel for the plaintiff submitted, as the plaintiff has taken steps for service of writ of summons upon the defendants both the ways, but it could not be served, and prays for substituted service by way of publication. In view of the submission made by the counsel for the plaintiff is given liberty to make publication of the note writ of summons of the instant suit for the information of the defendants in one English newspaper, namely
So once your lordship, English Times of India.
Times of India, and in Bangla newspaper, namely
And there's one vernacular language, your lordship, this showing your lordship daily Thanti.
where it is.
Lordship in Kerala, your lordship. Both are in Kerala.
The Hindu bola na? First one, Times of India, and not Bangla, and in it is the Tamil, this
Have daily.
Malayali language.
Yes, your lordship. Kerala. I'm getting your lordship is actually Tamil. May I just clarify and
What is the address?
Thanti. This Kerala, your lordship is.
Kerala, it is in Kerala.
Yes.
Malayalam newspaper.
Then your lordship Thanti is your lordship is showing your lordship in the Google.
Please check it.
Yes, your lordship.
And in Malayalam newspaper, which is duly circulated. In
Dina
the
Thanti.
district of
Thanti.
What is the district? Indian registered partnership having the business interior office Andur Kannakod. What is the district? Kannakod district or Pataminta?
Kannamkod Adur.
That is the district.
Yes, your lordship. This district specifically not mentioned.
Kannakod is
Padanam Tritha.
which
Pune
is,
dekho na
which is
dale.
really widely circulated at Adur AOOR Adur, comma Kanna KANNAMKOD Kannakod / Adur, comma Pattaminta. ये एड्रेस में देख लेना. केरला. Within 2 weeks.
Within 2 weeks. Your lordship.
Within 2 weeks.
And your lordship, the district is this Pathanan Namtintha.
That is the
Yes, your lordship.
district.
That is the district. I have got the instruction.
Huh? Within 2 weeks from date, the plaintiff will directly take appropriate steps for publication of the notice in the English daily newspaper, the Times of India, and in Malayali newspaper, namely Daily Tanthi.
It's a good.
Tanthi, which is widely circulated in the district.
I'm
Yes.
grateful.
Lordship. I'm for the plaintiff, Lordship.
Yes. Yes, madam.
Lordship,
What is the suit for?
Lordship,
Decree for 82 lakh, 8 crore, 29 lakhs 5,000. Credit in the defendant's account against the check which was read. When the check was dishonored, the check was
Lordship,
Cash.
Lordship, on 24 July 2023, one situation was occurred that the plaintiff bank was facing an issue, and thereafter the check was
How
uh,
your check was encashed in the account of the defendant?
Lordship, the fact was that on 24th July 2023, the plaintiff bank was facing a technical issue in the inward clearing instruments, and thereafter the check was the amount was credited into the defendant's bank account through the check truncation system.
Which bank? Where the bank situates?
Lordship, the bank.
You have deposited the amount. UCO Bank. Who has issued the check? You issued the check.
Lordship, the check was issued by the defendant number 10, Mr. Jaidul Islam.
Defendant number 10.
Yes, Lordship.
To you.
To UCO Bank.
UCO. That's a UCO Bank. You are for a UCO Bank. To
Lordship,
you.
Lordship.
So, but the amount has gone to the HDFC.
Yes, Lordship, what was happened, one, a check has, to clear the check, uh, Lordship, to clear the check, one NPCI portal is there, and the NPCI always cleared the check amount and debited the amount to the bank. Okay. Now, what was happened in this case? One technical issue was facing by the plaintiff bank, and thereafter the amount was debited to that bank, but after but on one Lordship. On 25th July, when the issue was resolved, the plaintiff bank has found that the account was has had insufficient funds, and thereafter when and not that check was there was a check amounting to rupees 4.75 crores, except the check number 130230 amounting to rupees 69,70,000. All check was returned, all the amount was returned back to the UCO bank, but except this check,
Okay. The plaintiff has filed the suit praying for a decree for a sum of rupees 8,29,5,000, being the amount wrongly credited in the defendant's account against a check which was in respect of an account having insufficient balance, along with interest at the rate of 12% per annum. Full counsel for the plaintiff submitted. The plaintiff is within the jurisdiction of this court, and the defendants are outside the jurisdiction of this court, and part cause of action arose within the jurisdiction of this court, and part cause of action arose outside the jurisdiction. Accordingly, the plaintiff prays for leave under clause 12 of the latest patent. At the learned counsel for the plaintiff, peruse the matters on this court. Leave under clause 12 of the latest patent, 1865 is granted. Plaintiff is admitted, subject to scrutiny. Yes, admitted.
Lordship.
Yes.
But I understand, my lord, Mr. Vishnu Shah, my lord, has got, my lord, he's on legs, my lord.
Okay.
So, my lord, may I just, my lord, with my lord's please, my lord, can you, my lord, first look at, my lord, the judgments, my lord, which hurriedly I'll just go through the judgments, my lord, which they, my lord, relied upon. My lord, Lord Leela Parulekar, my lord, that's 2005-11 Supreme Court cases, 73. And my lord, I understand, my lord, they relied on paragraph 52.
2005.
2005, 11 Supreme Court cases, my lord, page 73. And this is very important because, my lord, it's...
Yes.
Yes, my lord, kindly look at paragraph 52. The proposition, my lord, is that, my lord, according to them, my lord, time can be refixed.
Yes.
That's, my lord, why they relied on, my lord, paragraph 52. My lord will find, my lord, paragraph at page 97.
Yes.
May I just read, my lord, from paragraph 50? We are of the view that there was also no repudiation of the contract by the appellants as contended by the respondents on account of the appellant's alleged failure to pay the price within time fixed by respondent number 2, 3 and 4 by the notices dated 21/2/1985. Then, my lord, 51 is very important. This is, my lord, under section 11. There's a, my lord, statutory, my lord, provision there. Section 11 of the Sale of Goods Act 1930 expressly says stipulation as to time unless a different intention appears from the terms of the contract. Stipulation as to time of payment are not deemed to be the essence of a contract of sale. Whether any other stipulation as to time is of the essence of the contract or not depends on the terms of the contract. In 52, as there was no time fixed under Article 57A or in the offer letters, question of time being the essence did not arise at all, as was held in such and such Pillai. The stipulation must show that the intention was to make the rights of the parties dependent on the observation of time limits prescribed in fashion, which is unmistakable. If this is, my lord, what they relied on, if there is no stipulation as to time, it is not open to a party to unilaterally stipulate a time and then cancel the contract because of an alleged failure of the other party to act within the time stipulated. Of course, if time is fixed by the contract but is not originally of the essence, a party could, by notice served upon the other, call upon him to complete this transaction within the time fixed and intimate that in default of compliance with the requisition of the contract, the contract will be treated as cancelled. But when no time is fixed for completion, it is not open to either vendor or purchaser to serve notice limiting a time at the expiration of which will be treat the contract as an end in the circumstance of contract. So, in the middle, my lord, what they relied upon. But, my lord, I'm sorry, but they forgot. My lord, I think, my lord, my argument on, my lord, section 59 has not been answered at all. My lord, remember, my lord, section 59, where, my lord, there are several distinct debts. If I write and say that appropriate it against this debt,
Yes.
then, my lord, when appropriated, that debt is, my lord, is goes. And which is here, my lord, the installment of April and, my lord, July.
Correct.
So, my main argument was you having elected. This is a question, my lord, of election. You having elected to appropriate this debt to the outstanding installment. There's no debt which survives. So there's no default, my lord, or debt, my lord, which survives for you to now proceed.
So what would affect if in the contract, okay, it is required, there is no time. What would affect the in violation?
My lord, that's why, my lord, under Sale of Goods Act, you can't do anything. And otherwise, you have to refix time.
Correct. So if they, because in your argument, Mr. Mukherjee has
Yes,
also argued
yes,
with
yes.
regard to once they have given 7 days, then 3 days, and then so there is no specific time has given.
Correct.
So time has to be provided, and specifically stating that if it not paid, then it will be cancelled.
Correct.
Correct. So it will be cancelled. So what would be the effect of the 3 notices
My
given?
lord, no effect. Because, my lord, it's a question of, my lord, whether, my lord, it's a fundamental breach of a contract or not.
Okay.
My lord, when, my lord, time is not of the essence, then, my lord, knows unless it goes to the root of the contract, you can't cancel the contract.
Okay.
Because you are getting delayed interest.
Okay.
You're getting your
Yeah,
installment.
that is the
That's right.
that is the
That's
subject,
right.
that is
Correct.
the argument Mr.
Correct.
Shah made.
Yes.
Once you given the notice of the fixing a time, but you accepted the amount or interest or delayed interest, so it cannot give an effect. That is the one of the arguments.
One of the arguments. And I showed, my lord, a statutory provision. That's why I showed, my lord, section 59.
Okay.
Because if you accept, my lord, it goes away.
Okay.
And you have got, there's no damage you have suffered. My lord, today, you can't, my lord, cancel a contract for the sake of cancelling it. Because your default and the damages has been met with payment of, my lord, the installment and, my lord, interest.
Correct. Yes, next.
Now, my lord, before, my lord, I just show, my lord, the other 2 judgments. One, my lord, very important thing, my lord, will recall, my lord, we had made a case with regard to saying that this is really not a genuine, my lord,
Actual occurrence.
yes, not a genuine reason, my lord, why they're going after me. They're really going after, my lord, the shares, which, my lord, is there, my lord, in that mall. Now, my lord, unfortunately for them, my lord, telltale marks, my lord, always come out. they had handed up a compilation of documents.
Yes.
On the last day.
Yes, sir.
We have taken some of those documents and prepared
Entirety. That
entirety, we have prepared a supplementary affidavit so that it's on record. We have put it on affidavit saying this is the compilation which now kindly look at just a few.
Have you served the
Yes, we have served on them.
the
It's
same
their
document
compilation.
you relied upon?
Yes. Their compilation which we are giving.
Page 7 से
Now
start होता
kindly look at from page 7 is that's their compilation. Kindly look at page 7. This is what they had given.
Of your compilation or
No, of the supplementary affidavit. This only has their compilation.
है. It's the only thing we have annexed.
Page 7, this is their compilation. We have put it on affidavit. Now, we are relying on it to show what they have done. Kindly come to first page 42.
Yes.
As on April 24, 2025, the top finds April 24, 2025.
Correct.
Sabera Agrawal from Piramal.
Yes.
Now, within themselves. Now, kindly see, dear Supriyo, this is reference to the discussion held with Yesh, wherein decided to initiate legal enforcement for all the credit facilities extended to the money group.
Yes.
Please find below the overall status of Piramal credit facilities. Now, this is the first one, is not the second two, one in Piramal Capital Housing Finance. Then, kindly see the last. Primarily, we would like to initiate enforcement against money group only. And at later stage, we can involve Salarpuria group.
Minority stakeholder.
That's the minority stakeholder in the project.
Date is
Yes.
very important. Long
And this is April 24, 2025. Request your views, strategy to take this forward. Telltale malafide because this is not a public institution. Piramal is not a public institution. It's a private financial institution. So the fact that they're siding, and that was recall Mr. Shah had made that submission saying that this is not where the purpose of invocation makes unfortunately the conduct also makes a invocation bad.
Yes.
And will find they have for us very studiously given us a chart which is at page 51. I'm happy they have given us this chart which shows this is nothing to do it's not a fundamental breach at all. Kindly see the number of delays for each.
reasonable time. 54.
And they say reasonable time. This shows they have been accepting with interest.
7 days.
For 87 days also default has happened. So two things are very clear from this. One, time is definitely not the essence of the contract. Secondly, that they have been accepting with interest, which shows this does not go to the root of the matter at all. It's not a fundamental breach which will entitle them to today cancel the contract.
Yes.
Well, only one thing, I'll interrupt Mr. Banerjee.
Sorry,
Well, Your Lordship.
you go, just two more sentences.
No, Mr. Banerjee, just the last item.
Yeah,
The
sorry.
last delay is 61 days only, just that. I
Yes.
don't want to repeat anything.
Well, we'll see, yes, the last number of delays
Of this,
of this, in this is
imputes
which is now challenge is 61 days. Before that, there's an 87, 82, 74,
83
83.
reasonable time.
So, what changed? With great respect, if I ask, put my argument in a question form.
Yeah.
In 5th October 2024, 83 days was not something which was fundamental. But in April 2025, when you say only enforced against Piramal and not against the money group and not against Salarpuria, then everything changes. 61 days you go after us. And then you accept. Then you accept whatever has been tendered. Now, yes. And that, yes, we have shown that. Even in the July payment, has seen, when I closed my arguments, I had shown. July also they have accepted without any demo. Now, my lord, the other two judgments, my lord, and particularly my lord's judgment. Sorry, first, my lord, 1965, 35 company cases 376. My lord, this is, my lord, on the question, my lord, interpretation, my lord, of a contract.
Yes.
Para 10 with I'm not. Huh? Oh, sorry, it's an unnumbered paragraph. No, no, তোমরা যেটা দেখিয়েছো। Lord, kindly see, my lord, the second page. Lord, I'm also, my lord, again, my lord, I think, my lord, this is something, my lord, which should go against them, because it says main question, my lord, at the bottom of the page, my lord, that second paragraph, the main question.
Last seventh line, yes.
Yes. Question in this appeal is whether the policy had been terminated. Respondent contends that power under clause 10 of the policy to terminate the contract at will, and it had duly exercised the power by the letter of August 7. Appellant denies both this content, states that term must be implied in clause 10, that termination could only for reasonable cause. Termination in the present case was not. It then said that if rules of interpretation do not permit the term suggesting implied, clause 10 must be treated as void and ignored. Content is based on the interpretation of clause 10. Now it is commonplace court's duty to give effect to the bargain of the parties according to their intention. And when the bargain is in writing, the intention is looked for in the words used, unless they're such that one may suspect that do not convey the intention correctly. Those words are clear. There is very little that the court had to do. Court must give effect to the plain meaning of the words. However, it may dislike the result. We have earlier set out clause 10. We find no difficulty doubt as the meaning of the language used. This clause says the insurance may be terminated any time at the request. Well, Lord, unfortunately, my lord, we are not now concerned, my lord, with the question of interpretation of the contract. We are concerned with section 55 and section 59 of the Contract Act.
No, that's why, Mr. Thakkar, because the second paragraph of the page 3.
Yes, my lord.
Indeed, the language of the
The language is the plainest.
The
Clause says this insurance may be terminated any time at the request of the insured, and the insured, and the insurance may also at the time be terminated at the instance of the company. These are all the words of the clause that matters for the present purpose. Words at any time can only mean at any time the party concerned likes. Shortly put, clause 10 says either party may at will terminate the policy. No other meaning of the words used is conceivable. With great respect, Lord, I don't know how, my lord, this principle fits into, my lord, our fact situation, where, my lord, there's a question of, my lord, delay of 87 days, 61 days, 73 days, all, my lord, being, my lord, accepted with, my lord, interest.
Yes.
And interest, my lord, in that sense, my lord, covers, my lord, any damages, my lord, which they suffered. Well, I said that.
Yes.
My lord, I'm glad, my lord, whatever I'm submitting, Mr. Mukherjee has now come and endorsed. So, my lord.
Yes, next.
My lord, just, my lord, my lord's judgment. My lord, this is, my lord, the unreported judgment. My lord, CS.
Fox and Wonder.
Yes, my lord, Fox and Wonder. Now, my lord, I again, my lord, kindly look at, my lord, paragraph 1.
This is a perpetual injunction.
Paragraph 1, my lord, has set out, my lord, the reliefs, my lord, which have been asked for. We have not asked for any such relief. Kindly look at, my lord, paragraph 1. And quite naturally, my lord, relied on, my lord, Cotton Corporation to say, sorry, I can't give you this relief because this is directly in the face of injuncting any kind of recovery proceeding. My lord, paragraph 1.
Yes, sir.
My lord has seen that. My lord, declaration entitled to, then B is declaration only entitled, and C is declaration restraining the defendant one from claiming any amount of money against the share of late Dinabandhu Mondal other than rupees 1 crore, plead in paragraph 22.
C, D, and E.
Yes. No, my lord, one question with great respect, my lord, has also not been answered, my lord, to say how the reliefs which we asked for are, my lord, at present within the jurisdiction of the NCLT. They are, my lord, independent, which, my lord, their very code says they are independent to determine and assess where there is a debt and default.
Within the meaning of that act.
Within meaning of, my lord, IBC itself.
Okay.
Not, my lord, when I've come here. And, my lord, they say, my lord, we are not enforcing mortgage. My lord, all that, my lord, should be, my lord, recorded.
The undertaking.
My lord, they say we have not invoked pledge, we are not, my lord. That should be put on record, saying we are not doing it.
Did they undertake?
My lord, those are, my lord, my submissions. My lord, I'm sorry, Mr. Shah.
No, my lord, I have nothing more to add. I have nothing more to add, my lord. There's no point in repeating that stuff.
Okay.
My lord, wait.
My lord,
We have not cited any cases.
One clarification.
What?
This can't go on then again.
no, only
Lord, insofar as the security agreement is concerned, my lord, lordship will recall, we had, my lord, shown you the power of the security trustee, my lord, to effect the recall.
That Mr.
No,
Thakkar.
I want to show you
That
that
Mr.
they are
Thakkar
also parties to the security trustee agreement. They've signed it.
correct. That Mr. Thakkar has already shown that. Yes, Mr.
And that was not made part of this enclosure.
Yes, Mr. Thakkar, anything
Annexed to the plain.
that is already Mr.
My
Thakkar.
lord, only one submission apropos the affidavit which they filed, my lord, day before yesterday, annexing our documents, the documents which we had handed over to your lordship, my lord, the compilation. Only two submissions have been made on that, my lord. One, they've stated that the document itself, I am not proceeding against Salarpuria, but against the money.
Yes.
My lord, your lordship knows very well, my lord, it is the absolute right of the creditor to proceed against the principal debtor or the guarantor, whomever he wants to in whichever sequence. So to attribute malafide to that, my lord, is a figment of imagination. It's not a
Okay. I will
neither here nor there. And your lordship will also one thing, your lordship will also kindly make a note of this, my lord. Prior to the filing of the suit, there is no allegation made by the plaintiff that I have a vindictive attitude towards the money group or that I'm siding with the Salarpuria. This is coming for the first time in this plaint. Prior to this, there is no correspondence. He has never said that you're siding with the Salarpuria group or you have nefarious intentions.
Yes.
Kindly make a note of this, Mala. This is a story which has now been cooked up to kind of create a prejudice and a stigma against a lending institution from whom they've borrowed huge amounts of money. Second, my lord, I'm sorry, my lord. Second, my lord, the chart shows the delayed payments, and why we brought this to your notice is to show, my lord, that this is a habitual defaulter. Every time he defaults, he pays interest, but that is not the intention of the loan. The loan requires prompt payment. The payment of interest is a recovery of damages, but that does not mean that he continues committing breach and I continue condoning the breach. There is no answer that it is not in breach. He is in breach. The loan agreement gives me an absolute right to recall, which I have exercised. So he keeps on committing breach, and I condoning him in the past does not give him an absolute unfettered right to keep on committing the breach as long and pay as and when he wants. Then we might as well throw the agreement into the waste bin, my lord.
Okay.
That is his submission.
Okay.
Grateful, my lord. Deeply obliged.
Grateful. One line, my lord, the appropriation is towards the entire recall, not towards any one particular installment.
That is there in the last notice.
That's the section 59 answer.
Yes.
Hearing
Grateful, my lord.
for orders.
But the supplementary
affidavit filed by
the compilation,
supplementary affidavit filed by the plaintiff number 1.
plaintiffs, my lord,
Plaintiffs.
disclosing, my lord, the compilation, my lord.
Pick up with the record. Hearing concluded. Pick for orders.
I'm so grateful.
Number 8.
Great.
It's an application, which was taken out, previously, under Order 38, Rule 5 and 6. Your Lordship had passed an order, receiver, special officer was appointed, attachment order was passed. Thereafter, the receiver had taken possession of and has attached 4 properties, of the debtor. Now, out of the 4 properties, one of the property is the one where the directors are residing. And all the properties, the 3 properties were purchased in the name of the personal name of the directors. But one of the property, there was the special officer could not find out that who has put the padlock on it. Thereafter, your lordship gave us liberty, to file a supplementary affidavit by which, to disclose, to whether the property, that is the 4th property, whether it belong to the defendant or whether it's again in the name of the personal director. We have filed the supplementary affidavit, we have come to know, we have been able to get the certified copy of the deed. It's in the name of the defendant.
Defendant company.
And it was purchased in the name of the defendant. Your lordship kindly takes up the supplementary affidavit. I have already, annexed a copy of the final report of the receiver. Your lordship comes to page 13, which is the report of 9th of June 2025. Page 13, of my supplementary affidavit. that it only concerns now, my lord, unit F and G. Now your lordship comes to paragraph 11. It was only through the invention and assistance of the police officers I was able to enter. Firstly, I went to Merlin Warden Lakeview, such and such, unit F and G, Kolkata 767. I found that the notice of intimation of symbolic possession had been removed, which I had pasted on my earlier visit. It was very shocking and surprising that I had received. Then, my lord, last line, the property was still under padlock by somebody else. In addition to that, I had put a padlock in the property. So this is the only property now in concern. Now your lordship, my lord, turns straightway.
No, it was shocking or surprising. I had received no such intimation, removal of the notice from anyone before it was removed.
Yes.
Then I pasted a fresh notice on the
Yes,
visible
that he has
place of
done.
property. Yes.
Now your lordship, my lord, kindly comes to one of the photographs which has been annexed by the special officer. Just that it's not necessary, but I want to show it at page 25. Now it's very clear. My lord, your lordship sees the new, my lord, my lord, he has put the notice of intimation on the left hand side.
Yes.
And on the right hand side, your lordship sees the name of the defendant is there, signet. It is their office. Now it is very clear. Now your lordship, my lord, comes straightway to the order which has been passed by your lordship on, my lord, of at page 79 and comes to page 80. Page 80, paragraph 5. Order of 16th of April 2025.
Yes.
Considering the above, the special officer is directed to attach the properties of the defendants, that is flat number such and such, and Merlin Warden Lakeview, Bidhannagar Road, first floor, block 1, unit FNG, Kolkata. But this is the one which I am. Plaintiff, after notice to the defendant, the special officer went and whatever was done, my lord, was done. Thereafter, my lord, your lordship, my lord, gave me liberty to file a supplementary affidavit to bring on record the deed so that I can claim that they belong to the defendant. That is at page 30, the order of your lordship of 10 June 2025.
Page
30, my lord, 30.
Yes.
Paragraph 5, counsel for plaintiff prays for time to file supplementary affidavit. Let the supplementary affidavit be filed. Now your lordship straightway comes to the certified copy of the deed, my lord, which is at page, my lord, at page 86. The deed of conveyance, my lord.
Yes.
Your lordship sees, my lord, Merlin TF Lakeview, deed of that's the vendor. Then your lordship, my lord, kindly turns over to page 88.
Signet.
Yes, Signet Media Services Private Limited, a company such and such is the purchaser.
And Terra. There are
And
two
Terra
purchases.
is the confirming part. Must be the landlord or something like that. Now, my lord, your lordship, my lord, comes to the consideration amount, which is at page, my lord, 99. Now, my lord, only one paragraph, my lord, page 90 prior to that. Last paragraph, my lord. Now this indenture witnesses
Yes.
that in pursuance to the aforesaid agreement and in consideration for the sum of 1,28,60,000 paid by the purchaser to the vendor. So that clearly shows, my lord, that the money was taken out of the accounts of the company of the defendant and was purchased. And this kindly comes to page 99. Receive the aforementioned sum of 1,28,60 as full consideration from the purchase. So now, my lord, nothing remains, my lord. It is straightway, my lord, that the money was taken out of the money coffers of the defendant and was used, my lord, to purchase this property. My lord, that also, my lord, your lordship would see the date. That is on 26th of December 2013. That was way after, my lord, the confirmation was given, and also, my lord, the demand notices and everything was sent.
Yes.
So I was praying, my lord, now for an order of attachment of this property, my lord, by the special officer and a padlock we put on it.
Attachment is already there.
Attachment is already there, my lord, to take it in his possession, physical possession. That he could not do because, and your lordship was also of the query, my lord, whether it belonged to the defendant.
Correct.
Now it is, my lord, it does belong to the defendant. So the special officer can go and take physical possession of the property. But I'll have to wait, my lord, for the sale, my lord, until the decree is passed.
So, what is the condition? Who is, it is under padlock, na?
Yes.
It is under padlock.
Yes. He has put a padlock.
Yes.
And also, my lord, the defendant has failed to put in the security which your lordship had directed.
Why? Which order dated?
My lord, your lordship, my lord, kindly comes to, my lord, the attachment order which I had placed.
Furnish the security. That is first security. The
Just one second.
interim order was passed.
Yes, my lord.
20th September 20.
Each down table.
Page 62.
52.
62.
52, my lord.
52.
Of 20th of September 2024.
That's why the operative portion 62.
Yes, 62.
62. Then thereafter, what has happened?
So thereafter, my lord, they never appeared. They did not put in the security. They said that they are insolvent, but however, why they are insolvent, why the money was siphoned away, why the money, no explanation was given thereafter. They did not appear
Restraint for
thereafter.
depositing, alienating, or creating any third party interest of the flat number so and so and so. That is the flat. No. This flat number 5.
My lord, these were the Hemanto Mukherjee ones.
No, this
Thereafter,
flat.
yes.
The page 62, in the middle, the defendant is restrained from disposing, alienating, creating any third
But
party.
that is also there, my lord.
That what about this
Page 62, my lord, FNG. Your lordship sees, my lord, the defendant is restrained from disposing, alienating, creating third party such and such. Then, my lord, your lordship says the second being Merlin Warden Lakeview 104 Bidhan Nagar, first floor, unit FNG Kolkata, and 2 other similar assets, which is Hemanto Mukherjee. So this was also, they were restrained.
Then the special officer attached the flat.
Yes.
V1, first floor, Merlin Warden, West Bengal, and the 104 Bidhan Nagar.
Yes.
These are the 2 he has attached.
Yes.
And
My lord, he has attached, my lord, if your lordship, my lord, comes to the special officer's report.
No, page 80, I come to paragraph 5. Considering the above, the special officer is directed to attach the property.
Lordship comes to page 15. That is the last report which regard to FNG. The Merlin Warden FNG.
50.
15, my lord. My lord, Merlin Warden such and such. Block FNG to attach the property, photos taken, property put under padlock of the special officer.
This is second one. The first was also attached.
Yes, yes. All of them attached.
He has attached 2 property, no?
He has attached, my lord.
He has attached how many property?
No, he has attached, my lord, 2 properties, 3 properties.
That's
My lord, 2 properties.
2 property.
2 properties.
That is the Merlin Lakeview 104.
Yes.
Correct.
That is FNG.
FNG.
And the other is, my lord, one is at Hemanto Mukherjee.
Where is that?
One second. My lord, if your lordship, my lord, comes to my lord, the special officer's report, my lord, which is of The report of 6th of April 2025.
No, that page number, kindly count page 15.
Lordship,
Page 15. These are the two properties.
these are the two properties
Attached.
at Merlin.
This is attached.
Yes. My lord, this one, item number 2 could not be attached because the directors are living there.
Correct.
And it was in the name of the personal name of the directors.
Correct.
So this could not be attached.
Correct.
Now, notice has been put. One is in the name of the defendant, which was under padlock. The special officer has put padlock on it, but he did not, notice of attachment has been pasted, but he did not take symbolic possession because there was no surety as to whether the flat belonged to the defendant or not. There were other two properties, my lord, at Hemanto Mukherjee, which your lordship has attached. My lord, by the order, your lordship kindly comes to the order which I was referring to at page, my lord, 62. Kindly comes to page 62. Two other immovable assets, P499 Hemanto Mukherjee, and the other one, and also two other immovable assets situated. Here, my lord, what happened? One of the assets, SBI had taken over and had sold it to someone else. So that goes out. And the other, my lord, is a peculiar situation that property is not in existence, though a deed of conveyance is there.
Correct. That's what I'm telling. Now, as on date, only one property was attached.
Yes.
He has put the
One.
padlock. That is
One.
the signet. That is the office.
Yes.
And one is already there and residing in the
Yes.
premises. So that cannot be attached. Only the notice
Yes.
was pasted.
Yes.
Correct.
Yes.
So now it has only one property has to be the
Physical possession has to
symbolic
be
possession
taken.
is to be taken by
Yes.
the, that is with
Yes.
regard to the
FNG.
FNG.
Yes.
FNG.
Yes.
First floor, block number Merlin Lake Road, 104 Bidhan Nagar, first floor, block number 1, FNG.
That's
This is one.
That's
The plaintiff has filed supplementary affidavit disclosing several orders passed by this court, comma, the report submitted by the special officer and the deed of conveyance dated 26th September. What is the date? 26th December?
26th December, man.
26th December 2013. 2013 entered between Merlin TF Marlin Merlin TF Lakeview, page 86, and Signet Media Service Private Limited. Full. By an order dated, where is the first order? By an order dated
Well, 9th
20th
of September 2024.
20 September 2024.
I'm sorry. 20th of September.
Yes, 20 September 2024. This court passed an interim order restraining the defendant from disposing / alienating / creating any third party interest with respect of flat number V-Roman 1, comma first floor, Merlin Warden Lake View, comma 104, Bidhan Nagar Road, Kolkata 700067, registered in the name of the defendant, and the Merlin Warden Lake View, comma 104, comma Bidhan Nagar Road, comma first floor, comma block 1, unit F and G, Kolkata 700067, and also other immovable assets situated at P-499 Hemanto Mukherjee Sarani, comma Kolkata 29. And this court further directed the defendant to furnish security to the extent of rupees 3, 37, 42, 633.27. Even after the order of injunction, the defendant has not complied with the order dated 20th September 2024. Accordingly, this court has appointed an special officer, and the special officer has submitted the report wherein it is mentioned that the special officer went to Merlin Warden Lake View 104, Bidhan Nagar Road, first floor, block 1, unit F and G, Kolkata 700067, and has pasted the notice by taking symbolic possession of the property in flat in question. Full stop. Now the plaintiff has disclosed the conveyance deed dated 26th of December 2013, wherein it is crystal clear that the defendant has purchased the above mentioned property, that is block 1, unit FNG, Kolkata 700067, West Bengal. Full stop. Counsel for the plaintiff submitted, as it is clear from the conveyance deed that the defendant has purchased the above flat, and as such, the special officer is the special officer may be directed to take possession of the property till the possession of the property, that is Merlin Warden Lake View, 104, Bidhan Nagar Road, first floor, block 1, unit F and G, Kolkata 700067. Full stop. Learned counsel for the plaintiff further brought to the notice of this court that as per this conveyance deed, the defendant has purchased the said property for a total sum of rupees 1, 28, 60, 000, and the defendant has paid the said amount to the seller. Full stop. Considering the above, this court find that in spite of the specific direction passed by this court, the defendant failed to secure the amount in terms of the order dated 20th September 2024, and as such, this court find 2024. This court also find that the special officer has already taken the symbolic possession of the said property and has put the lock in the said property. Now the special officer is directed to take the physical possession of the above mentioned flat, that is address likha hai na, that is Merlin Warden Lake View 104, Bidhan Nagar Road, first floor, block 1, unit F and G, Kolkata 700067, West Bengal, within a period of 2 weeks from date, and to file the report before this court on 28th of August 2025. Let the matter appear on 28th for filing report by the special office. Yes.
Well, the affidavit of service may be
Affidavit of service filed by the plaintiff be kept with the record.
Before your lordship takes up the 11:30 fixed matter,
Yes.
OCD 9, your lordship, is my application. I was in some difficulty. I was requesting if it could be adjourned to any other date, your lordship.
Item number 9. As per the prayer made by the counsel for the plaintiff, the case is adjourned. Let the matter appear on 20th August.
Very well, your lordship. 20th August.
Deeply obliged.
All the
Deeply obliged.
Well, the lordship is kept it on the
28.
Item number 4.
20 August. This 20.
Item number 4, Your Lordship, I am for the plaintiff. Mr. Dasgupta is doing, Your Lordship. Your Lordship kindly allows him.
No problem. All are competent.
But on the documents where we were stuck yesterday, the emails, but may I ask a few questions? We'll not adduce the third email.
What was the last question? Give that. Yesterday question. Who delivered the printout of this mail to the defendant? Our office boy.
Yes. But in this document, if your lordship takes the fifth volume of the judge's brief, page 711.
Yes.
But page 711 and 712, they are the correct emails. And 713, the email, as your lordship pointed out yesterday, that it's not the complete email. Well, we'll ignore 713. We can't adduce that.
Now that is one aspect, and another aspect is this a trail mail.
Yes.
Trail mail,
Trail
but
mail.
the first page of the 711
Yes.
having the seal and signature.
Yes. Well, that I'll ask questions on.
That no, that's why he has raised the objection,
Yes,
because
yes.
they are trail mail and is a mail. So how it is and you have not made any averment in the plaint that this has been printed out and handed over to the defendant by hand.
But this was by hand, and this email also says, because I'll tell my lord why, but it is better when the witness says that. But I'll not ask.
Yesterday also, my lord clarified this, and also the witness has given evidence to that effect also. My lord, as your lordship pleases.
Shown
You'll get the chance.
On this document, on the same document.
Yes.
Shown documents, copies whereof appear at pages 711 and 712 of the judge's brief of document. Why did you deliver the document to the defendant by hand?
This document was first sent by email, and every time we got the complaint that they are not receiving our.
So
yes, slow,
every
slow.
time.
First we have sent this document by
email, and when we received the complaint that they are not receiving our emails, so I prepared one printout of the email and hand delivered to the office of the defendant.
My lord, one thing, if your lordship kindly allows, that let it go, my lord, but with objection as leading.
Okay, okay.
Leading, but he has already said it's by hand.
Within bracket, objected by the plaintiff as the same is not raised, the same plea is not raised in the plaint.
My lordship was exhibited when I marked the document. Very good. 711 and 712.
Triple G.
Triple
G.
With objection, huh?
Shown a document, a copy whereof appears at page 714 of the judge's brief of document. What is this document?
This is a suspension letter issued by DGFT suspending importer-exporter code number of Austin Private Limited.
How have you obtained this document?
This has been given by the Austin Private Limited to us.
Where is the original document?
This is all downloaded from the sites. They are not nowadays, they don't issue physical copies.
Which website are you talking about?
Which
website?
This is a DGFT website. DGFT website.
DGFT
website.
Are all the inscriptions made on this document? Now, were all the inscriptions made on this document available when you received this document?
Yes.
What do you have to say about the contents of this document?
They are true and correct.
Is this the photocopy of the original document?
This is a downloaded copy.
Have you furnished any affidavit in
Yes.
support of this document?
Yes.
But may this document be tendered.
Exhibit triple H. H.
Malad, this is a notification. The contents is true and correct of a different authority.
Not required.
If it goes, let me say, if it is not required, let the court decides. I would make an objection to this, Your Lordship, whatever.
HHH within bracket objected to on the ground that he is not the author of the document.
Shown documents, copies whereof appear at pages 715 and 716 of the judge's brief of document. What are these documents?
This is an email dated 8 November 2021, written by Mr. Amit Prasad of defendant to me, sent by WhatsApp to me.
Sent by WhatsApp. From whose WhatsApp number was this document received?
This is from Mr. Amit Prasad's WhatsApp number.
Amit Prasad's WhatsApp.
To whose WhatsApp number was this document sent?
To my WhatsApp number.
Is this the original document?
Malad, everything can be taken in a classical way. I have got nothing to say. But so far, Order 8, there is an embargo in the Commercial Courts Act. Whatever written in the evidence, anything goes beyond, there is a bar. So he can goes in a classical way. I do not have objection.
That you can argue.
No, I am not raising that point here right
Okay,
now.
that's what I'm telling. You can argue that.
Yes.
You can argue that.
Yes, this is the original printout.
Who has taken the printout?
I have taken the printout.
Did you compare the printed document with the original document?
Yes.
Did you find the contents to be Did you find the contents to be identical?
Yes.
May this document be tendered. Have you I'm sorry, one more question. Have you furnished any affidavit in support of these documents?
Yes.
You have affidavit though? 65 all affidavit though? This will not go.
But this is
WhatsApp
file. Yes, mobile.
But with regard to the WhatsApp email, WhatsApp communications, and the print has to be Navjot Siddiq case guidelines has been given. And subsequently, again, the Supreme Court has affirmed another judgment. I could not remember that.
I'll find out. 65. We'll have to consider.
You have to preserve.
In my mobile.
You have to preserve, and this you are telling that you give. I don't know what will be final, but this is not. If you are giving the affidavit with regard to the 65B, what are the document? Each document you have to specify.
That's not there.
65B is the admissibility of the electronic record.
That's why.
That is hit by this. 65B subsection 4.
Subsection 4.
But these are
he's evidencing.
But these are he's saying that through WhatsApp and PDF of the email. Yes. Yes.
Where is the affidavit? Received. I kept it
I've
as
stored
it
it in my.
Where is the affidavit?
That's why I was
wondering if I could ask those questions.
You
Whose
can't
email?
unless there is an affidavit.
Yes, that's
And the affidavit you're taking this all the affidavits, but none of the document is mentioned.
Documents
in the
are not
affidavit.
specified.
Then how it
It's
is
a general. It's a general affidavit.
Amendment of the Commercial Act that bursts it.
It's a general affidavit where he has said electronic records,
Will
all
not
electronic
do,
records.
Will not do. Yes. This will not do it. This will not do.
The WhatsApp communication.
Even the other documents will also, what you're putting the question to the witness, that will not, I thought it was there, but now I.
No, it's a general affidavit.
There.
It's a general affidavit. But then, in that case, we have to file an affidavit under 65B.
Correct.
That is although that affidavit is there, but it is not in proper form.
Correct.
But maybe file the affidavit. Maybe file the correct affidavit, and it is only a procedural issue. But although it is with regard to admissibility of documents, but it is then again it's a procedural issue. But maybe file the affidavit under the proper affidavit under 65B. And
So
if you're
now
not,
how those documents which are already gone in evidence, you cannot now.
But it is
Because
only,
the witness has stated that he has given an affidavit.
Yes.
Subsequently to evidence, he cannot file a separate affidavit.
no, whatever the witness has said, that will remain because he has referred to this affidavit. This affidavit is a general affidavit saying whatever electronic records are there, he is certifying. But since it is a requirement under law to specify the documents, we pray for liberty to file that affidavit only to explain the affidavit which is already there. It is only for explanation of the 65B certificate or the affidavit which is already there.
Of which document?
Of whatever documents have been disclosed.
This court will not allow what the documents you already exhibited, and the witness stated that he has filed the affidavit under section 65B. That this court will not allow to cure that defects. Further, you want that the court can give that because evidence has not been done. But what the document you already exhibited, on the basis of this document, this court will not allow you further.
On the basis of the existing 65B.
You could have been cautioned prior to the leading
But,
evidence.
it was seen later on that the documents are not specified.
Then how the other document can be though exhibited, but it cannot be taken into consideration unless it is in terms of the law.
But we'll try to find out cases if that is. We'll try to find out cases. We'll try to.
I don't think the last case. I think 2019 after the Nojo Sidhu case.
I think there is
Justice-
one.
Justice
I will
Chandrachud's judgment
explore
was
one that
explained.
also told in the same line as my lord is
Correct.
direct.
So, but
And with regard to the WhatsApp messages and WhatsApp photo and Facebook, there is a separate first. First, you have to give yes, it has been kept as it is.
Yes,
and
it has
not
been stored.
tampered.
Yes, absolutely. That is those averments insofar as other electronic records are there. Those averments are there in the affidavit.
Okay, whatever.
But
it may be.
WhatsApp, we'll
What
try
you
to
want?
find. May I proceed with the examination, or if your lordship could grant us liberty to file an affidavit, and we'll try and persuade your lordship whether that is permissible, and whether I can cure the defect which is already crept in the other exhibits, which have already been the documents which have been.
It's already done then.
We'll try to persuade the lordship
That
whether
is
it
a
is
matter
permissible.
of arguments because I will have
Yes,
the
yes,
right
that is
to
a matter.
cross-examine.
Absolutely, man, absolutely. But I'm only praying for a liberty so that we can file the 65B certificate in the form of affidavit, explaining all the documents, and then lordship will decide whether that affidavit could be taken as an affidavit in support of
No,
other
how the
documents.
court can allow you to file for, affidavit after adducing the evidence? Till date, whatever the exhibit GG, till the GG, you will not be allowed to file a separate affidavit on that because your witness has stated on oath.
Yes.
He filed an affidavit.
Yes, yes.
So after that, court cannot say yes, you file further affidavit.
It's only to explain the
You
affidavit is
explain
already
with
there.
regard to the further.
But may we proceed for the time being? May we proceed with further documents? And then we'll try to
my lord, again with the same defect, my lord.
Continue.
If it goes, that cannot be curative situation, my lord,
Taking the
thereafter.
risk.
Yes,
Yes, continue.
whatever, your lordship.
May I do this? May I do this? But maybe bring the affidavit. Well, if your lordship, I know it's a fixed matter, but still this week did not foresee. If it could be adjourned for the day, maybe bring the affidavit under 65B with all the particulars. And if your lordship permits that, on the next day, subject to arguments by both by us and my senior friend.
How many documents you are having for though?
10 for now.
That's why I have kept this in the code, because every time this the commissioner is not able to adjudicate. Every time it is coming before this court. That's why I kept this matter before this court. I know it will happen.
No, it had to be. We have not many, 20 more documents.
Further 20.
Further 20. But some of them are repetitions of documents which have already been exhibited.
Yes.
Maybe do this. Maybe come back on a later day. The lordship doesn't have time. That is.
Plaintiff witness is present. The plaintiff has produced one document appearing at page 711. Not 711, 713, 715 and 716 of the judge's brief document. Counsel for the witness said that this document is the WhatsApp message. But this court find that the affidavit, the certificate, the affidavit filed by the plaintiff under section 65B of the Indian Evidence Act 1872 does not disclose the said document which the plaintiff intend to bring on record before this court. The counsel for the plaintiff prays for adjournment for taking appropriate steps. Accordingly, case is adjourned. Let the matter appear. Yes, give the date. Witness action.
Witness action.
Let the matter appear on. Give 2 dates. 22nd and 23rd September at 12. 12 में मत रखो ना, 12 hearing back.
22nd I am not available. We have AGM of
At
the
12:30
company.
At 12:30 p.m.
At 22nd September, the witness has some difficulty.
Then November.
But lordship will keep it in November.
Matter appear on 3rd and 4th November at 2 p.m.
But apart from these dates for witness action, will your lordship also keep the matter next week or next to next week, any day, so only for the purpose of acceptance of 65B, the additional?
That day.
But very well, come on that. Grateful.
But later copy, advance copy.
Yes, whatever they will give serve to you.
Yes.
Without serving, how it can.
Yes. Great.
The IPF for the plaintiff in this matter, Milord? The GA2, Milord, is the
Milord, I appear
defendant's
for the
application.
defendant. GA2 is my application, Milord, for extension of time to file the
His
written
lordship
statement.
had
Milord.
directed for a report from the department.
Milord, I have some clarity now. Milord.
As regards whether the written statement was actually filed within this 120 days.
Yes, it was filed, Milord, before 120 days, Milord, on 18 June.
अरे डिपार्टमेंट से मंगाओ बोला था ना रिटर्न स्टेटमेंट. J2 is
for extension of time to file written statement, my lord. After 90 days, but before 120 days, when it was
when
filed.
you received writ of summons.
My lord.
Summons together a copy of 19th
of
March.
June, it has been filed, my lord.
19th
of
March
March.
you received.
Yes.
19th.
The summons required to defend entered appearance. Writ of summons together with the copy of served upon the defendant number 1. How many defendants are there?
3.
So you are appearing for one only.
There are 2 defendants, my lord.
2 defendants, sorry.
You are appearing for?
This written statement is for defendant number 1.
1. So 19 March. So 19 March or the 18th April was the 30th day.
Yes.
So May, June, July, and you filed on
Somewhere
18
around
June.
July.
Huh? So he has filed on 18 June.
I filed on 18 June.
18 June.
And if he has 5 minutes, that is okay. Right, the leave was granted
Yes,
on
leave.
18 June.
18 June leave was granted. It's submitted in the department.
And I was only making a formal prayer for costs.
Okay.
Costs.
Defendant number 1 has filed the present application being GA 2 of 20, GA Com 2 of 2025.
ফাইল করেছে কোথায়?
Praying for
কোথায় রিপোর্টটা কোথায়? ও ফেলে দিয়েছে ভিতর থেকে। আমি বলেছিলাম এটা।
extension of time to file return statement.
আমি বলেছিলাম কৃষ্ণা is the sole responsible.
Writ of summons was served upon the defendant number 1 on 19th of March 2025.
ফাইল কবে হবে লেখা নেই ওটা।
Counsel for the defendant number 1 submit that after receipt of the writ of summons, the defendant number 1 has contacted the advocate on record of the defendant one, and accordingly the learned advocate on record had instructed for bringing the necessary documents to prepare written statement. The authorized officer of the defendant number 1 company provided the documents along with the instruction, but in the meantime the 30 days period was over. But after receipt of the documents and the instruction, the advocates have prepared the written statement
18 June
and was affirmed
18 June.
on
16 June.
on 16th of June 2025.
এটাই তো খেলা।
That is after the period of 30 days, but within the outer period of 120th days. Counsel for the plaintiff submitted on the same day, that is on 16th defendant.
আমি এখানে বুঝতে পারছি না ভাই।
On the same day, on 16th of June 2025, the defendant number 1 has taken leave from this court to file the written statement in the department, subject to acceptance of the same by this court. Accordingly, the same was filed in the department, submitted in the department on 18th June 2025.
My lord, may I only say one thing, my lord? My lord, 18 June, my lord has given the leave. When the application thereafter, my lord, when the application was filed, the application made no whisper relating to the filing of the written statement in the department. Application states otherwise, my lord. And my lord, the second thing, my lord, when we had pointed out on that day, if we can have the facility of the virtual mode, and Mr. Singh has categorically said on behalf of the defendant that my lord, the written statement is with them.
No, I did not say. I said I'm not sure. I'm not aware. I had said I'm not
It has
aware.
not been filed.
I was appearing
It's with
virtually.
him.
I was appearing virtually.
That's why my lord wanted the report to be given, my lord.
Okay. I will take care of your service.
Because
Just to clarify.
and that's why my lord cut off the entire order recorded on that day. I'm only on that.
I was
After
appearing
we are
virtually, my lord.
We are all running after the truth.
My advocate on record was not with me. I said I am not aware whether this has been filed or not. I did not say it was.
Otherwise, the application must have stated.
Acceptance.
The master ledger
Then at counsel for the defendant, plaintiff has raised objection and submits that. Though the plaintiff and though the defendant number 1 has submitted the written statement with the leave of this court in the department on 18th of June 2025, but no averment has been made in the present application whether the defendant number 1 has filed the written statement in the department on 18th of June 2025 with the leave of this court. The counsel for the plaintiff further submit that no.
May I reply to this, my lord? This was affirmed on 16th of June. How could I have made this submission, my lord, in the pleading, my lord?
No.
Kindly allow my advocate on record to take the inspection of the master ledger. Everything will come out.
Defendant number
16 জুনে affirm হয়েছে,
why the
18 জুনে
defendant
leave
number
পেয়েছি।
1 has not filed the written statement within the period of
না দেখে বলছো।
আমি দেখেই বলছি।
for rejection of the
আমি other day on the তোর virtual submission টা দেখে
but the learned counsel for the respective parties. This court find that the writ of summons was served upon the defendant number 1 on 19th of March 2025. Admittedly, the plaintiff, when the defendant number 1 has not filed the written statement within a period of 30 days, that is on or before 18th of April 2025. It is the specific case made out by the defendant number 1 that after receipt of the writ of summons, the defendant number 1 has contacted the learned advocate, and the learned advocate has instructed for the documents and the instructions so that the written statement can be prepared. When the defendant number 1 has produced all the documents and instruction and given the instruction, by that time the 130 days was over, and due to which the written statement could not be filed. But it is found that the written statement is filed within the outer period of 120 days, and with the leave of this court, the defendant has submitted the written statement on 18th of June 2025 with the department. The question raised by the plaintiff that the defendant number 1 has taken the leave on 18th of June 2025 for filing a written statement in the department, but has not stated about the said averment in the application. But this court find that the written statement as well as the present application being GA Com 2 of 2025 was affirmed on the same day, that
on 16th of June, 2 days before.
On 16th of June 2025. And नहीं, क्या बोला?
Leave was
The written statement was affirmed on 18th of June 2025 and taken leave from this court on 18 June 2025. 18 June to file in the department. But the application being GA Com 2 of 2020 was affirmed and filed in the department, affirmed on 16th of June 2025. Full stop. Taking into consideration, this court find that it is not possible for the defendant number 1 to disclose the statement with regard to the leave taken by the defendant number 1 to file the written statement in the department on 16 June 2025, as the defendant has already affirmed the affidavit of this application on 16th of June 2025. As regard the cause shown by the defendant, this court has already held that sufficient cause has been shown why the defendant number 1 has not filed the written statement within a period of 30 days. But this court satisfied that the defendant has filed the written statement within the outer period of 120 days. Considering the above, this court find that one opportunity should be given to the defendant number 1 to file the written statement subject to payment of cost of rupees 2,000 in the High Court Legal Service Authority within a week from date.
But only one thing, my lord, but kindly allow us the liberty to have the inspection of the master ledger, my lord, to my advocate on record.
Or?
But actually to ascertain the date when it was filed, my lord, because it
My
was a
court
category-
officer signature is there. What you want to see? That's why I know this will happen. That's why I intimated the whole members of the bar who is practicing in this court. If you are not filed within 30 days, you want to file outer period of 120 days, please take the leave. Otherwise, the department is in also dilemma. What they have to do. And by that time you file an application, 120 days is also over, then it is very difficult to this court also, to the defendant also to bring the written statement. That's why one third way this court has found that
the thing that on that day, my lord, the written statement was before your lordship, my lord, and
no, this court, because when I give the leave, my court officer, unless until this has not been recorded, the master office will not accept this. GS within a week, GA consensus is disposed of. The plaintiff is the defendant number 1 is directed to serve the copy of the written statement to the plaintiff by in course of the day. By tomorrow.
By tomorrow.
Let the matter appear on 19th of August 2020.
Very well. I'm deeply obliged.
There's no counterclaim, no?
There's no counterclaim.
Item number 11.
I appear for the plaintiff.
Yes.
This has been adjourned on several occasions on behalf of the defendant.
Yes.
The defendant has taken out an application for acceptance of the written statement Beyond the 120th day, their only case is written statement was affirmed, never filed. My lord had called for a report of the register, never filed before my lord. Affirmed within 120 on the 120th day. My lord, they've sought time on several occasions. I believe my learned friend is seeking time today as well. My only prayer, my lord, if my lord will allow me 2 minutes, I'll just indicate the dates and end my submissions on this application at least.
Yes, madam. Where is your senior? Every day this is not coming here. Either you take this brief to the other court where your senior is comfortable. Every time he is coming and my senior is busy in the other court. You tell I will send the file to the where is your senior is appearing, which court I am sending this file with the request to the Chief Justice. The learned advocate is not having the time to appear in the court number 38, so let it be court number so and so, so and so. This is the fourth time you are appearing. The order says.
Yes, Your Lordship.
So, who is your senior?
Ritoban Sarkar.
Huh?
Ritoban
Lord,
Sarkar.
I don't stand in the way. Let them submit on another day.
No,
May I
you
just
cannot say, but the court has to. And every day the court cannot adjourn the matter on the prayer of the junior. Either you come ready, the extension of time, why you persons are not reading the files? You are not attending the chamber of your senior. June also you have taken time. 17 June you have taken time. Yes.
Lord, may I just submit 2 minutes, my lord, on the facts? Thereafter, whichever day, my lord, my learned friend wants to submit, I don't believe there will be much rebuttal, my lord, in this matter. My lord, admittedly, para 5 of their application, my lord, I'll just indicate the dates. 24 July 2024, writ of summons received as per para 5 of their application. 120 days expires on 21st November 2024. They have affirmed the written statement on 21st November 2024. They have affirmed the affidavit in support of master summons on 21st November 2024. Master summons taken out on 26th November 2024, beyond 120 days, admittedly as per their case, and written statement never filed. This is the sum and substance of the matter. I am carrying my lord's own judgment, my lord, in the Fox and Mundell matter. My lord, I'm sorry. This is the stitched, my lord, this is the stitched copy. I'm sorry. I'll, my lord, hand over a copy to my learned friend. My lord, this is settled law today.
Saying one thing, madam. I am keeping tomorrow especially fixed when you have to come and argue. Not required to Mr. Sarkar should come. Come ready. Give this judgment also.
I've just handed over.
Go through this order also. And you have to, I will not allow your senior to argue. I am giving 24 hours. Tomorrow at 12 noon, I will take this matter. You will ready? What is your good name?
Apple Mahali Jimo.
Apple Mahali Jimo. Go through it and come with the what is your submission? Counsel for the plaintiff. The defendant has filed an application being GA
2 of 2024.
GA 2 of 2024, praying for extension of time to file written statement. The counsel for the plaintiff has raised objection and submitted that till date the written statement is not on record. Counsel for the defendant prays for time. Accordingly, for the interest of justice, the case is adjourned. Let the matter appear tomorrow. Tomorrow under the same heading. Come tomorrow ready.
Obliged.
I appear for the plaintiff respondent in this application.
My lord, due to personal difficulty of Mr. Sengupta Miller.
This can be allowed, my lord.
Yes, ma'am.
Their contention is written statement is within time. The department also made an endorsement.
Yes,
If written statement is within 120 days.
my lord can only
Earlier,
refer
my
to
lord,
page number.
Earlier, my lord, they came up with an application which was disallowed because they were not present. And we didn't know whether the written
What
statement.
application you filed?
My lord, this is a delay of condonation, good condonation of delay, my lord.
For filing written statement?
Yes, my lord. My lord would only refer to page number 110, my lord.
110 of?
This GA3, my lord. This application.
What is the GA2?
GA2, they have filed two separate applications. One is for condonation, one is for acceptance.
Yes, my lord. 79 days of delay, my lord. That is why. Would only refer to 100.
Receive the writ of summons.
Date of summons.
24 September, plaintiff filed the suit.
Yes.
Refer the reply. When you receive the writ of summons?
My
The
lord,
summons was delivered on 18th November 2024. My lord, this is the sheriff's report.
They have not stated anything.
service. My lord, it expired on 20th December 2024, my lord. And
Huh?
it
Now,
expired.
when you received?
I had received. My lord, extremely sorry, my lord. I'm being unable to assist your lordship, my lord, because I'm not the advocate on record, my lord. Under certain difficulty, my lord, I am just filling up the place of Mr. Sengupta, my lord, just for today, my lord. I'm extremely sorry, my lord.
Lordship will allow the application.
Extremely sorry, my lord.
Plaintiff, I'm saying, Lordship will allow. 18th November, writ of summons delivered, and
13th November. 18th November.
18th November.
Yes.
And they sought leave and filed the
The
application.
written statement in the department.
Yes, no, that is the at page 110 of this application. Lordship will
My
find.
lord would
there's
refer to the
110?
letter, my lord, at
Yes.
page number 109, the advocate on records letter at 109 of GA3,
yes.
and my lord, page, and that is, and page number 110, the reply from the registrar, my lord.
As per the report of master, the High Court interfered the written statement the defendant presented we will not terms of the due. 10th March.
Within 120. Within 120 days. But we didn't know earlier the application was dismissed. We didn't know whether it was filed or not.
How much cost you will pay?
To me personally, whatever it is.
Sole dependent.
Sole dependent.
Sole dependent, my lord.
Dependent has filed the present filed two applications, being GACOM 2 of 2025 and GACOM 3 of 2025. One is for condonation of delay in filing written statement, and another for acceptance of the written statement.
With the advocate on recording.
It is fine from the record. Learned Counsel for the plaintiff has handed over the service report issued by the Deputy Sheriff of Calcutta dated 3rd December 2024, wherein it reveals that writ of summons was served upon the defendant on 18th of November 2024. It is also fine from the record that the defendant has filed the written statement in the department with the leave of this court on 10th of March 2025, subject to acceptance by this court. Subject to acceptance by this court. Learned Counsel for the defendant submitted after receipt of the writ of summons, the defendant has contacted the present advocate on record, but the defendant could not produce the documents within time, and as such the written statement could not be filed within a period of 30 days. But after receipt of the document and instruction, the written statement was affirmed on on 4th of March 2025 and filed in the department with the leave of this court on 10th of March 2025, that is within a period of 120 days. Full stop. Had the learned counsel for the respective parties peruse the materials on record. Admittedly, the plaintiff has not filed the written statement and defendant has not filed the written statement within a period of 90 days, but within a period of 30 days, but has filed the written statement within the outer period of 120 days with the leave of this court. Police. Considering the above, this court find that one opportunity should be given to the defendant to file written statement subject to payment of cost of rupees 2,000 in the High Court Legal Service Authority within a week from date. Police. There is counterclaim.
We have not been served with the written statement. We don't know.
No counterclaim.
No, my lord, I believe that we have not filed any counterclaim, my lord. File
from date. The plaintiff is the defendant is directed to serve the copy of the written statement along with the documents to the plaintiff by tomorrow. GA Com 2 of 2025 and GA Com 3 of 2025 disposed of.
Deeply obliged.
Full stop. Please the matter on 20 August 2025.
Deeply
Lordship may pass directions for
Come on. First is come on record.
Great.
Then tomorrow you will say this is not legible, that is not legible.
Possible.
Deeply
Great.
obliged.
I appear for the defendant applicant. My lord, GA2 is my application, my lord, for referring the matter, or rather, my lord, for rejection of plaint on the ground of there existing an arbitration clause in the loan agreement, which is the subject matter of the suit. I had concluded my submissions on the last occasion, my lord. It was for the plaintiff.
I
to
appear
reply.
for the plaintiff. Lordship, kindly come to the master summons. The master summons, it is
Of GA2.
GA2 master summons.
My lord, would my lord grant me leave, my lord? Mr. Mitro is here.
So this is the
12:30. My lord, may I reply on another day, my lord?
No, I will not finish today.
Why?
No, you have cited many judgments. Your Lordship,
Hey, master summon कहाँ है?
so this is there are three prayers. One is suit dismissal, rejection and or return, and number three is stayed. So this is not for this is not on the not
referring.
Not referring. So the point urged is essentially, or you will see page 4, that there is an arbitration clause. Can you see page 4? The entire cause of action is paragraph 5.
22A.
Yes, 22A, and Lordship, middle of the paragraph, section 5 ousts the court's jurisdiction. Terms of section 5, no judicial authority shall intervene once it comes to the conclusion and that there is an arbitration agreement to the parties.
Yes.
Thus, once the judicial authority finds out arbitration act, the judicial authority finds that the court has the arbitration clause, it loses jurisdiction.
Yes.
Lordship, this in my humble submission is not correct law, and as has been held up by our High Court. After all, section 5, may I just place Lordship has the Arbitration Act with my lord.
Yeah.
Lordship has seen this number of times. It is like carrying coal to Newcastle. Kindly takes a look at the Arbitration Act, section 5 once, my lord. Section 5 does not oust the court's jurisdiction, especially when section 8 is considered. Section 5, notwithstanding anything contained in any other law for the time being enforced in matters governed by this part, no judicial authority shall intervene.
Yes.
Except where so provided in this part.
Yes.
So in this part, your lordship, it is provided under section 8. Section 8 is an optional provision. It's a waivable right. A judicial authority before which an action is brought in a matter which is the subject of an arbitration agreement shall, if a party to the arbitration agreement or any person claiming through or under him, so applies not later than the date of filing, submitting his first statement on the substance of the plaint, then notwithstanding any judgment decree, refer the parties, unless it finds that prima facie no valid arbitration agreement. And number 2, application preferred subsection 1 shall not be entertained unless it is accompanied. So, my lord, the defendant has the right to waive. So, suit is very much maintainable only if an application is filed subject to 2 conditions, that it is before first statement of defense and with the certified copy of the agreement. If it is not filed, the court has. So, looking at the arbitration agreement, where the plaint presentation stage or at the interlocutory application stage, the court does not lose jurisdiction. This is very much covered by our High Court. Straight away, let's go to the judgments. Oh, no, iPad টানতে বলো তো। Or may I cite 12 to CHN টা আগে দাও? 12 to CHN. সঞ্জীবেরটা ওটা নাকি? 12-2 CHN, 17-1 CHN, দুটো আছে। I must have argued this, placed these judgments before also, my lord, because this is an argument advanced once in a while, I find, but then. This 2012, volume 2, Calcutta High Court Notes, page 452. Now, other side ke dao একটা।
Yes.
But you kindly come straight away to paragraph 13. I hope I'm just seeing whether the paragraph tallies or not. Para 13 to? Yes, para 13. Arbitration by definition has to be consensual. There is no law that commands that upon a party acting in derogation of an arbitration agreement, the other party is obliged to seek enforcement thereof. It's a matter of choice. And the party can waive the arbitration agreement or accept the breach without a grievance. It then cannot be said that a cause of action asserted by way of a suit in derogation of an arbitration agreement can subsequently be pursued by way of arbitration upon the suit being filed. About suit filing. The unconditional withdrawal of a suit has the same effect as dismissal. It is true that it is an unconditional withdrawal. But this is a consent. Next to the 17th. Yes, not sure. Paragraph 7 on 2017 1 CHN 729.
Yes.
It is elementary that the resolution of disputes by arbitration has to be consensual. Otherwise, the parties to an agreement have to agree the dispute mechanisms would be by way of arbitration. Once such consensus is reached, the same would be reflected in writing. The writing will be so and so. In para 8. Again, merely because there is an arbitration clause contained in an agreement, or there is an independent agreement between the parties for their disputes to be resolved by way of arbitration, does not imply that the parties have to have the dispute resolved by arbitration and by no other method. Just as it is possible that a clause in any contract may be waived or the operation thereof may be disregarded by the party. It is open to a party to an arbitration agreement to act in derogation thereof. Upon a party instituting a civil suit, notwithstanding the dispute being covered by an arbitration agreement, it is not for the court to point out to the party that it should go to arbitral reference. As Section 8 of the Act recognizes, an application in the nature of specific performance of the agreement to go to arbitration must be filed, whereupon the court has to make a prima facie assessment as to whether arbitration agreement is valid and in existence. Upon a positive prima facie case in such regard being formed, the court is obliged under the command.
But now the subsequent judgments of the Supreme Court, what will happen?
I will show the Supreme Court also. They have shown a Delhi High Court, but that Delhi High Court is the only aberration. I will show the Supreme Court also. Only aberration where the court had, on the seeing the agreement pleaded in the written statement, the court referred. That judgment has been criticized, not followed by Judge Bhanumati sitting as a judge.
No, written is that now the Supreme Court deprecated by keeping the suit alive if the arbitration is there.
Without any application, without any application being filed. But that's the
not
question.
without any here, okay.
I am on that. Once the application is filed,
that's what I'm telling.
So I concede. I of course I do not disagree with that. Once an agreement is filed for specific purpose, so for enforce refer the parties to arbitration, and then the court has really no choice. but without making an application.
So you are on the prayer portion of.
I'm on the prayer.
Okay.
The pleading. So that's the whole point.
Okay.
That's why I'm showing his section 5 will not oust the court. His pleading is at page 4 of his application, paragraph 5, that section 5 ousts the court's jurisdiction.
That okay.
That is not
got,
so.
got,
So he cannot ask for rejection of plaint or on the basis that the court has no jurisdiction. In fact, this kind of an issue came up in. I will since my lord put this question, let me show the division bench of Hyderabad High Court, where this issue came up. Like this, I mean, this is Justice Banerjee's division bench also says so. You must make an application for this relief. You should kindly take a look at the Hyderabad High Court judgment, division bench. 2018. 2018 now. This is also reported in All India Reporter, 2018 Hyderabad, page 18. Paragraph 15. This is now, so they have to make it. If they apply, I will see. I will face it. It is a submission of the learned counsel for respondents that once it is held that there is an arbitration clause governing the dispute between the parties, this court is bound to refer the parties to arbitration. Particularly, your peremptory language. The learned counsel for the respondent rely upon Hindustan Petroleum. Held that the court has no mandatory duty to refer the issue to arbitration. It finds that there is an arbitration clause governing. As per the learned counsel for respondent, the learned counsel for petitioners himself cited the Constitution bench. I am not Constitution bench in Patel Engineering. In this case, paragraph 16, the Honorable Constitution cited Anand Gajapati Raju, where I will show the Anand Gajapati Raju also, where under the mandatory language section 8 was held to be binding on the courts. In the present case also, as per the counsel for respondents, the application in IA 1751 to styled and one under Order 7, Rule 11 makes a reference in paragraph 4 that there is an arbitration clause like our case and that both the parties must go to arbitration in terms thereof. There is an express reference to section 8 of the Act in paragraph 5. In our case, possibly there is not even a reference to section 8. It is only ousts the court jurisdiction. No, there's a reference. Yes. It is also averred in this affidavit that filing of written statement would amount to waiver of the arbitration clause. Thus, in essence, that the necessary ingredients of section 8 are complied with as per the learned counsel for the respondents, C.V. Narasimhan. The learned counsel also argued that plaintiffs submitted to the jurisdiction of the court. A reading of the letters. Now, para 17. Considering all the above, the question that arises is whether the lower court was right in rejecting the plaint. Learned court should have seen that section 8 of the Act only empowers the court to refer the parties to arbitration, but does not give the court an option to reject the plaint. The lower court also lost sight of the fact that Order 7, Rule 11, CPC empowers the court to reject the plaint, where there is a bar to the suit because of any law. Section 8 of the Act is not a bar to a civil court. It provides an alternative to a defendant against whom a civil suit is initiated to submit to the jurisdiction of the civil court or to make an appropriate application at the appropriate time under Section 8, seeking an order to refer the parties to arbitration. Therefore, Section 8 of the Act cannot be considered as a bar to the civil suit entitling the rejection of the plaint under Order 711. The bar under Order 711 is an absolute bar to the suit which enables the court to reject the plaint at the threshold itself. Then para 18. In addition to this, the other important issue argued by both the counsel is whether the application which was presented ISO was an application Order 7 Rule 11 or an application under Section 8. An ex facie reading of the application shows that it is filed in Order 7 Rule 11. And the relief sought is that one for the rejection of the plaint filed by the plaintiffs, as the Honorable Court has no jurisdiction to try it again. This is exactly the case here. The counsel for the appellant submitted and argued that in effect it was an application under Section 8 only. as can be seen from the averments made in the affidavit. However, the provision of law was wrongly quoted. He also submitted that substance of the application should be looked into if the statutory power is available. The court can exercise the power even if the wrong provision of law is quoted in the application. Now, however, it is noticed as per the averments in the application, petitioners in IEA have clearly stated that the High Court has no jurisdiction to entertain the instant suit, and the plaintiff is liable to be rejected in view of the arbitration clause provided. The prejudice for rejection, exactly our case. It is not a case of a mere provision, wrong provision of the law being quoted. At first blush, the argument of the learned counsel for the respondents appeared to be reasonable. But it is particularly important to note that when a statute describes or requires a thing to be done in a particular way, it should be done in that manner or not at all. The popular principle of law is settled in very old case of Taylor versus Taylor, which is cited with approval of the Honorable Supreme Court in Shiv Kumar Chadda, and so forth. Then the sixth line, an application of Section 8 is an application that should be made in a particular manner and at particular time. The application should be accompanied by the original arbitration agreement or certified copy under Section 8.2. Even the Andhra Pradesh arbitration rules as framed by this court that every application Section 8 has be duly signed and verified. It shall state the provision of law under which it is filed and contain a statement as described in Rule 4 of also states. So, Lordship, the last three lines. The Honorable Supreme Court in P. Anand Gajapati Raju also laid down the manner and method in which an application Section 8 should be filed. I will place that. In view of above discussion and legal position, the court is of opinion that the application that is filed in this case, IEA so and so, is not an application under Section 8 of the Act. It is an application Order 7, Rule 11, seeking the rejection of the plaint on the ground that the arbitration clause bars the suit. So, and there can't be any oral application today. That's those days are over. So, there are several other judge lordship can keep it.
Okay, next.
It is dismissed.
Counsel for the plaintiff has argued the matter at length, but due to paucity of time, hearing could not be completed. Let the matter. Can it be in the list tomorrow?
Tomorrow I have no difficulty. Tomorrow morning I have a difficulty, Lordship. Monday.
Let the matter appear on 18th. 18th.
I'm grateful.
Okay. August.
Sorry.
Yes. Call the pic.
Appearing for the plaintiff, Lordship, this was their application. Recollects that amendment application was allowed by your Lordship.
No, this is not an amendment application.
Which was upheld by the Supreme Court, and thereafter they filed an application for dismissal of the plaint on the ground.
My application may
Lordship was hearing Order 13A of the commercial code that they do not want to adduce evidence, and that is why my plaint should be dismissed.
Lordship, may I may I commence my arguments, Lordship?
GA 14?
GA 14. Lordship, the first, right now at the stage at which the suit is, the judge's brief of documents has been filed. Therefore, discovery inspection is completed. Now, the plaintiff has all that the plaintiff had in its custody, documents in custody or documents in possession or documents in knowledge has all been put before your lordships. Everything is on record. There is no further documents that the plaintiff intends to or rather wishes to rely on. Now, in view of that, my application now before your lordship is, suppose lordship, the plaintiff has 5 claims. In respect to 5 claims, the plaintiff has failed to produce any document in support of 3 claims. Now, all that by my application I am placing before your lordship is that those particular 3 claims in respect to which no documents has been produced or are in custody of plaintiffs. Now, since the judge's brief of documents is ready and filed, there is no documents. We have looked in. The learned juniors have also looked in. There is no document in support of these particular claims. Now, lordship will kindly take the order 11. Lordship is aware that by the amendment of 23rd October 2015, the process in a commercial suit was fast-tracked. Why? Because a commercial suit, the time is of essence, and frivolous claims may be cut short by an application under Order 13A. Lordship will kindly see Order 11 and Order 13A has been amended and brought in by the amendment of 23rd October 2015. So intention of the legislature was to cut short the matter. My intention as a defendant before your lordship is also to cut short the matter because there are no supporting documents in respect to certain claims. Now, which are those claims? Now, lordship, I have prepared a chart. Extra copy. Lordship, may I take your lordship through the claims which I submit that there are no supporting documents? Kindly take paragraph.
Issue framed.
Issues have been directed to be framed. I have put in my
Suggested issues have been put in, lordship, the issues, because Order 13A presupposes that the issues have not been framed. We are at such a stage. Judge's brief of documents are ready. Now, everything has been disclosed. We have looked in. There is no document in respect to these documents. May I, these claims, may I indicate? Kindly takes page paragraph 38 to 43 of the plaint, which is at page page 44 of the my application. This is the amended plaint, lordship. This is after amendment, and by way of an amendment, there are paragraphs. Several paragraphs have been incorporated, and even claims have been incorporated in the plaint. Now, kindly come to page 44 onwards. Paragraph 38 to 43 is in respect to lordship. May I place this paragraph? The plaint, paragraph 38 onwards, the plaintiff further states that on the self-same reasons as aforesaid, the penalty imposed from time to time under clause 2A of the contract is wholly illegal and contrary, particularly clause 12 thereof, as much as there is no certificate by the engineer in charge stipulating the proportion of the supplementary work executed in relation to the original contractual work. Nor does the orders issued under clause 2A issued from time to time imposing penalty taking into account the said proportion of the supplementary work. The said order imposing penalty to the extent of so-and-so is thus wholly illegal, null and void, and liable to be set aside and quashed. The plaintiff, on or about 7 July 2015, came to learn, lordship, this perhaps is the cause of action, learn that a purported order was uploaded. This is a cause of action of 7 July 2015. Uploaded in the website, and defendants by which the plaintiff has been purported to be debarred from participating in any tender in PWD for the next 2 years with effect from the date of issuance of the said order. The purported order has come as a total surprise to the plaintiff, as no prior notice was issued to the plaintiff before issuance of the said order, purporting to blacklist the plaintiff. The basis of issuance of the said order, as contained in paragraph 2 thereof, is wholly illegal and false and would appear from the statements contained herein above. Lordship, this continues, the plaintiff being aggrieved by the illegal and arbitrary conduct on the part of the defendant, debarring the plaintiff for a period of 2 years, instituted a writ. In the writ petition, the blacklisting order has been directed to the authorities to remove the name of the plaintiff from the website. Subsequently, the engineer, this is paragraph 41, lordship. Subsequently, the engineer-in-chief and ex-officio secretary of the Public Works Department issued a notice dated 8 September 2015, thereby alleging that the plaintiff have failed to execute the work within the time period, requiring the plaintiff to show cause as to why punitive action will not be taken. Lordship, this continues till paragraph 54. Lordship, there are several show causes which has been set aside. Lordship, thereafter at paragraph 54 is the relief that is claimed in respect to. Lordship, paragraph 52 at page 51.
Yes.
The defendants, by acting in manner as aforesaid, particularly by imposing penalty without recourse to clause 12 of the contract and consequently rescinding the contract, have invaded and or threatened the plaintiff's right under the said contract in question. The invasion is such that compensation in money will not provide adequate remedy. Injunction is necessary to prevent multiplicity of proceedings. The plaintiff is thus entitled to and claims a decree for perpetual injunction restraining their men agents effect to the memorandum issued from time to time imposing penalty aggregating to so and so. 53 is the quantification. His
Yes.
plaintiff is entitled to a sum of rupees 57,76,037 from the 35 from the defendant as per the following particulars.
Yes.
Interest on delayed payment on account of bills, refund of the amount deducted from security deposit. Now comes the question, Lordship, when a plaintiff is claiming refund of a certain sum, the very first document that the plaintiff requires to disclose or rely upon or furnish is to show that such an amount had been deposited at so and so date for which the refund is paid for. Now we have looked up all the documents that has been disclosed. An amount of rupees 48,76,037. There is no document to show that this amount has been actually deposited by the plaintiff. Now, if that their document is not disclosed in a commercial suit, then no claim can lie against no claim can lie, and that claim needs to be struck off. Next comes, Lordship, but this is part of Lordship, there is no document with respect to this. Lordship, the next claim that appears at paragraph 44, Lordship, which is at 47. Page 47. Paragraph 44. Lordship, this is again a claim with respect to estimated loss and damage suffered. May I place paragraph 44, which is at page 47?
Yes.
The plaintiff reasonably estimates the loss and damage suffered by it as a consequence of the wrongful order dated 7 July 2015 and the publication and circulation thereof to be 2,21,61,296.
Yes.
We do not know on basis of which this figure has been derived. The plaintiff is accordingly entitled to a decree for a total sum of pleaded above. Now, this is, Lordship, there is no document in respect to this quantification of loss.
Madam.
If there is no document
for damage,
yes,
and
Lord.
whatever the thing, it is the duty of the plaintiff to prove an evidence.
Yes, Lord.
The court cannot prejudge. He has no document, the suit go out of the court. It is the plaintiff case. It is up to the plaintiff to decide the case, whatever the procedure he has opted.
Yes,
The
Lordship,
court has
here-
to see whether he has adopted the legal procedure. He has filed the suit because he is claiming with regard to the damage, because every now and then he had blacklisted. He challenges the blacklisting time and again the competent court having jurisdiction set aside all the orders and given the liberty. Now he claimed with regard to the damage he has suffered. So he has to prove all the judgments is there.
Lordship.
Your blacklisting orders is there, correct?
Yes, Lord.
Contract awarded to the plaintiff is there, blacklisting is there, order passed by you time and again, order passed by the High Court or the competent court is in the file. Subsequently brought on notice.
Yes.
So he has to prove how this damage of 74 lakhs or 7 lakh or 80 lakhs, he has to prove on doc. The court cannot image by sitting here. Yes, he cannot claim to 1 crore rupees. He cannot. The court has to evaluate the evidence.
Lordship, these issues we shall raise at the time of when the evidence is.
Yes, you raise your evidence.
We shall, Lordship.
You have authority. You can cross. No, raising it does not arise. If you adduce the evidence, if you will get an opportunity to cross-examine and
Now,
you
the only,
cross-examine.
Lordship, what my argument
Why
is,
the
Lordship,
cross-examination?
Lordship, I can cross-examine to show that there is no document.
Correct.
Lordship, but since the provision says if there is no document, it can be cut short.
Correct.
That's to
No
save the
document,
time,
it can be
judicial
cut
time.
short. Suppose I am
And
fed
there
up.
is no scope.
Suppose I am fed up with the authorities. I filed a 50-page application, this and this and this and this, that this and he has done nothing document. Then the court can take exception to that. Yes, there is no document, only by a pleading, and by a pleading it cannot be. But in this case, this
Lordship, there is no document,
but
Lordship.
here your blacklisting order, quashing order, High Court order, Supreme Court order, all the things is there. Then he has to prove the
Now,
compensation.
Lordship, here, may I, only my submission is restricted to the fact that if there is no document now on record, when the judge's brief have already been filed,
correct,
there is no further scope to adduce further evidence. Lordship, if your Lordship records this,
You can see, madam, you cannot, the party or court cannot restrain a person to adduce the evidence.
No, Lordship, they
Show me the law. Show me the law.
Lordship, the
Show
order
me the
11
law
is
where
there.
the court
May I
has the
place?
jurisdiction to restrain the party to not to restrain, and I will pass a order. Show me the order.
Their application, so they are saying.
Show me the
Lordship,
law.
may I place order 11, Lordship? First?
Yes, show me. You are telling the expedite and you are delaying the process from
that
one
is-
time.
that is
Then
not
I will then record this. If you are going on merit, I will record all these things. In open court, I am telling. Not to play with the court, with the state. I will record all these things and I give the compensation with the cost. If you further pursue this application. You continue. I will hear the 3 days to you.
Lordship, I do not need.
No, you continue.
Lordship,
You started your argument. There's a commercial court is for the expedite. And since beginning, when I have taken the determination of this court, I am dealing with one or the other. This is GA 14.
Lordship,
What the state is doing, I am giving the compensation here in now. Go and challenge to the Supreme Court.
Lordship, let all points be kept open. I'll take my.
What kept open? Issue will be framed.
Yes,
What
Lordship.
in the civil suit, any point is to be kept open. This issue is to be decided in the civil suit. What are the issues you have raised in the
Lordship,
written
Isha,
statement? What the issue he has raised in the plaint? That is the issues. That is to be decided in the
Yes,
plaint.
Lordship. These points will suggested issues will incorporate these points.
Lordship, 1 year, I'll be asking for, because 1 year they have spent on this GA 13, GA 14, same thing.
Lordship,
Even after Supreme Court upholds the
several
order,
GAs
they
were
again
filed
come
by
up
the
with this.
plaintiff.
Now, order
Might
13.
be, but
Plaintiff
some
has filed certain
limitation, some
applications.
limitation. State has this. Not I am telling the state. All the parties having some limitation. It is not that one or the other applicant. You are submitting that the object of the commercial court is to expedite the trial, expedite the matter, and you are filing an application. If you want, the court is not restraining, you continue.
No,
There is no
Lordship,
problem.
my
I will
prayer
hear.
now, Lordship, I am submitting that these issues, Lordship, I shall file my suggested issues in which I'll incorporate these points.
So what
Lordship,
will
may-
happen to this application? Tell me.
Lordship, let the application be, Lordship, Lordship, I'll take these points in the suggested issues, Lordship.
Yes, take that.
Lordship will direct me, I shall.
No kind of liberty, but I was saying, Lordship, order 13, Lordship will see their filing of this order. Lordship will see the wording of order 13A. The filing of this application is without recording oral evidence. So their right for oral evidence gets.
That's why the 13A has come.
Exactly. So, Lordship, if that is application is taken on board and rejected, there means their oral evidence gets stuck.
No.
So that is a very wrong interpretation.
That is
Lordship.
different thing.
Lordship.
Second thing, if a damage has to be
I will
proved.
prove my
Later
case.
judgment of the Supreme
judicial
Court. Even in the arbitration proceeding, even in the arbitration proceeding, the damage, the court suo moto, even arbitrator suo moto cannot say yes, it is a damage. It is the duty of the person who claims.
Yes.
And you cannot restrain, no, you cannot adduce the evidence for. Okay, you are not adduce the document. If there is no document, but might be something else. Yes, was what you want to say.
My lord, only thing, my lord, we have heard whatever has fallen from your lordship, my lord. But the 13A consequence that I am not going to agitate any further, but a 13A consequence of 13A, particularly in a scenario where when the plaintiff has not filed or used any reply. The consequence is self-contained and embodied in the section 13A itself. My lord, kindly record, my lord. Definitely, we will agitate whatever our grievance in our issue that will be adjudicated, my lord. And my lord, let it be recorded, my lord, that they will not be adducing any further document.
Who?
The plaintiff.
Why it is recorded? That is
Because
law
order
provides.
11 has already stood in the
Sir, commercial code law provides.
The lower court.
The court cannot restrain. If they want, let they come with an application. You oppose that, the court will decide in its own facts. What the law provides. In the commercial code, they cannot deduce any further document which are not disclosed.
The
If
teeth
it
of
is,
order
if it is
11,
in the possession of the parties.
Very well, well.
So what can be done, sir? Tell me this.
Rejection with costs, extremely heavy costs.
Yes.
I believe the
Not press.
একটা instruction নিয়ে আসা উচিত। Well, Sinha is the best person to address on this.
But I think your lordship may please to dispose this off now with liberty. Because I'm not.
No,
to raise all.
of liberty. This is
That
what
they
is
will dictate
falling.
also.
Either
Look,
yes,
I have not-
obviously, either they press this, I will then pray for rejection of this application, or they withdraw this. They cannot be
No,
liberty.
no, I don't wish to not press the application, but I have made myself clear. Not because not we in law are entitled not to raise issues. So we'll raise.
So
Lordship
whatever they want to do.
your lordship may record my submission not that I'll raise these points in
May
the
that
issues not.
liberty be-
Yes.
whatever
I
point
don't
you
need
to
liberty.
agitate,
I don't need liberty.
What issue?
Lord, issues not. He has suggested issues not. We'll give our suggested
Correct.
issues.
Suggested issues with regard to the pleadings only, not
Lordship,
the applications.
No, not about the application.
Not of the
Yes,
application.
yes. Your lordship may dispose of the application, but I'm not pressing the application.
So what you want the, on merit the
No, no,
order?
your lordship may dispose of as withdrawn.
withdrawing?
Yes, yes. Disposed of as
You're withdrawing.
I'm withdrawing the application.
After 6 months of laboring it.
The defendants have filed the present application being GACOM 14 of 2025, praying for summary dismissal of the suit or in the alternative for rejection of plaintiff. Police counsel for the defendant has argued the matter at length. Subsequently, the counsel for the plaintiff counsel for the defendant in their usual fairness prays for not pressing the present application. Accordingly, GACOM 14 of 2025 is dismissed as not pressed.
Great, good.
Lordship,
It
the
is-
suggested
it-
issues have
it
already
is
been filed by
informed
the
that
plaintiff.
Your lordship not fix the date, not we'll come up with
it
that.
is informed by the party. The case is at the stage of framing of issues. Let the matter appear on 12th of August 2020 and 19th of August 2025 for framing of issues.
Highly pleasure.
No, maybe have one more week, not 26th. Maybe
For
26th.
framing of issues.
19th. Okay, come on 26, no problem.
grateful.
26th August.
1 year they wasted time and they come up with kind of innovative
The
application.
Sina is there, so 1 week.
I know. Has to. He has to come in front to get these things done.
Your lordship not finds a change, my lord, in Mr. Shah, my lord. He's really
Yeah,
calmed
yes,
down,
yes.
lord. He's really calmed down of late, my lord. This
Yes, call the matter. बोलो वो क्या है हमारा अर्दली क्या है यहाँ भेजो उसको यहाँ भेजो call the matter call
14. My lord, appear for the applicant defendant, my lord. My lord, this is my application for acceptance of written statement.
just a minute
Yes, ma'am.
yes
My lord, this is my application for acceptance of written statement, my lord, filed within the 120 days. My lord, writ of summons was received on 20.
where is the
15
application
My lord, this is GA
one
1. My lord. Yes.
yes
কোনো তারিখে রিসিভ করেছিস
হ্যাঁ
বাই পোস্ট
yes
My lord, summons was received on 15th of February. It's been recorded in my lord's order of 1st May 2025. I have affirmed the written statement on 9th of June. That is immediately after reopening, my lord.
15th February you received
Yes, my lord.
correct
My
Then-
lord, there was an intervening vacation. 9th of June it opened. Affirmation was done of the written statement on 9th of June and application was filed on 10th June. My lord, 120 days expires on 13th of June tentatively. My lord, we are within the 120 day
application
period.
filed on 12th of June from cost case status available?
My lord, application has been affirmed on 10th of June. My lord, will kindly see.
Affirmed as
And
well.
my reasoning is, my lord, the advocate on record's brother had passed away. One of the reasons, my lord, I've annexed the bereavement note. Yes, my lord. So I'm relying upon the same, my lord. Para 5 onwards is the application, and page 11 is that attachment. My lord will kindly allow well within the 120 days. No counter claim out here.
Yes.
Milad, the application was filed on 12th of June. Anyway, Milad, it was 2 days prior to 120.
But the written statement was
written
filed.
statement they have filed, Milad, they have
leave on
mentioned, Milad, though it was mentioned without notice. Milad, be that
No,
as
this-
it may, Milad usually gives Milad the leave. Milad, don't record any concern, Milad will do the
Grateful.
only thing, Milad, only prayer, Milad. This is Milad, Milad, single person who's running the business. Give it some precedence, Milad, the directions for Milad, the usual directions, so that we can come back with the suit before the lordship as early as possible. Because I'll take that Milad advantage of your lordship.
That I do not stand in the way.
Because his monies are stuck, Milad.
Sole defendant.
Sole defendant. One is two.
Defendant has filed the present. Acha, Syam Sil.
Yes.
I am only thing is, Milad, I used to appear for them also, Milad. I defended many section 7. So that's the only difficulty. So Milad, kindly expedite
The
Milad.
defendant has filed the present application being GA-Com 1 of 2025, praying for extension of time to file return statement. Counsel for the defendant submit that the writ of summons was served upon the defendant on 15th February 2025. On receipt of the writ of summons, immediately the defendant had approached the advocate on record of the defendant, but unfortunately, the Illinois advocate appearing for the defendant suffered a tragic personal bereavement. On 16th April 2025 in the form of sudden and ultimately death of his elder brother. And in the meantime, the summer vacation also started, due to which the written statement could not be filed within the period of 30 days. He submit that after the summer vacation, the written statement was affirmed on 9th of June 2025, and with the leave of this court on 10th of June 2025, has submitted the same in the department, subject to acceptance by this court. Police counsel for the defendant submitted that due to some personal difficulties of the advocate on record, the defendant could not file the written statement within the period of 30 days, but has filed the written statement within the outer period of 120 days, and as such, he prayed for acceptance of the written statement. Per counsel, an advocate for the plaintiff raised objection and submits that the defendant has received the writ of summons on 15th of February 2025. He had to have filed the written statement by 14th of March, by 16th of March 2025, but has not given an explanation as to why within the said period the defendant has not filed the written statement. The case made out by the defendant that the father of the advocate on record was suffered seriously and brother of the advocate on record died on 16th April 2025, but by that time the 30 days period was over. He prays for rejection of the present application. Had the learned counsel for the respective parties peruse the materials on record, this court find that though the defendant has not filed the written statement within a period of 30 days, but has filed the written statement within the outer period of 120 days, and as such, this court find that one opportunity should be given to the defendant to file written statement, subject to payment of cost of rupees 2,000 in the High Court service.
My lord, just humbly praying, my lord. I know this, since it's a personal difficulty, my lord, that cost will. My lord, that will be a token on us, my lord. That's just I'm just humbly praying, will
1,000 rupees.
My lord, kindly expedite the suit, my lord, with the directions, my lord.
With the High Court Legal Service Authority within a week from date. Full stop. The different have you served the copy?
Yes, yes. We have received.
Department is directed to accept the written statement subject to scrutiny by the department. Full stop. As the written statement is accepted, full stop. Accepted and both the parties are appearing before this court, comma. The parties are directed to complete the discovery and inspection of the document within a period of 3 weeks.
Do it before, keep it, my lord, before puja, my lord. Do it
Within a period of
3 weeks is, my lord.
Within a period of 3 weeks. Full stop. Affidavit of admission and denial be filed within a week thereafter. In the meantime, the parties are also directed to exchange the suggested issues. List the matter on 4th of November 2025 for framing of issues. GA number 7 dispose. Yes, call the list.
Lord, this is my contempt application, my lord. Pursuant to your lordship's last direction, we have effected service, my lord. We have been able to serve only 5 out of all the respondents, my lord. I do not know if everyone is represented, my lord.
Well, I am appearing for the all alleged complainants.
All.
Yes. This is my affidavit of service.
Yes, what is the instruction?
Well, may I hand over a compilation, manner, because there are a lot of letters, communications issued after the order was passed. May I have pray.
Want a copy, no? Yes.
No,
have you served?
Well, I have received. Well, only once sees the order of your lordship's, my lord, the direction. Page 84 of the contempt application, may I place the direction, my lord? The respondent authorities are directed to take appropriate steps for granting final clearance to the appellant. Now, my lord, kindly says, in my humble submission, in compliance of this order, we have taken all possible steps that can be taken, my lord. May I place that compilation first, my lord? After this order was passed on 22nd December 2022. And immediately after that order was passed, page 4 of that compilation kindly sees, my lord, this retail outlet is situated on national highways. Now, if your lordship knows that if there has to be an access granted by the National Highway Authority for having any access to any properties on the national highway.
Correct.
So now this retail outlet is also situated on the national highway. So accordingly, the access permission is required from the National Highways authorities. Well, accordingly, we requested, well, kindly see page 4. This letter was issued on 16th of January 2023. Well, we have requested, we have also paid the process fee. The process fee is also required to be paid for grant of access. So we paid the process fee and all the necessary documents which were required. And we requested the National Highway authorities to grant a access permission. Well, no response was received. Thereafter, kindly see the next page. Again on 21st of February 2023, we again wrote to the authorities.
Yes.
And we also said that we have to make this retail outlet operation in compliance of an order passed by this honorable court. We have also indicated that. Thereafter, my lord, nothing happened. Again in the next month on March 2023, page 6, 13 March 2023, we again made a request.
Yes.
Thereafter, for the first time on 16th of March 2023, page 7, in response to our earlier letters, we got a letter from the authorities. They pointed out certain discrepancies and made the following observations. The location plan is not clear about exact chainage and surrounding places of the proposed retail outlet. ROW details of submitted drawings are wrong. The proposal is not maintained to maintain the ministry guidelines dated 26 June 2020. In response to that, we submitted further documents and clarification. Page 8, 12th of April 2023.
Yes.
We accordingly requested the authorities for a joint site verification.
Yes. Joint visit of our office and further issue necessary. Yes. Then what is that?
Then nothing happened. Again, we wrote on in June 2023, page 9.
Yes.
We referred to the earlier memos and we said that we are resubmitting the proposal after compliance of this. This is the guideline that the National Highway authorities were relying upon, a guideline of 26 June 2020. So based on that, we submitted that we are submitting revised proposal. Thereafter, we did that. And again, we wrote a letter on 12th of July 2023, page number 10. And we requested for NOC from the highway authorities. In response to that, my lord, the authorities wrote us on 3rd of August 2023, page number 11.
Yes.
Then they pointed out certain observations. The size of the plot is not satisfying the requirement as per ministry's guideline. Location plan showing all features like ROW, existing intersection and intersecting roads, including existing public roads and other development falling within a reach of 1.10 kilometer in each side of the fuel station and carriageway has not been submitted. Document of land is not available. As per inspection report, concerned executive of engineer, there exists a retail outlet at a distance of 25 meter and at the same side on the proposed one, which is less than 300 meter, because this is against the guideline. Hence, it is not fulfilling the required norms. Now, in response to that, they again, citing the same thing, they again wrote a letter on 9th of August 2023 with the same observations.
Yes.
And in response to that, we again wrote them on 14th of September 2023.
Whatever now, what is the latest position?
Now the last thing which they have said, the National Highway is saying, authorities is saying, you have the area of the retail outlet is not as per the minimum requirement as per the NHAI norms. So accordingly, the area may be enhanced. Otherwise, it has to be recited at a different place.
So who will pay the cost of the reciting, the expenditure made by the petition? You are the NHAI.
Well, kindly say,
because this order has been affirmed by the Supreme Court.
Yes.
So we cannot review, recall or nothing. Correct. And till the Supreme Court, NHAI was silent.
No, not silent. NHAI was present in the Supreme Court. It's recorded in the in the Supreme Court order.
Where is?
Let kindly take the Supreme Court order at page 47.
Yes.
I stand corrected. 47 is the initial order. Page 48.
Yes.
National Highway Authority was represented by none other than the Solicitor General,
Venkataraman.
ASG.
Now, my lord, kindly take page 48. My lord, kindly see the petitioner. My lord, kindly see the petitioner was the private respondent who had the subsequent writ petition which your lordship decided together, because the other pump owner is the private respondent, which was private respondent in my writ petition. He said that he pointed out that there are alleged violations and irregularity of Road Congress guideline based on the National Highway Authority's guideline. Your lordship turned that down.
Correct,
Your
because they are
lordship
not
said
adopted
no,
that.
nothing doing. When this went to the Supreme Court, now my lord, kindly have a look at the respondents in the Supreme Court. My lord, the ASG represented Archana Pathak, represented the Union of India, which is the National Highway Authority. So they could have pointed out to the Supreme Court that this retail outlet could not have been granted because of the alleged irregularities or whatever today they are saying post the Supreme Court order. Now, my lord, not only that, my lord, your lordship will see that the Mr. Venkataraman, the other ASG appeared. So not one, two ASGs that appeared. And my lord, we had appeared on behalf of the petitioner. So the matter was heard in extenso. Well, I can say this because I was personally present in court.
Well, if the National Highway Authorities, the only thing that is standing in the way is the no objection from the National Highway. So if National Highway Authorities,
It is your headache, sir. It is your headache.
but the National Highway Authorities is independent.
You file a compliance report by the next date, otherwise have to face the consequence.
Because the National Highway
All
Authorities,
parties appeared before the Supreme Court.
the National
Oh,
Highway
they were
Authorities is not a
partying
party
before
to
the
the
writ
writ petition.
court.
Maybe.
They were not a party in the writ petition.
Of course they are. National Highway was a party in the other writ petition. The
No. It is SLP. SLP, the National Highway Authorities are not party.
well, the other writ petition which were heard together by the private respondent, the only party was the National Highway Authority.
Well,
So
I
their
have the
entire writ
SLP.
petition was based on the National Highway Authority guidelines.
Well, I have the copy of the SLP. National Highway Authorities are not party. I have the copy of the SLP. National Highway Authorities are not the party in the SLP.
Okay, whatever it may be, you tell me this court when you comply with the order.
Well, we have already issued letter of intent.
Ah.
We have already issued, the appointment is made. We have already issued letter of intent. The only thing that the petitioner is required to operate, if he has all the licenses, he can operate, because we are not standing in the way. We have issued the letter of intent. We have made the appointment.
You file an affidavit, he can start the, he can run the.
The only
The appeal
permission
paper
that is,
book before the Supreme Court, the opposition. No, my lord, I'll show you a lot. This is the opposition filed by the National Highway Authority. My lord, affirmed by Dinesh Kumar Hansaria. My lord, kindly have a look at volume 124. What is he saying? National Highway Authority of India. My lord, kindly have a look at this. This is the writ. On the basis of this, the division bench, your lordship, my lord, was a member of that bench, my lord, sitting in there. This is the affidavit that was filed by the National Highway Authority.
In our writ?
Yes.
now, no.
This is in 13179 in this room.
Yes.
This is the other writ petition, my lord. This is not the writ
Both
petition.
the writs were heard together.
Both writ petition has been taken together.
But in the order, my lord, the order that your losses has passed, that order has been passed only in this appeal, not in the writ petition, my lord. Kindly see that order. Earlier, there is a direction for consideration of the writ petition as well as the appeal. But the order your losses has passed, that order was only in the appeal, not in the
689.
It's not in the writ petition. Kindly see the order, my lord.
Yes, Mr. No, in the 689 only. This is the MAT 689.
Yes.
Correct.
Yes.
This affidavit in opposition.
No, this is the writ petition.
And my lord,
whatever it may be.
Not the writ petition connected with this mat.
and
This
my
is
lord,
the other
this
writ petition.
and the appellant before the Supreme Court was the petitioner of the writ petition in which National Highway was a party.
The MAT number, what was the MAT number?
MET number.
689?
689.
Correct.
Yes.
This affidavit in opposition is filed MET 689 arising out of 6840. Can you see this? Can you see this?
Repetition to court.
My lord, my junior rightly points out, my lord, kindly take the trouble of once coming to page 27.
Of your contempt application?
Yes, madam.
মানে this
Yes, 27.
Contempt petition page 27 টা খোলো। This is the order
Yes.
passed by your lordship in the appeal. My lord, kindly take MAT 689 of 2020.
Yes.
My lord, this is by Ashif Mehboob. Ashif Mehboob was my clients. Now, my lord, kindly come to page 29. Kindly take the last 3 paragraphs of page 29. In fact, the entirety of page 29.
Yes, the appellant in the present appeal shall be added as a
Correct,
repetition in WP
Yes,
13179.
And my lord, kindly take the last 3 paragraphs. The appellant shall file an informal paper book, such and such. At the same time, the party shall be entitled to complete their respective affidavits in WP 13179 of 2019 with a cumulative period of 3 weeks.
Yes.
Appellant in the present appeal shall add the writ petitioner in WP 13139 as a party respondent in this appeal.
Next page.
My lord, and my lord, why? If the answer is there in the first para at page 29.
Okay, in that case, what
My
I
lord,
propose?
my lord, my
You
lord.
file, you have given this document. To come with the affidavit of compliance, it will be decided on merit. That will be,
My
nothing
lord,
can be done.
authorities, bureaucrats will never follow orders of court unless it suits their purpose.
That's why he has given the document. Let come with the affidavit of compliance. How much? How soon?
2 weeks may be given. 2 weeks may be given.
2 weeks.
Very well.
Well, if philosophy also give some directions on the NHI authorities, because if the NHI authorities is appeared before this honorable court as well as before the honorable Supreme Court, the NHI authorities also to be
not let your affidavit of compliance come.
All he has to do is, in terms of your lordship division bench order, give me the final clearance.
Well,
That is the direction.
Final,
Issue the final clearance.
there is no document termed as final clearance. My lord, the a letter of
You
intent
said that
has been
anywhere
given. Well,
before the
letter-
division bench, before the Supreme Court.
An advocate appearing for the alleged contemners has handed over bunch of document containing 74 pages. Let the same be kept with the record. Police. After hearing the learned counsel for the alleged contemner, this court is of the view, we are of the view that the contemners shall file the affidavit of compliance of the order dated in respect of the order dated 22nd 12 2020. Let affidavit of compliance be filed within 2 weeks after serving the copy to the learned counsel for the petitioner. Let's list the matter. (28th August at 1 p.m.)
Grateful, madam.
Great one.
Thank you.
2024. My lord is hearing it. I am appearing on behalf of respondent number 5 and 6, lordship. The writ of summons was served upon me on 16th April 2025. This is the 118th day, lordship. My application is being filed. I was praying for leave to file my written statement in the department.
Ready?
Yes, lordship. It is affirmed and punched. Grateful, my lord.
Filed it today and it's
Yes, lordship. Filed.
yes. Call the matter.
The date fixed for witness action.
Yes.
That we have already handed over the judge's brief of correspondence in 2 volumes and the affidavit of evidence, my lord, that has been prepared and served upon the other side.
Yes. Witness present?
Yes, witness is present.
Yes, please the witness.
But here is the, may I hand it over? Evidence and affidavit. Now, before I put my witness to the box, my lord, may I tell you, lordship, one thing? A few documents are yet to be disclosed.
Yes.
Few documents are yet to be disclosed in the judge's brief of correspondence. My lord, the documents at the time of preparation of the documents, my lord, the plaint, my lord, though the documents were relied upon but not annexed with the plaint. My lord, subsequently it was found, my lord. I crave leave to file a supplementary judge's brief of document while I will rely upon. My lord, in the meantime, my lord, may I proceed with the witness action?
My lord, I also want to make one submission, my lord. There has been big latches on our part. My lord, there are 2 points which we intended to raise. Unfortunately, the junior who was appearing has also resigned, my lord. My lord, one thing is, my lord, there is a Supreme Court judgment and a division and a concurrent bench judgment which says, my lord, when an old suit is converted into a suit, there should be my lord, case management proceeding. That has not been done. That was not done. Consequently, WS was not filed. So we will take up this point. Now we are unable to resolve.
WS not filed.
No.
Well,
Defense has been stuck.
Huh?
Defense has been stuck.
Okay.
So this is a point we will take, my lord, either at some point of time. So I am leaving it up to your lordship, my lord.
No, in the when it was in the original division, you are not filed the written statement. Then after it was transferred,
No case management was held. So concurrent bench has held that when no case management is held, the time will be extended only after the.
Correct. When the case was transferred to this court.
But
my lord, the commercial suit specifically, this is not a transfer case, my lord.
Transfer.
No.
Huh?
We have instituted our place in the commercial division itself after the non-starter report. My lord, we have
commercial ছিল তো বোধহয় ডিভিশনে কমার্শিয়াল অরিজিনালি ইয়েতে ছিল
no, that's not the case. It is originally filed in the commercial
CS number is there.
Because no CS number, because prior to this 2023
it is a CS.
It is only a CS. Now it has nomenclature has been came only in the September to 2023 or 2024 something.
And now it is
when rule कब का दो?
Now it is CS.
Commercial court का rules जो है ना.
ও কমার্শিয়াল ডিভিশনেই ফাইল হয়েছে
suit was filed originally in the commercial division.
Only renumbered, not transferred.
Only
after we get the non-starter report from
and also then another things depends under 2 very similar things. One is there was a arbitration agreement. So section 8 application has not been taken out by us.
And the very first day you have to file.
And one more, they had themselves in their plaint. These are my faint attempts to save whatever is remaining, my lord. They have themselves in their না না আমি বল আগে নালে উইটনেস হয়ে গেলে মুশকিল না I just my lord ওটা কই প্লেনটা they have themselves my lord, I had shown this paragraph 64 তো হ্যাঁ 84 না 84 60
page 84
64 page 25 64 they have themselves stated my lord, this is a litigation between 2 governments. It is page 25
of the plaint.
Paragraph 60. What this I had pointed out to you.
Amicably settled to refer to the high power committee.
But there are some Supreme Court judgments which says that
that is optional, my lord. I have taken.
No, madam, it's my duty to point out these things. Whatever apprehension I have, because after this starts, I should not. Madam.
No,
That's all.
This you had appeared, you have not filed the written statement.
No.
So only you will cross-examine the witness. Okay.
I
solemnly affirm that
solemnly affirm that
whatever
in whatever
I will depose
I will depose
by way of evidence
by way of evidence in this suit, I shall
speak the truth
speak the truth
and no part of it
and no part of it
shall be false,
and I shall not
and I shall not conceal anything.
conceal anything.
Your name, sir?
Zulfikar Ansari. JULFIKR FIKAR ANSARI. Mohammad late Mohammad Jairuddin. MD Jairuddin. JAHIRUDDIN. Age 44 plus. Occupation.
Mr. Ray, what is your
I am working. Sorry.
Mr. Ray is having any matter?
I am a senior manager in Bridge and Roof Company India Limited.
Senior manager, Bridge and
Roof Company India Limited.
First aid. Residential address.
Village and Post Aradanga. Post Araidanga. ARAIDANGA. Aradanga Police Station Pukuria. Pukuria. District Malda. PIN number 732204.
Yes. Continue.
Mr. Ansari.
Yes, sir.
Are you acquainted with the facts of this case?
Yes,
and in what capacity?
I am posted there as a project manager, and I am looking after the job.
I am posted in the company as a project
manager,
and I am looking after the affairs of the
company.
Are you duly authorized?
Yes, sir.
To adduce आगे question टा सुने ना तारपर. Are you duly authorized and competent to depose and tender evidence on behalf of the plaintiff company?
Yes, my lord.
Affidavit.
Do you have any documents to show before your lordships in support of your authorizations?
Yes.
Kindly look at this. Is that the document you're referring to?
Yes, yes, my lord.
Shown what is that?
Malad, this is
Authorization.
the authorization.
No, what is that? The total.
affidavit of competence.
Shown the affidavit of competence wherein the authorization of the company
Of Bridge and Roof Company.
Plaintiff.
of the plaintiff company is enclosed therewith. Yes. What is this document?
This is, my lord, this is the authorization. Company give me the authorization to
This
proceed
is
with
the authorization given by the company to me.
Yes, sir. Yes, my lord.
Yes.
Is there any power of attorney?
Yes, ma'am.
Say that.
In the next page, this is the power of attorney, ma'am. Sir, my lord.
Yes.
Let it be exhibited. Let it be exhibited.
Power of attorney is original.
No, it is not original.
Authorization is original.
Authorization is original.
Show me. Who has given this authorization to you?
GM HR, sir.
Huh?
Our GM Human Resource.
This authorization has been given by me to me by General Manager Human Resource. Authorization is marked as Exhibit A.
Can you tell, my lord, the status of the company, the Bridge and Roof, the plaintiff company? Have you any knowledge about it?
Bridge and Roof Company India Limited is a Miniratna Category 1 company under Bridge and Roof Company India Limited is a Miniratna Category 1
Ratna Category 1 company.
Central Public Sector Enterprise undertaking working under Ministry of Heavy Industries.
Yes, next.
Do you know about the transactions which has been involved in the present case? Do you have any idea, knowledge about the transactions of the plaintiff's case?
Yes, my lord.
Kindly explain.
I was posted there as a.
Not necessary. You file the examination in chief. No?
I was posted there as a.
Not necessary.
Yes, next.
Mr. Ansari, who issued the tender and for what works?
Eastern Railway, dependent number 2, Eastern Railway issued the tenders.
For what works?
Construction of RCC minor bridge, major bridges, embankment work, PWA related to
Defendant number 2, Eastern Railway, he issued the tender work to the plaintiff for construction of minor bridge, major bridge,
retaining walls, PWA work, PWA, permanent way, permanent way work, embankment work, etc. from the section from Jangipur station to Iron station.
Yes.
I'm showing you a document.
You file the affidavit of evidence.
Affidavit of evidence.
Then you will not tender.
My lord, I shall tender, my lord. These are the original documents which
But you have to tender the affidavit of evidence.
Lordship. Very well. Show the affidavit. Kindly look at these documents. Just tell my lord what is this. This is the court page.
Evidence of affidavit of plaintiff's witness.
Have you gone through the contents of this affidavit?
Yes, my lord.
These are all true and correct?
True and correct.
At whose instructions such affidavits was drafted?
Under my instruction.
The documents that has relied upon in the evidence and affidavit, all the documents are in original are available with you?
Yes,
Can you
ma'am.
produce?
Yes, my lord.
Signature.
The signature appearing at the bottom of the last page. Page number 15.
One side.
The signature appearing in the page number 15.
Have you signed the affidavit of evidence?
Yes, my lord.
Is it yours?
It's my signature.
Let it be
Yes,
admitted.
next.
My lord, the original document may be tendered one by one.
Yes. Refer from the JBD. You have filed the JBD. Just we have document you have
That's
filed.
Lord,
Refer that document and place the original.
that's I am doing. This is the PDF one. This document. Kindly show that document. This is the tender document. PDF PD1.
PD1 page number?
Page number 12104.
12104.
104.
104.
You have just now deposed before your lordship that there is a tender issued by the defendant number 2. Is that the document is the tender document? I mean the documents.
Yes.
The
Yes.
tender document.
Tender document and agreement is the agreement.
Is the signature appearing unknown to you? The signature appearing in the bottom of the page 1.
Sir, this is not the way to adduce the evidence. Only you have to place the document and ask the question, what is this document? Then let the witness
I'm
answer.
one by one coming
Not
to
you
that.
put the answer from in the mouth of the witness from you. Only you put the what is this document?
This is the agreement, sir. Agreement and tender document.
This is the agreement along with the tender document. Yes.
Are the contents of the documents are known to you?
Yes, my lord.
If these are contents are true and correct?
How we can say?
My lord, he is the project manager.
Maybe, but it is issued by the government.
These are outside documents. Correct. Let it be exhibited, my lord. These are the tender documents. On the basis of these tender documents, they have proceeded with the work.
Who has issued this tender document?
Eastern Railway, sir.
Who?
Name
Who is
the
the
authority.
authority?
Chief Engineer Con 5.
Huh?
Chief Engineer Con 5, Eastern Railway, Kolkata.
Construction.
Construction 5.
Construction 5.
Eastern Railway.
Chief engineer. Chief engineer.
Agreement signed by.
At page 2, my lord, of the agreement.
Follow.
Yes.
Did the plaintiff participated in the tender?
Yes, my lord.
Let this document be exhibited as A and a B. B.
What was the work awarded to you? What is the name of the work awarded to you?
Construction of major and minor bridges along with platforms, embankment work, PUA work from
Along in this work order.
in
Where is the work order?
This is the tender document, my lord.
So tender document, how this is the no,
Agreement.
this, what you have shown, that is the memorandum. That is after the tender, the memorandum is to be signed by the parties. And containing that is the
It is an annexure, madam.
hmm,
Tender is the annexure.
you're not prepared.
153. Page number 153 of this document.
153 has not gone. This is only up to 105. 104 क्या हो रहा है?
उगलो है छोटा तो
एग्जामिनेशन चीफ दो. Yes, you are not shown. You have shown 101 to 104, but this contains so many pages. This document contains 155 pages.
in my copy also there is only because the agreement says well I would have taken it in cross examination but agreement says well the last is 155 possibly annexure C.
But in judge's brief document, you have shown only
104
104 is there.
104 well, kindly see page number typed page number 101 of 112 kindly see 104 of judge's brief.
Yes.
And then at bottom just underneath it page 101 of 112.
112.
So 102 is also not there.
You have not prepared the JBD accordingly.
Well, the annexures relied upon and the
No,
annexure annexed with
I
the
am
plain
telling.
document. The all original document contains much more document.
Nothing. What happens? Tender document is issued. First the tender notice, then tender document, then work order. So what they have done for their own benefit, they have prepared a paper book.
Make a paper book, and now they are trying.
This, as
This
per
has to
this,
be
155 has to come first. This is the tender notice. Then thereafter the work order. Then thereafter the agreement. It is not there.
They bind it up together, and it needs to be
And
documented.
the JBD, it is not in accordance with this. So it is very difficult to you lead the evidence.
That's true. It needs to be dismantled. That's why.
Whatever it is, man.
Copy original.
And you have to go by serially. First it will come the tender notice, then thereafter the work order, then thereafter the agreement.
Yes.
Then the performance guarantee, security deposit, then the.
Bind together.
So what can be done? Either you rectify the judge's brief document.
Lordship, that's true. Otherwise,
it will not difficulty. It is you cannot be you are not able to exhibit the documents.
I go by the plain, and accordingly things has been. But the original, when original comes and for their work
Original
purpose,
you have to. You can show, but now it has to be page number to tally with the
tally
judge's
with the
brief
judge's
document.
paper. But that's true. I need to rectify this one, and this document has to be dismantled accordingly.
Yes, but continue.
My lord, let me first rectify the things. And another thing,
kindly let my learned friend continue at least till 5 because I will object to all these documents.
What?
2, 3, 4, 5. Can you see the index of the judge's briefing? 2, 3, 4, 5. So if these are their timelines. These I will object whether these things can go in evidence at all. These are not documents.
Page number?
Page number 105, starting from 105.
105. Yes.
This they have made a compilation for understanding. Matlab, these cannot be marked as
That
documents.
can. That's why. That's I'm telling. That's why he's shown. So
Even these documents, matlab, from 2, 3, 4, 5. All these. One is detailed new items which are introduced. They have made a compilation.
Cannot.
These are just charts explaining the situation.
My lord, according to tender documents, my lord, we have prepared a timeline, and that was sent to them. Within this period, we are going to complete our project. That timeline was relied upon in the plain, my lord. And that's the admitted document. It's not that we have prepared the things.
Okay, if it's the objection, then we'll see to that.
Well,
You come with
and
it.
then
If you have objection, you raise objection, we'll see to that. Recorded.
And another thing is, my lord, few documents are left open. Left.
How you can introduce the few document?
My lord, these are all relied upon in the plain, but not annexed with the plain. My lord, I like to disclose, my lord, by way of judge's brief of correspondent, and these are admitted document. It's not that it's a current.
Know which documents.
You file an application.
Current bill, my lord.
Because as per the Commercial Court Act, you will not be able. This court will not allow unless you have to show the grounds why you are not disclosed the document at the time of filing of the suit.
No. At the time of filing of suit, my lord, plain things has been
Okay,
relied
disclose.
upon.
You disclose in an application.
Lords, I shall.
Consider plaintiff is present. Plaintiff has filed the examination in chief and judge's brief of document. Full stop. Plaintiff examination in chief has started, but during the examination in chief, it is found during the examination, one document is marked as Exhibit A. Further, it is found that the judge's brief of document prepared by the plaintiff is not correct and is having some discrepancies, and accordingly, learned counsel for the plaintiff prays for time to take appropriate steps to file the correct judge's brief document. In view of the submission made by the counsel for the plaintiff, the case is adjourned. First you file the judge's brief, then I.
Lord, I shall file the fresh judge's brief.
That's why you're
correct. Lord,
Let
that
the
liberty may be given.
Let the matter appear on 27th of August.
27th of August.
Not evidence. Let the file. First you file the
Lords,
document, then we'll see to that.
And I shall
For
come
filing
up with
judge's
the
brief
necessary
document.
application.
Yes, next.
Lord, I'm appearing for Sri Ramdut Pharaoh. My lord, Sri Ramdut Pharaoh.
Yes.
Appearing for, my lord, neither the plaintiff nor the defendant. I am
Ramdut Pharaoh. Yes.
Ramdut Pharaoh, my lord.
Yes.
Pursuant to the leave granted by your lordship, we have filed the affidavit, my lord.
And for
I'm filing
the defendant, your lord.
But I appear for the defendant, your lordship.
Read by Mr. Gupta on the virtual mode.
Yes. Who is for the plaintiff?
My lord will
No,
declare.
they are not appearing. Kindly dismiss it for default. That's my only defense, best defense I get.
Subir Banerjee. You filed affidavit?
I filed my affidavit. This is
We
regarding
had filed that
assessment of my
statement and our affidavit are ready.
What?
They had filed two applications, my lord.
Who?
The plaintiff.
Yes, you filed the affidavit.
Yes, they are ready. I'm fine. May I?
In both applications?
Yes, I have
You
served.
also filed in both.
My lord, I need not, because my lord, I was only interested in the property. My lord had given me limited.
So what
leave.
affidavit you filed?
My lord, attachment before judgment of one property they had sought. Regarding that property, we had already deposited 9 crores with the bank, who was the secured creditor. We have sought permission for WBDIC for transfer. That is under process, my lord. So we were saying that sum of money 9 crores.
So what you filed? What you filed
A
today?
small affidavit indicating all these facts.
Okay.
My only contention is that property may not be attached.
Then appears on behalf of the plaintiff. Yes.
Have been served with the affidavit in opposition. Have
you received the affidavit of the Ramdut Pharaoh? Have you served the copy?
Yes, ma'am.
So yes, what do you want?
But we need a week's time to file a replies, my lord.
Counsel for the defendant filed affidavit in opposition in connection with GA-Com 1 of 2025 and GA-Com 2 of 2025 after serving the copy to the London Council for the plaintiff. Let the same be kept with the record. London Council appearing for the Ramdut Ferro Private Limited filed affidavit after serving the copy to the London Council for the parties. Let the same be kept with the record. Counsel for the plaintiff pressed for time to file affidavit in reply to the affidavit in opposition in connection with GA-Com 1 of 2025 and GA-Com 2 of 2020. And with regard to that, you are also filed the affidavit.
Yes.
The counsel for the plaintiff also prayed for time to file affidavit in opposition to the affidavit filed by Ramdut Ferro Private Limited. Let affidavit be filed within 2 weeks.
Within 2 weeks.
Within 2 weeks. List the matter on 29th August.
With Mr. Gupta's leave, may I make one submission? Now, here I had to file my written statement. I had filed it on the 120th, subject to leave and subject to me moving an application. My application is also on board, which is GA3.
Where is GA3? Written statement hai?
Yeah, the written statement is annexed here, and I had mentioned the matter sought for leave.
Yes, what is that intent?
My lord, the writ of summons was served upon the defendant on 2nd of April, my lord.
2nd April.
My lord, we have the mode of service from the department, my lord, I can show. My lord, that is why the written statement is filed beyond the period of 120 days.
You filed the affidavit. Have you filed the affidavit?
My lord, we will file an affidavit.
The defendant has filed another application being GA-Com 3 of 2025, praying for extension of time to file written statement. Counsel for the plaintiff press for time to file affidavit in opposition. Let affidavit in opposition be filed within a week. Reply, if any, thereto be filed within a week thereafter. Let the matter appear on 29th. Hai na?
Obliged.
Take back.
Well, this could appear on any other day, this application, because
both come. Yes, next.
Lord, I am appearing for the defendant. Lord, as per my lord, leave granted on 31st of July. Lord, we have filed the written statement and counterclaim, my lord, and we have deposited the court fees. We have also served my learned friends.
I appear on behalf of the plaintiff, Your Lordship. It is there. Lordship, it was subject to payment of the court fees. I do not know when the court fees was given. My time to file any rejoinder to the counterclaim will start from that day.
My lord had granted me leave till 7th.
When you receive the written statement within 30 days?
Yes, written statement, my lord, within 120 days from the
within 120. Have you filed an application?
I had filed an application.
Where is the application?
My lord, it is listed today in
J1?
Yes, my lord. That is an application for extension of time.
To file written statement?
Yes, my lord.
Yes.
My lord, summons was received on 7th of April. My lord, entered appearance, my lord, on 5th of May. My lord,
7th April you received, on 5th of May you appeared?
Yes, my lord, before that. My lord, 6th of May, my lord, 30 days to file written statement, my lord, expired. And my lord, the 120 days was supposed to expire on 5th of August. In the meantime, my lord, I had prepared the written statement and counterclaim. I had come before your lordship. Leave was granted on 31st of my lord, July to file the written statement along with the counterclaim without the court fees, with the undertaking that the court fees will be paid by 7th of August, subject to acceptance by this court. That was done within the time.
Court is filed?
Yes, sir.
Kindly will record that my time to file any rejoinder to the counterclaim will start from that day.
That is from the
from the date of service, my lord, 5th of August was the last date we have filed it.
No. A receipt of notice. Acceptance of the written statement.
The written statement has been accepted
today. It will be accepted.
It has to be today. Your lordship's formal order is required.
Yes, sir.
Defendant, sole defendant?
Yes, sir.
No.
Yes, sole
Defendant has filed an application being GA-Com 1 of 2025, praying for extension of time to file written statement. Defendant says that the writ of summons was served on?
It was served Received summons on 7th of April, my lord.
Served on 7th of April 2025. And the advocate on record has filed the Vakalatnam on 5th of May 2025. 5th of May. After receipt of the writ of summons, the advocate on record of the defendant has informed the defendant to bring the documents so as to enable the non-advocate to file written statement, due to which time to file written statement within the 30 days was completed. He submits that though the defendant could not file the written statement within the period of 30 days, but has filed the written statement along with the contract claim within the order period of 120 days. He submits that on which date the court has given leave?
The 31st of July.
He submits that on 31st of July 2025, this court has granted leave to the defendant to file written statement in the department along with the contract claim, subject to acceptance by this court. Acceptance with the full stop. The police counsel for the plaintiff raised objection and submit that the defendant has not shown any cause as to why the defendant has not filed the written statement within the period of 30 days. And he filed the counterclaim along the written statement along with the counterclaim without paying the court fee. And as such, the written statement and the counterclaim should not be accepted. Had the learned counsel for the respective parties peruse the materials on record. This could find that the defendant has not filed the written statement within a period of 30 days, but has filed the written statement along with the counterclaim within the order period of 120 days. On 31st of July 2025, this court has granted leave to the petitioner to the defendant to file the written statement along with the counterclaim in the department. And this court also granted leave to the defendant to pay the court fee in respect of the counterclaim within a week from 31st of July 2020. It is informed that the court fee has also been paid with respect of the counterclaim. Considering the above, this court find that though the plaintiff and defendant has not filed the written statement within the period of 30 days, but has filed the written statement within a period of 120 days. Thus, one opportunity should be given to the defendant to file written statement. Accordingly, the department is directed to accept the written statement along with the counterclaim subject to scrutiny. And further, the defendant is directed to pay the cost of ₹2,000 to the High Court Legal Service Authority within a period of 1 week from date. Full stop. The defendant is directed to serve the copy of the written statement along with the counterclaim to the plaintiff.
Already served on 5th.
Counsel for the defendant submit that the written statement along with the counterclaim has already been served upon the defendant, but time to file the written statement to the time to file the additional written statement to the counterclaim is started from this day. Accordingly, that plaintiff is directed to file the written statement, additional written statement to the counterclaim within a period of 30 days from date.
As per the commercial code.
This is the matter on 10th of September 2020.
10th September.
No, 10th मत करो कितना है?
Deeply obliged.
15th September 2020.
15th September.
GA is disposed of. GA com 1 of 2022
Disposed of. Obliged. Deeply.
17, my lord, I appear for the defendant in the matter. But I am led by Mr. Shuddhashotta Banerjee, my lord. I am seeking an adjournment for
what?
My lord, I am the defendant, my lord. I filed GA3 seeking revocation of the leave under section 12A. My lord, taken by the plaintiff.
Revocation of leave?
Yes, my lord. That's GA number 3. Appearing for the first time.
I'm not going to use
You
any
will not file
affidavits in that,
affidavit.
no, my lord. On the last occasion also, my lord, I had said so. They were
Sir, may kindly, my lord, adjourn it, my lord. I am led by Mr. Shuddhashotta
My
Banerjee.
lord, the only problem is, my lord, may I just point out, I wouldn't have, my lord, but my dear lordship knows when I moved this application, it's one of those matters where, my lord, dear lordship has passed an injunction. on the ground that they have admitted to an extent of 99 lakhs. But my lord, after that, they came up and said that it has been sold off. Now, my lord, I'm asking for security, relying on Rahul Shah because there's an admission in 151, my lord. My lord, this is, I should be saying this.
Only 1
several
week's,
recurrences.
my lord, no,
Several
no,
recurrences.
that's not correct. My lord, may kindly have the last order.
And my lord, your lordship had also.
We have appeared every time we have not sought an adjournment.
And my lord, your
We've only
lordship
sought an
had-
extension.
Last
for-
day you are not appeared. 21st July you are not appeared. 11
that
July.
day, my lord, there was a difficulty, my lord, your lordship's request.
11 July you prayed for time.
But that was for the filing
11
of the
June.
affidavit. For filing of the affidavit. That was filed, my lord, in GA2. One and
When Mr. Banerjee will be available?
my lord, any day next week, my lord, any day, my lord.
I'll leave it, your lordship. And only once, my lord, may I just point out one more thing, my lord. I know there's no order to that effect, but your lordship, on the last occasion, my lord, when I moved the second application, I said, let them, at least this was the affidavit of assets. Your lordship then observed, but I wouldn't say your lordship passed on, that they will let them file it in the affidavit. If they don't, then you can ask for further. But if they can't
My
file,
lord,
my lord, that would
no, my lord, I'm
but that
praying
will
that
not
no order
be
be passed. My lord.
prejudicial to anyone. My lord, they can at least show something as to where, because my lord, they said they've taken 2 crores. Now that 2 crores I also don't know, my lord, after selling the property, which was supposed to be sold and given to me, my lord, the money.
There's
That
no
also
such-
I do not know where that is.
No such statement made, my lord. In the emails, in fact, my lord, the plaintiffs have disclosed 2 emails. My lord, 4th of February and 20th of March. My lord, no statement that we'll be paying them the entire money or even any admission. My lord, they rely on a scheme of compromise filed in the NCLT under section 230 of the Companies Act, where, my lord, my client has given an omnibus settlement, proposed a settlement of 20% to all its creditors. My lord, that is pending, my lord, adjudication before the NCLT. Now, my lord, if that order is passed, and my lord, that is to the knowledge of the plaintiff.
That is what
My lord,
they are
from
attempting.
4th of February, my lord, these discussions have been going on.
So I am sending it to the mediation.
My lord, no difficulty, my lord. That is our point, my lord, that my lord, already negotiations were going on and they were aware.
If I am sending it to the mediation, it will be
No difficulty,
within
my lord.
60
Absolutely, my lord.
I'll point out the tactics, well, I should be saying this, but
on the other
my
hand,
lord,
my lord,
they are basically wanting that the NCLT passes the order earlier than yours, your lordship.
so that go.
So that, my lord, they can just say that no, we pay 20%.
And it is
My
reserved
lord,
for
that
orders.
is why it is. That is why we are
that is-
before your lordship, my lord. That is
No.
why I objected to this.
my lord, that is not correct. My lord, under section 230 of the Companies Act. my
Okay,
lord,
when you
once-
will available?
no, next week, my lord, any day. Your lordship pleases, my lord.
Learned counsel for the defendant prays for time. For the interest of justice, case is adjourned. Let the matter appear on 19th August.
My lord, may I, my lord, sorry, my lord, 20th could it be, my lord? I'm not in town on the night.
20th August.
Grateful.
Interim order granted earlier is extended till 27th of August 2025 until further order.
And let them at least have the assets with them. They let them not fight.
On
Your lordship
20th,
will
my lord, on 20th, my lord, your lordship will consider, my lord. Kindly, my lord, my senior is not, my lord.
I
He's
understand.
leading me in the matter, my lord. That's why I'm praying that kindly, my lord, 20th, 1 week away. My lord, 1 week away. My lord, in 1 week.
Because of
And my
that,
lord, I'll only place this, my lord, in under the Companies Act. The NCLT first, my lord, goes through the scheme if it is contrary to law. Thereafter, my lord, the creditors have to meet. And my lord, I have to secure more than 70% votes.
So you do one thing. Before that, you secure some amount here.
My lord, kindly, my lord, consider.
Inform the.
My lord, consider it on the 20th. My lord.
Inform before the NCLT.
May
Yes, he
kindly
has
consider-
already secured the amount.
My lord, may kindly consider it on the.
Come on that day, I will
My lord,
otherwise
your
supply.
lordship ready to keep it at 2, my lord.
2, that is because time then September.
As your lordship please.
You want, I will give.
No,
the
my lord.
That is
I'm
the
in a
problem.
bit of a hurry, my lord, as your lordship.
No, my diary is to.
I understand, my lord.
Yes.
I would rather test my luck for this rather than wait for 20. Other matters I would have, but my lord, this is.
Okay. I will see to.
I'm grateful.
Next.
I'm here for the plaintiff, my lord. We have to file
I'm
my
for the
reply.
defendant bank.
Yes.
I have to file my reply, my lord, in
My lord,
compliance.
in the last occasion, opposition was fine. My
I've served this.
pleadings are complete. Pleadings are complete. My final fee.
Lord, one more
One
information.
thing, my lord. We have preferred one demerted application, my lord, and the application will
Not been
return
served
will-
to us yet.
No, my lord.
This is what
That
I
is served. That was served.
Served already.
Served already on. Not physically served on Friday.
Not served.
Friday.
Master, we have master some.
So, my lord, either way, she has served, my lord, I'm saying, my lord,
The
that both the
matter-
applications be heard together.
Had together and
You
tomorrow.
will not
my
file
lord.
any
The
reply?
application.
I will file opposition, but that application is not appearing.
What is this application?
This is
J1?
J1, my injunction application, which is appearing today. I am filing my reply.
Ah.
My lord, they are saying that tomorrow the matter is to come. Tomorrow their GA2 is to come, which is their Order 7 Rule 11. So I am saying, my lord, that let the matter appear tomorrow, my lord. We'll seek for directions.
Both the
And then-
application.
Come tomorrow.
Come tomorrow, my lord.
Okay.
That is written.
Let the matter appear. Not today.
Copy served,
Your
my
lordship, I
lord.
filed my reply.
Come.
Madam, we have the endorsement, my lord.
Okay, yeah.
Copy served.
Record an order.
That's for professional purposes.
The plaintiff has filed affidavit in reply in connection with GA.com 1 of 2025. After serving the copy to the Learned Counsel for the defendant, let the same be kept with the record. Learned Counsel for the defendant submitted the defendants filed another application being GA2, being GA.com 2 of 2025 for rejection of plaint, and it will be listed tomorrow. Let this matter be also placed in the list tomorrow. That is on 13th August 2020.
13th August. Extremely grateful.
Yes, next. Yes.
For the plaintiff, your lordships.
Yes.
Lord, this is my lord, our application my lord, under section 8 of my lord. This is my lord, that section 12A which my lord was not pleased my lord to
Section 8.
section 8. Only one thing, my lord, I was trying to, my lord, I needed a copy of the plaint, my lord. I don't know why, my lord, they're not
My lords,
giving us a copy of the plaint.
my lords, the scrutiny was carried out thereafter. The plaint was before your lordships for the judgment, your lordships. The plaint has to go down again to the master's room, your lordships, for writ of summons to be issued.
Whether you will accept the writ of summons, then I will pass an order. You will accept, then I will pass an order, serve the copy.
Because we have a section 8, my lord, there's an arbitration agreement. I just
Correct.
needed a copy of the plaint, my lord, to look at the plaint.
Correct.
Otherwise,
If you
my lord,
accept Section 8, if you accept the writ of summons, that will not prejudice your Section 8 application.
That's the, my lord, the difficult.
That will not prejudice. I will write that.
Time is over.
What time is over?
At must from filing of the claim.
Again, my lord, that is also, I don't know, my lord, whether the scrutiny, because of the scrutiny, because writ of summons also has to be served within 1 month.
No, Mr. Banerjee, is our department.
I know.
Nobody's followed that. If we ask the report also, they will say that it is pending for the scrutiny. Neither you nor the other side.
No, then can we, my lord, come back, my lord? I'll try and see, my lord, if I can get a copy of
problem.
it. Otherwise, then, my lord, we'll.
Give one copy.
Your lordships.
Give one copy.
Your lordships.
When?
To all
Today?
the defendants, Lord, appearing defendants, then they have to get a copy of the.
No, one copy, Mr. Banerjee. 8 who has filed an
We
application?
have filed, my lord, defendant number 1,
number
2 and 3 have
two.
filed.
Give the two. Who has filed? Huh?
I'm for one, my lord.
You're all together, so it's only me who's the outside.
Yeah, lordships, I'm led.
And it is submission, of course.
So who has filed the Section 8
Two and three,
application? Let the copy
2 and
given to him. Let the one copy be given.
Any day, my lord, next week, my lord, except 19, my lord, if it's possible.
As per the prayer made by the counsel for the parties, let the matter appear.
Your lordships, a time may be fixed for the hearing. Your lordships, our GA1 is pending. We are seeking an interim relief, your lordships.
First, I have to fail in section 8.
Your lordships may fix a time.
Section 8, you filed opposition?
We do not wish to file an
Do not file.
Oh, very well.
Let the matter appear on
Consequences, my lord.
25th.
I'm grateful. I'm grateful.
Next.
Lord, I appear for the petitioner. Well, I'm the defendant in the suit, my lord. Lord, the list is collapsed. I couldn't reach, my lord. Lord, it was my application that your lordship was hearing regarding amendment of the written statement.
Yes.
Well, I placed one judgment, my lord. The rest, my lord, I'll have to. May I come back any day convenient to your lordship, my lord?
Not today.
My lord, if it can be kept to, because I want to be physically present. The list collapsed. That's why, my lord, I couldn't reach on time.
As per prayer made by the counsel for the
I'm
defendant.
sure Mr. Karnani won't be opposing it. But I
Defendant.
had comments my submissions. I've already
Mr.
made it.
Karnani got the order today. So his purpose would be served. As per the prayer made by the counsel for the defendant, case is adjourned. Let the matter appear on 21st of August.
My lord,
Grateful, my lord.
can it be any day after 21st and 22nd?
Then 26th.
Yes, please.
पहले वाला मैटर कब रखा?
My lord,
26th.
in that 25th, your lordship kept that matter, my lord, when Mr. Banerjee appeared, my lord, for that
Yes,
section
yes,
8.
yes.
My lord, held the section 8 without having a copy of the plaint. They argued the 12A without copy of the plaint. My lord, kindly give an earlier date, my lord, because why, my lord, my GA1 and then the puja is approaching, my lord. One summer vacation went away. I couldn't get my GA1 heard because of these applications. Now the puja will go away and 19 crores they've taken away.
But now the other side left the court.
I'll give them notice, my lord, that I'll mention.
Come tomorrow by notice, then we'll see to that.
Please, man. Grateful. Deeply. I'm sorry, my lord. I was unwell. I couldn't.
Okay, no problem. Yes, next.
Grateful, my lord.
My lord, I appear for the petitioner, my lord, in this matter, my lord.
Well, the time for the respondent.
My lord, I was to, my lord, file a reply to the application filed, my lord, for summary judgment. My lord, my reply is ready, my lord. My lord,
as per my
a copy to my Mr. Lakmani.
Let us, my lord, consider this and come back.
Lordship has a 3 p.m. fixed matter as well. Very well, my lord fixes it any day convenient to the court.
12-6.
It's my lord order 13A.
13.
No defense. Here, my lord, this was a claim arising out of a consultancy agreement. So we, my lord, provided services. Claim is admitted in the sense when we go to NCLT, there's a terms of settlement filed. In that terms of settlement, they say this is the ultimately manner in which we are going to pay. Checks were given. One check, my lord, handed up. Thereafter, rest, my lord.
Mr. Lakmani will come.
I don't know, my lord, what defense he'll come up with, but
he will come something defense. Don't worry.
no, my lord. I'll file my reply affidavit to my lord GA. About the GA 2 of 2025.
Affidavit in reply filed by the plaintiff in connection with GA2 of 2025. Pick up with the record. Let the matter appear on 28th August.
Grateful, man.
Grateful.
28.
May it please your lordship, I'm appearing on behalf of the defendant number 1, the applicant in GA8 lordship. Mr. Pronit Bag was leading me in this matter. He was Mr. Pronit Bag. He was distinguished.
On the last occasion yesterday also, my lord, a time was sought for in this matter, despite my lord all urgency. Lord, I really do not know, my lord, whether today they'll be.
Lordship is just engaged in another courtroom, lordship. He's arguing in 37 right now. Lordship fixes the time, lordship will come back, lordship. This time we'll come back, lordship.
I will make a window so you can make the.
Once he completes, can we file? I have Mr. Mukherjee was leading me. I have short notes of arguments.
When you will be available? Tomorrow?
Lordship, either tomorrow or any day next week, lordship.
As per prayer made by the counsel for the defendant number 1 and applicant in GA 8 of 2023. Case is adjourned. Let the matter appear on 28th.
Lordship,
I'm
grateful.
I'm grateful. But I'll just give my evidence.
Yes.
Sorry, but I've been appearing for Mr. Ghosh's.
Record the appearance.
My lord, I'm appearing on behalf of the plaintiff in this matter.
Yes.
My lord, our argument was concluded. Mr. Devnath Ghosh was in reply.
Lord, he's not yet come. Maybe
not today.
Not this week, my lord.
Not this week. All will be next go to week. As per prayer made by the counsel for the defendant, let the matter appear on 20. Next.
Grateful, my lord.
Grateful, my lord.
Very good. I am opposing this application. He's asking me to agree to an order.
Will not actually indicate what is the application. I must, my lord, tell your lordship what the suit is for. Kindly have a look at.
What is the application for?
It's for disclosing one document.
Disclosing document.
3rd of February 2020.
GA2.
Yes, my lord, GA2.
Yes.
Please have a look at Annexure B.
Page.
This is at page 130.
Yes. 3rd February 2020.
Yes. Now, this is issued by State Bank of India to my client.
Yes.
This is how, my lord, we get our credit facilities. Because the relevance of this document will be, my lord, placed apropos the statement of truth. Because I am paying for leave after, my lord, filing my statement of truth, indicating that I have disclosed all documents in my possession and control. My lord, please have a look at.
So you are for the plaintiff.
I'm for the plaintiff.
Hmm.
Now, my lord, this is a suit. My lord, we participated in a tender process. And, my lord, we put in some money. Ultimately, my lord, it did not continue. And we wanted, my lord, a return of the money. We went before the writ court. Writ court, my lord, directed return of the money. Ultimately, by agreement, question as to interest, my lord, was left to be decided before the appropriate court. This, my lord, suit is for interest. Because they will not, respondents retained my money, MMTC, but they retained my money for a long time. They refunded the principal after the writ court order. Suit is for interest. Now, my lord, when we file the suit, we don't rely on the document of, my lord, credit facilities. This, my lord, we had advised in the course of conference while preparing for the litigation, for the trial. My matter is fixed for trial before your lordship. So we indicated that this would be necessary for proving the rate of interest, because loss you have to prove. And this is not really a matter which is connected with the transaction under reference. If your lordship sees what is the transaction under reference, tender process, I participate, I thereafter withdraw, and I become entitled to refund. This is the subject matter of the transaction between the parties.
Correct.
Now, ultimately, after the writ court order, I file a suit for not the interest. In course of conference, the client is advised by advocates that this is a further document to prove the rate of interest which may be necessary. So we have filed this application. But this is all, sir. I have nothing more.
So why you not filed the document?
Yes, my lord, it wasn't.
As per the amendment provisions, how
Yes.
the court can allow you?
No, lordship can allow. It's your lordship discretion. Not commercial court sec though.
Hey, commercial court act though.
My lord, it's if your lordship, I think order 18, no?
Order 11.
Order 11.
Amended portion.
Rule 5 na 6. I have given us statement of truth, and if it is not a document in possession, 15 would Commercial Courts Act ano na. I am very sorry, my lord, my.
No. Kindly come to the 11.5.
Yes.
11.5.
It's not that it is not permitted, it is frowned upon.
11.5.
Pages.
Plaintiff shall not be allowed to rely the document which were in plaintiff's power, possession, control or custody and not disclose along with the plaintiff or within the extended time period set out above. That is the clause 4.
Yes. Relating
Save
to
and
the
accept
present matter. It's not an absolute part.
No. Save and accept by the leave of the court, and as such a leave shall be granted only upon the plaintiff establishing reasonable cause for non-disclosure. What is the reasonable cause?
The reasonable cause was this could not be anticipated by Millard the advocate's preparing.
Because you're
The
claiming
reasonable cause is a notch lower than sufficient cause.
correct.
Millard, sufficient cause is Millard what your lordship see for condonation of delay, restoration, etc. That's Millard, that's on a higher pedestal. This is, it must be reasonable. Now, it's not all documents, it's one document. Millard, in the course of conference, for the purpose of Millard taking witness to the court, it may be that one document has been missed out. Otherwise, Millard, there is diligence. I'm not asking for 100 documents. I am Millard praying for leave to put in one document to prove loss. It's not so unreasonable, Millard, that one document cannot be missed out.
Yes.
Well, it kindly takes the application, my lord, and comes to my lord paragraph 5.
Yes.
The said document dated 3rd February 2020 came up in course of discussions in conferences held by senior advocate. So, my lord, the document was there. My lord, if this document was there, then the statement of truth is incorrect. My lord, kindly takes the plaint. My lord, the plaint is annexed. Kindly comes to page just after the verification 39 of the same application. Page 40, paragraph, my lord, 4 and 5.
Yes.
And this is as per the, my lord, provisions of the, my lord, Act.
Yes.
Code. Para 4, my lord, page 40 at the top. I say there is no false statement or concealment of any material fact, document or record. And I have included information that is according to me relevant for the present plaint. I say that all documents in my power, position, control, custody pertaining to the facts and circumstances of the proceeding initiated by me have been disclosed. Copies of the same have been filed before this court, and I do not have any other material document in my power, position, control or custody. Today, allowing this application would mean, my lord, the foundation in the plaint to claim interest is being, my lord, modified or amended without there being a formal amendment application. That is not permissible in law. That's considered by our High Court. My lord, Supreme Court has also considered. Your lordship has also, my lord, rendered a, my lord, judgment on this aspect. I'm carrying the judgments, my lord. The only, my lord,
can never be, my lord, the
kindly now comes to the
it can never be the interpretation.
Come to yes.
My lord, kindly comes to page 130. He is still not disclosing the entirety of the documents.
Yes.
My lord, his is a claim of interest. My lord, he wishes to rely on a document of 3rd February 2020, which is, my lord, issued pursuant to their letter. Kindly see the first letter, first para, with reference to your request letter dated 19 December 2019. They don't disclose that. This is, my lord, prior to, my lord, this suit being instituted. It is not a document, my lord, which it cannot be said that they didn't have this document.
Yes.
Now, my lord, the explanation in the reply kindly takes the explanation in the reply, affidavit in reply. Kindly comes to paragraph 5. Supreme Court of or Purti Tower. Purti. My lord, para 5 is page 3 of the, my lord, affidavit in reply.
Yeah, affidavit reply का है?
Reply তোমার ফাইলে আছে?
I replied
Yes. Yeah.
ওই যেগুলো অরিজিৎদার কাছে নিয়ে যাচ্ছিস তো সেগুলোই দেখাবি তো
না my lord,
we are arguing the same point before the division bench.
But my judgment, my order is also there.
But we did the matter before the learned commercial court at Barashat. Then he didn't cite my lord Rajarat. He did not cite my lord's judgment.
That's not a ground for my lord allowing the application. My lord, kindly comes to paragraph 5. My lord, leaving, my lord, the first 7-8 lines, sentence starting with I say that.
Yes.
Till the conference held with the senior advocate and advocate for the purpose of preparation for trial, relevancy of the document dated such and such in connection of the present suit was not appreciated. My lord, if this is a ground, And if this is allowed, my lord, tomorrow, my lord, lordship will be, my lord, facing with similar, my lord, Order 11, Rule 1 applications, and lordship will have no other, my lord, option but to allow all these applications, my lord, permitting the parties to disclose documents. That is exactly what was reprimanded. Kindly now takes, my lord, the Supreme Court decision in, my lord, Sudhir Kumar, my lord, matter. Lordship had considered this judgment. Well, so I am not multiplying. Paragraphs 9 and 10, lordship kindly comes. Uh, 9.3, Order 11, Rule 1 is quoted at page 79 of the, my lord, judgment.
9.5 is
9.5. Order 11, Rule 1.5 further provides that plaintiff shall not be allowed to rely on documents which were in the plaintiff's power, possession, control, or custody and not disclosed along with plaint or within the extended period set out above, save and except by leave of court. Such leave shall be granted only upon the plaintiff establishing reasonable cause for non-disclosure along with plaint. My lord, relevancy or appreciation by one of the advocates regarding the, my lord, relevancy of the document at the stage of trial cannot be a ground, my lord, to allow after, my lord, instituting the suit in 2022, in 2025 to allow this, my lord, document to come in. Therefore, on combined reading of Order 11, Rule 1.4 read with Order 11, Rule 1.5, it emerges that in case of urgent filings, plaintiff may seek to rely on additional documents within 30 days of filing suit, making out a reasonable cause for non-disclosure along with the plaint. The 9.6, my lord, deals with the further 30-day period in case of urgent filing. Then para 10, having considered the statutory provisions in detail, the order passed by the Commercial Court confirmed by the High Court rejecting the application of the plaintiff for leave to rely on additional documents is required to be tested and considered. Then, my lord, kindly comes to 10.3. Even the reason given by the learned Commercial Court that invoices being suspicious and therefore not granting leave to produce this invoice same cannot be accepted. At the stage of granting leave to place on record additional documents, court is not required to consider genuineness of the documents, the stage at which genuineness of documents to be considered during trial and or even at the stage of deciding the application under Order 39, Rule 1, that too while considering prima facie case. Therefore, Commercial Court ought to have granted leave to rely on invoices. This was on suspicious documents. Then, my lord, kindly comes to 10.4, the other set of documents which they wanted to rely. So far as other documents ought to be relied on produced as additional documents other than invoices are concerned, the same stands on different footing. It is not disputed, and in fact, it was specifically admitted and so stated in the application that the additional documents other than the invoices were in their possession but not produced, being voluminous. My lord, here also it is there in their possession but not produced. However, it is to be noted that when the second suit was filed, it cannot be said to be urgent filing, as the first suit was filed in October 18 and there was an ex parte ad interim injunction with the order of October 18. Thereafter, plaintiff withdrew the suit on 27 July 2019 with liberty to file a fresh suit as per Commercial Courts Act. And this second suit came to be
yes,
filed.
you do want to give the copy to Mr.
Very well. I have two more judgments.
I'll delete it right now.
Other fixed matter.
Oh. My lord, permits me to come day after tomorrow, my lord. I'll give Mr. Chaudhary the judgments and I'll finish in 5 minutes.
When?
Tuesday. Then Monday, my lord. I think he's not there, my lord.
Tuesday on 19?
Yes.
As per your choice.
Long weekend coming up, Mr.
No, I am here, my lord, but
that's why I'm done.
After I am actually rest of August, I'm in till 27th, 28th, I'm in grave difficulty, my lord. My learned friend will do.
Second September. As per the prayer made by the counsel for the plaintiff, case adjourned, let the matter appear on 2nd September.
I really want to argue this. It's not that if your lordship accepts my learned friend's argument, then in no commercial suit can your lordship grant any.
No, that's why I am doing this. I am not allowing any of the persons.
Even confronting lordship is not allowing.
I am not allowing.
Lord, may I have
my lord those judgments.
Lord, may I have an opportunity to try to have my lord change my lord's mind?
That would mean, my lord, heads I win, tails he loses.
No problem.
No, my lord, it's not like that. I submit, my lord, it's not like that.
I welcome
not-
you. Please change.
Yes, I want to.
So then thereafter the lots of application will come for additional.
I'm quite confident I'll be able to, my lord, convince your lordship.
Come.
But my only thing, rider, is it's not for the asking. If it's, my lord, little bit of leeway, your lordship can grant. Otherwise, this is, my lord, an adaptation of the red fund procedure. Even the red fund procedure permits.
That's the Sudhir Kumar consider. Let you consider.
And my learned friend's arguments, I have, my lord, I respect my learned friend for making such an argument, but if your lordship sees his argument, he says there's a statement of truth. Now, if you allow, that means your statement of truth is false.
Not that. That's why
then you can never allow.
That's why the Supreme Court stated that in the statement of truth, this has been
My lord,
given.
statement of truth has been, my lord, found to be a part of the pleading.
If you're not able to file the document, you take the leave for the 30 days.
But even then, my lord, the same provision says, which my learned friend is not stressing on, and rightly so, that save if I can come and show reasonable cause.
That's why reasonable
merit
cause
also,
has to
it's not reasonable.
That's why what is the reasonable
What
cause?
is reasonable? That is the question.
What is the reasonable cause?
Absolutely. I'm going to say, my lord, that reasonable cause is a plausible cause. Some cause. Not even
What is the
sufficient
reasonable cause? Yes. What is the reasonable
My lord,
cause?
in our judicial system, 5 years after, my lord, if the trial commences, somebody says that senior counsel advised.
Okay. Let it come on
Okay.
second. We'll see to that.
Yes. Great.
Yes. Now call the fixed matter.
Takes up this matter, my lord.
No. Fixed matter. Yes.
Next item, Lord, so I'm praying for not today.
Okay. No. It will not be taken. Yes.
My lord,
I am telling it will not be taken. Come tomorrow.
Lord.
Yes. Call the matter.
Dear.
Yes.
Lordship, on the last occasion, we had started
Yes.
our argument.
Lord, I have filed an application also praying for testifying the handwriting before the handwriting expert. That is GA number 9. So I am praying before Lordship to dispose of that application first.
My lord, that application, in my respectful submission, cannot be filed at this stage, my lord.
It can be filed at any stage. And in this respect, I am relying upon a judgment passed by the Honorable Supreme Court of India. I am handing over the judgment to your
My
Lordship.
lord, your lordship will take up 13 January 2025 order, my lord. My learned friend has finished his argument and he was directed to file written notes, which he has already done. And my argument we have started our argument.
Correct.
At this juncture, my learned friend comes up with an application in a suit for final hearing after completing his argument.
At any stage. I'm relying upon the judgment. in
Okay,
this
you have
regard.
filed the application. And I will take. Let the argument complete.
Lordship.
Now, my lord, this is an application for grant of probate of a will of the testator, wherein the
Kindly, just a minute. Kindly go to the order dated 28th of March.
Yes. It is there.
Then, considering the above, this court is of the view the application filed by the defendant being GA9 can be taken up for final hearing at the time of final disposal of the suit. Yes.
That is
My lord, this is an application for grant of probate, wherein the propounder had come to the box and she was examined and cross-examined. Thereafter, my lord, the added defendant, before that, my lord, the attesting witnesses had come before this court and given evidence. They were also cross-examined by my learned friend. And thereafter, my lord, the added defendant was also given an opportunity to give evidence, and she gave her evidence in chief as well as she was also crossed. Added or substituted.
Yes.
Now, the caveator was the husband of the
present defendant who had expired. And thereafter, she was substituted in place instead of the caveator. Now, in a probate proceeding, what are the basic requirements?
Who is the caveator?
Caveator is the son.
Son.
And the son has expired, and in his place, his wife has been added as a party in the
That he expired before the evidence or after the evidence?
Before the evidence.
So the caveatrix, this wife has led the evidence?
Yes.
Yes.
Well, she was added pursuant to your lordship's order dated 8th of July 2022. Well, in a probate proceeding, in order to prove a will, well, what are the salient features which a court has to take into consideration? First point, my lord, the testamentary capacity of the testator. The second, my lord, the testamentary character of the instrument. What kind of an instrument it is. Thirdly, my lord, the knowledge and approval of the testator.
Yes.
Fourth, absence, I have to prove absence of undue influence and coercion.
Yes.
And fifth, due execution of the will and attestation, which has to be proved by the attesting witnesses who had put in their signature as the attesting witnesses. My lord. My lord, in this case, my lord, the testator was a retired judge of this honorable court, my lord. He died on 22nd of September 2011 in USA. My lord, the last will of the testator is dated 29th of February 2008.
29th February.
29th February 2008. My lord, in his will, the executrix of the said will were jointly his wife and his daughter. My lord, he had two, but he was married to one Sneholata Sengupta, who had died at the time of giving birth to her son, and thereafter he again remarried, and he had a daughter by his second wife. The son from his first marriage did not have good relationship with the testator. He had led a wayward life, and he was disowned by his father.
Yes.
In the will itself, it has been stated, my lord.
Yes.
My lord, the said will were attested by two attestating witnesses, my lord, who are practicing in this honorable court. They have come to the box, given their evidence, and proved that they were present at the time of the execution of the will.
Yes.
They were cross-examined thoroughly by my learned friend, my lord. In spite of that, the proof of their signature has been established. I'll bring your lordship to that. Now, my lord, the ground taken by my learned friend's client in the written statement, my lord, if your lordship takes up the written statement once. If your lordship comes to paragraph 6 first one, may I please thee? It would be pertinent to mention here that at no material point of time, the sad news of the death of my beloved father was ever communicated to me by any of the present executrix and the so-called present will in question, for which the illegal and motivated granting of probate is now sought for by this honorable court. Therefore, there are cogent grounds for not to grant any kind of probate and or letter of administration as sought for by the present executrix of that purported will in question as per provisions of law as laid down under the Indian Succession Act. Now, my lord, your lordship will take up paragraph 9, which is at page 4, my lord, where the grounds for challenge of the will has been laid down, my lord. If I may place the relevant paragraphs, my lord, be that as it may, I do hereby most humbly and respectfully state and submit before your lordships that the entire will in question is absolutely vague, untrue, false, forged, and fabricated from its very first line to its very last line. The signatures as well as the initials as depicted on the face of the so-called will are also absolutely false and forged. The so-called will in question also does not include the details of other various properties duly owned by my deceased beloved father. The late Ajit such and such, who was none other than a retired man, your lordship can skip this. The manner or the language in which the so-called will has been drawn up cannot be that of an eminent retired High Court judge. Next paragraph, my lord. That the so-called purported will is very, very much motivated, malafide, manufactured, purported, and concocted from its very sum and substances. The purported will in question does not bear the signature or the authentication of the person who had drafted, typed, and explained the same to the testator as required under the statute. Now pausing here for a moment. In these 3 paragraphs, what is the ground taken by my learned friend? First is, it is vague, false, untrue, fabricated, forged. The signatures appearing in the will are not the signature of the testator, and it has not been authenticated. And the final point, my lord, or the authentication of the person who had drafted, typed, and or explained the same to a testator as required under the statute. But it is not required that a person who is himself writing it, it has to be explained to him. Well, this is one part. The second limb of his objection, your lordship will take up paragraph 12. That the testator was an aged person suffering from various ailments and senility and was not in a sound state of mind and body, and moreover was fully dependent upon his wife, and my prolonged absence from home had given them the absolute liberty and opportunity to contrive against me and fulfill their sweet desire by putting undue influence, pressure, and coercion on the testator. Now, I'm pausing here for a moment. My learned friend has to either choose the first limb of his objection or the second part. Both cannot be taken up together. If it is a forged document, it cannot be a document obtained by way of coercion and undue influence.
Yes.
It has to be either of the one. Now, my lord, in the event my learned friend takes up the first limb of his objection, relies on that, then it is his duty to prove before this court that the signatures appearing in the document are forged and does not belong to either to the testator or any of the attesting witnesses, as has been stated by the plaintiff, my lord. And if he is taking up the second limb of his objection, he has to give a go-by to the first limb. Then he has to prove before this court that the testator was in a condition, and as such he was not physically as well as mentally fit to make and
execute the
publish the will. Now, my lord, before moving on to the evidence which has been put on record by the plaintiff, I would just like to hurriedly go through the will. Your lordship will see it is the annexure A to the application, my lord. আমারটাতে পাওয়া যাচ্ছে না, আমি খুঁজে পেয়ে বসে থাক।
Yes.
Now, my lord, the first paragraph I am skipping. I have been anxious to make necessary arrangement in respect of my properties and assets, as also other belongings. I am executing this will and testament of mine out of free will, voluntarily, without any compulsion or pressure of any person, with a sound disposing mind, and bequeathing as follows. I give, devise, and bequeath my absolute right, title, and interest in respect of all the properties, including property situate at being flat number such and such, Oroville Cooperative Housing Society at Mandeville Garden, and my property at Ashoknagar, including the convenient enjoyment of all rights and easements thereof, and all my assets, both movable and immovable, as also my other personal articles, belongings, and effects to my wife Srimati such and such, and who will be solely entitled to enjoy the same during her life, with full and absolute power of disposal and alienation, and after her death, my daughter such and such will be entitled to hold and enjoy the same with full and absolute power of disposal and alienation. The second paragraph, first paragraph in page 2, I am skipping. The relevant part which I want to show you, Lordship Malan. I have one son, namely Snehojit, by my first wife, Sneha Sengupta, who passed away at the time of giving birth to my son. With great difficulty and lots of hope, my wife Tapati and myself brought up my son Snehojit and put him in renowned schools for by spending enormous money and taking good care of him. Unfortunately, my son became a drug addict and chose a wrong path, which caused immense disturbance, pain, and distress to us throughout our life. My son has always been disloyal and inimical to us, despite the fact we had taken care of him. It was disgraceful that my son had even gone to the extent of issuing disparaging and harmful press statement against me in the past, and spread ill will against me amongst our relative and friends, which caused untold mental suffering and pain to us and created lot of mistrust and strained relationship. Finally, he deserted us altogether. We have no connection with him whatsoever for more than the last 15 years or so. I have therefore decided to disown and disinherit him. Accordingly, my son Snehojit shall not be entitled to inherit any share of my aforesaid property or otherwise. Now, my lord, your lordship will turn to page 3, where the signature of the testator is there, along with 2 other signatures of the attesting witnesses. My lord, both the persons are
Examine.
practicing advocates of this honorable court. My lord, you have come to the box and gave evidence. Now, my lord, your lordship will take up the evidence given by the propounder. The evidence is in chief is very short, my lord. I will go through the entirety of it. My lord, it will be in the report of the commissioner.
Yes.
Your Lordship had got it? The first examination in chief of the propounder, my lord, Tapati Sengupta.
Yes.
My lord, the first answer, I am the applicant. How are you connected to the testator? He is my late husband. You are the only executor of this probate. No, my daughter Angona Sengupta is one of the executrix. Has the probate application been filed by both of you? No, I am the applicant. Did you obtain no objection from the other executrix? Yes, she had already submitted an affidavit giving her permission. Is this the affidavit you have talked about, my lord? The affidavit of Angona Sengupta giving no objection is annexed to the plaint, my lord. Yes, that is so. Can you identify the signature? Yes. My lord, the signature of Angona Sengupta is marked as Exhibit A. Now, my lord, can you indicate from this affidavit the paragraph where no objection? My lord, it is not necessary. When did the testator expire? Especially on 22nd of September 2011. Was his physical and mental health condition, what was his physical and mental health condition like before his death? He was totally hale and hearty before his death. He passed away due to cardiac arrest. Where did the testator expire? In USA, Connecticut. Were you aware of the will of the testator? Actually, I came to know it when I came back to India. Before that, I had no knowledge. When I came back from USA after my husband's death, one Mr. U.S. Menon, learned advocate, handed over me this will and told me this is my husband's will. My lord, my specific case was that I was unaware. The will was in the custody of one Mr. U.S. Menon, and after his death, when I came back to Kolkata, my lord, I was handed over that will by Mr. Menon. Mr. Menon has also come to this box. He was subpoenaed by a subpoena was issued in his name by my learned friend, and he was thoroughly cross-examined by my learned friend on this issue, my lord. What did you do after you came to know about this will? I asked Mr. Menon what I was supposed to do, and afterward I contacted my advocate and requested him to file a probate petition. I am showing you a document. Please indicate if this is the document you have been talking about. Yes, that is so. This is the document I was talking about. Please take a look at this document and indicate whose signature is there as a testator. This is my husband's signature. The document bears his signature along with his initials on each and every page of the document, my lord. It is a 3-pager document, my lord. On each of the first and the second page, initials of the testator is there. Can you please encircle the signature in red? My lord, it has been encircled by the witness. How are you aware of the signature of the testator? This is my husband's signature. I have several times seen his signature. When he used to write a letter to me when I was abroad, then I saw his signature. I saw his signature on checks, legal documents of clients, and papers which are in his chamber. Is there any other signature reflected in this document? Altogether, 2 other signatures. Do you know the persons who have signed? Yes, I know them. They are Gautam Mitra and Shuren Dubey. Are you aware of the contents of this document? Yes, I am. Are the contents of this document true and correct? Yes, it is true and correct, tendered and marked as Exhibit C. Please indicate what you have prayed for in the instant application. I prayed for grant of probate of the last will and testament of my deceased husband. Question number 25. Do you recall the date of the will? 29 February 2008. When did the testator retire from his service? in the year 1996. What was the condition of his health in 2008? He was having a very good health. He used to do many arbitrations, consultations, and I think he also had an idea to write a book on the subject, and his memory was just like computerized one. What was the condition of his mental health in 2008? It was very good. Was the probate application objected to? Yes, that is why we are here. Who has objected to the grant of grant of probate? My husband's late son from his first late wife. Now, my lord, this is the examination in chief led by the propounder, my lord. Now, she was cross-examined by the defendant. My lord, before going into the cross-examination, one thing I would like to indicate to your lordship, my lord, the substituted defendant had adopted the affidavit in support of caveat filed by her late husband. My lord, no addition or amendment was made to that. Now, my lord, the cross-examination, which I would like to take your lordship through, is firstly, my lord, your lordship will take up question number 76 and 77. My lord, it is there in the commissioner's report, my lord.
ठीक है इसका
Commissioner report.
only this one is there.
Well, there is a bunch.
Only this bunch is.
Yes, what okay.
Yes.
Now, my lord, the propounder, while giving evidence in chief, had deposed before this honorable court that the signature on the will was her husband's. She has also deposed that she knew the signature of her husband. Secondly, my lord, she has also deposed on oath that her husband was in very good mental and physical condition, as he was constantly doing consultation, arbitration, and taking steps for writing a book, my lord. So, two aspects. The owners had shifted to the defendant to prove wrong. One, that the signature on the will was not that of the testator, and secondly, that the testator was not in good physical and mental condition to execute the will. Now, my lord, the first question relating to the signatures of the testator, my lord, will appear at question number 76 and 77, my lord. My lord, page 51 of the...
Yes.
Shown the front page and third page of the will, you will find there are two handwritten dates. Is there any initial by Justice Shengupta against this handwriting? Yes, initials are there. 77, beside the line in which the handwritten date surfaced, is there any initial of Justice Shengupta? No, there is an initial at the bottom of the entire page.
Yes.
Now, my lord, your lordship will take up question number 125.
Question number
125. Page 59 of the Commissioner's report, my lord.
Yes.
In shown the will once again. In these 3 pages of the will, 7 except the last page, that is, in the first 2 pages, Justice Sengupta had put his initials at the bottom of the page. But I am showing you the certified copy of a sale deed, wherein case of correction, Justice Sengupta has put his full signature. What do you say to that in this respect? My lord, the answer is, I don't know what he would do. This is up to Justice Sengupta. My lord, pausing here for a moment, my lord. If your lordship takes a look at the question itself, there is an admission that the initials of the testator are there in the document. They have not said that alleged signature or purported signature. Nothing of that sort. It is admitted that the initials on the will are by the testator himself. The question put to the witness was regarding whether it should be initial or whether it should be the full signature or on which position it should be made. Now, the next question I would like to refer is question number 166, my lord. Page 65, my lord.
Yes.
You have just deposed that all these signatures are of Mr. Justice Sengupta, and all these signatures are tallying with each other. But in none of the occasions you were present at the venue. Then Justice Sengupta had put his signature in this document. Is it correct? Yes, that is so.
Yes.
I have missed one question.
That's why, madam, it's called this cross-examination is an art.
I found out. And at question number 163. Shown the will once again, the signature of Justice such and such, are you 100% sure that this is the very signature of Justice Sengupta? Yes, it is Justice Sengupta's signature. My lord, subject to correction by my learned friend, there is not one single suggestion given by my learned friend that this evidence given by the propounder in respect of the signature of the testator is false,
It is not the
untrue,
signature of the testator.
or incorrect. Not one suggestion.
Okay.
These are all technicalities. Using the word purported or alleged, using or not using the word, it doesn't mean that I have admitted it.
Okay.
Entire thing.
Let the argue. Let her.
From the
Let's
very
see argue.
beginning,
Let's see argue on their her way.
My lord, this is in respect of the issue of the witness of the testator, my lord. Now the signature of the attesting witnesses, my lord. The attesting witnesses had come to box. They had deposed. Apart from that, the propounder was also asked. My lord, in question number 19 to question number 20, my lord, I have already placed before your lordship, my lord, the signatures of the attesting witnesses were identified by the propounder.
What is the evidence of the attesting witnesses?
My lord?
What are the evidence of the attesting witnesses?
They had come to box. They have stated that. I'll come. I have to show your lordship the entirety of it. Now, mind the questions relating to the attesting witnesses, your lordship will take up question number 78. Attesting witness Question 78. Lordship of page 51. Do you know the attesting witnesses of this will? Yes. Mr. Gautam Mitra and Mr. Shuren Dubey. Do you have any family relation with these two attesting witnesses? No. Do you know them personally? Yes, I know them because they are also in the legal profession and I am also in the field of legal education. So we have met in functions and other places. Were they your students? No. Now, Lord, the next question I would like to refer is 117, my Lord. Shown page 3, my Lord, page 57.
Yes.
Shown page 3 of the will and the signatures of the attesting witnesses. My Lord, this is the question put to the propounder during her cross-examination, my Lord. The attesting witness number 2, Mr. Shurendra Dubey, has described his designation as well as his address, but attesting witness number 1, Mr. Sachins, has neither disclosed his designation nor his address. What do you say to that? I don't know why he did not disclose his address and designation. Are you sure that this Mr. Gautam Kumar Mitra is the same Gautam Kumar Mitra about who you are talking? I cannot follow your question. I want to mean that on the last occasion you have said that Mr. Gautam Mitra is a person from legal fraternity, but here it is written as Gautam Kumar Mitra. Are you sure that this Gautam Mitra and Gautam Kumar Mitra whom you have talked about in the last occasion are one and same? Yes, that is so. Now, my Lord, your Lordship will come straight to question numbers 170. Page 66. When you have gone through the will, you have also gone through the signatures of the attesting witnesses? Yes. At that very moment, have you recognized the signatures of the attesting witnesses? I have seen their signatures. At that point of time, did you know the attesting witnesses? Yes. So it means you knew the attesting witnesses well before the date of handing over the will to you. Yes, I knew them. Thereafter, when the attesting witnesses sworn in this affidavit, who has approached them? Whether have you approached them to swear the affidavit? Yes. Have the attesting witnesses sworn in their respective affidavits under your instruction? Yes. Did they voluntarily swear the affidavit? Yes. But you have just told us that they have sworn in this affidavit under your instruction. I requested them to do and they did it voluntarily. Now, my Lord, there are various questions put by my learned friend to the propounder in respect of properties which are beyond the scope of this will.
Yes.
Several questions. She has been called upon to produce the documents in respect of immovable properties which are not subject matter of the will, which she has said that since they are beyond the scope and purview of this proceeding, she will not produce, my lord. I will come to those later on, my lord. But before that, since your lordship called upon, wanted to look at the evidence of the attesting witnesses, my lord, your lordship will take up the evidence given by Mr. Shurendra Dev Dubey, my lord.
Yes.
My lord, dated 11th of August 2023, my lord.
Is the PW2? Not written, okay.
My lord, I think he is PW3. The first evidence was given by the other attesting witness.
Matter hai? 345.
No, no, don't anyway.
Next.
My lord, I will beseech your lordship to give a short date, my lord. Very small matter, my lord. Given 1 hour's time, I will complete.
Counsel for the plaintiff has argued the matter at length, but due to paucity of time, hearing could not be completed. The matter. कोई adjourn matter नहीं है ना? कोई adjourn matter नहीं है ना? Problem is that there is no scope in my diary. Hey, come here. September. Second September 3:45. Or
কাল দিলে কালই করে দেবো।
10 and 11 September 12:30. That I can.
Deeply obliged one.
10 and 11 September 12:30.
Lord, may I more respectfully submit to your lordship that the propounder was the principal of South Calcutta Law College. Though I was not the student of that college, I was student of another law college, Srinath Law College at the same time. But I used to visit that college very frequently. I have made that propounder several times, quite a few number of times. So putting such type of suggestions in front of her face, that you are giving false evidence before this commission, I have devoured myself making such type of suggestion.
Okay.
After all, he was a principal. He was our principal, maybe.
Okay.
So for the sake of this argument, so making such type of
Yes, call them
suggestion, grateful to lordship.
But I appear for the defendants. I was midstream of my argument. Your lordship, in this matter, the plaintiff has alleged that the husband of the defendant number 1, my lord, had siphoned off monies
that one
of the bank account. Your lordship may remember.
Yes.
And on 12th of September 2024, my lord has passed an order in giving them all the injunctions that they want. Well, I have made my submissions in detail on the facts. I was on the law.
Yes.
So if I just to remind my lord, if my lord takes section 60 once of the, because some of the injunction and the movable properties mentioned in the schedule include a list of policies, life insurance policies. Now those life insurance policies, some I have got the money, some I have not got the money. But section 60 of the CPC, my lord,
yes,
provides the 60 subsection 1 provides which are the properties that can be attached, and if my lord comes to the proviso, if I may read from provided the following particulars shall not be liable to such attachment or sale, namely, if my lord comes to KB, all monies payable under a policy of insurance on the life of the judgment debtor. So assuming, my lord, the allegation is that the deceased is the person liable to return this money, and I am being sued as the heir. It's not really an allegation that I have siphoned off the money as the wife or the minor child. So, my lord, if I am correct on the position of law, now, my lord, I had handed over a chart like this of the policies. It's there in my learned friend's petition as well as in the affidavit. No, chart. Of the policies that are involved. It's showing the front page below these of the
affidavit.
No, man, just I had handed over just for convenience. And it's in our affidavit opposition also. It's just for the. Yes. Well, we'll take this. I have to copy
this one.
Yes, ma'am. With the first page, because my lord, I'll just explain this chart. The life insurance policies are named 1 to 13. If my lord comes to the fourth column, date of commencement, all these policies were initiated or commenced before 2021. The allegation is from 2021 to 2024. For 4 years, the 4 financial years, the money has been taken out of the account.
Yes.
So, first point is date of commencement. That's why I've given the first pages. Then if my lord comes to the second last column, amounts received. So these amounts I have received. So the 1, 2, 3, 4 of them. And the rest I am yet to receive.
Yes.
And only one clarification that the insurance, which is number 4, that is my insurance, the wife's insurance. That has nothing to do with my husband's insurance. But that also hasn't been received yet because I'm alive in that sense. And the policy is still subsistence. So my arguments that I'll make today, my lord, is that not only does section 60B prohibit money being injuncted that is payable. This is payable, all the monies in the last column.
Yes.
I have still not received because my lord has passed an injunction.
Yes.
LIC, like most of them are LIC life insurance, is a party, defendant. And there's an injunction. They have not appeared yet. But so anyway, when these mature, the dates of maturity are given. There's some time left still. But when they mature, I am entitled to those. And of course, as on the death, I think they've already matured. These are the end dates.
Yes.
But I will get the money as soon as I can inform them that my husband has died. Yes. And these other ones, the monies that I have received. So I want to just show that it does not lose its character as insurance money. Because once the money has been paid out to the nominee and then to the heirs, that money does not, I want to show some judgments, that money does not lose its nature as money received under insurance policy and therefore is still protected under 60 KB. That is the intention that I was showing some decisions to my law. If I may show those. The other factual aspects, my lord, I have argued before my lord. I had shown details. I had given a letter to them that there were loan transactions between the plaintiff and my husband. There were commissions paid to me. All those, they have not disclosed their bank accounts and their IT returns. On the contrary, they have disclosed my husband's because they have the laptop and they have access to all my husband's papers because our auditors are the same. So the point that I had made initially was that it is unbelievable that a litigant, my lord, would be unaware that for 4 years money is going out of the account and this man is authorized to run your bank account and he is operating the bank account. So the money is going and then it's unbelievable, and the every year it's been audited. So they should have known. So on 3 principles of 4, my lord, I will cite cases. First is the application of 60 KB. My lord, I'll cite about 3 or 4 cases. And then a non-vigilant litigant is not entitled to an interim order. And third point will be that suppression of material facts. This suppression of the fact that my husband was actually doing other businesses with you. Like I had given him a loan, I had taken a loan, etc. That suppression disentitles you from getting an ad interim order. And finally, it is not up to them to decide, it's not up to a litigant to decide what is material or not. They should have come with all the facts and let your lordship decide. So on these 4 principles, I'll cite decisions and I'll be done. So on the insurance, my lord, the first decision I had cited already, I'm not repeating, 1984, 1 SCC 424, this Sarbati Devi. Yes. This is the mother case which says the nominee is only a receiver. The actual money will go finally to the legal heirs. So what my learned friend Mr. Mukherjee had argued was that the money that even after it is the policy is paid out, it belongs to the estate of the deceased and it doesn't belong to the nominee. Which I agree with, which this judgment also says, and based on this, most of the later judgments are there. So the first decision I want to cite today is, my lord, reported in 1986, AIR 1986 Bombay, 101, which is equal to 1984 SCC online page 246. And I'll place paragraph 1 and then 7 and 8. This clarifies the position. What is the fate of the money once it comes? Does it lose its character of insurance money? So, paragraph 1. Whether money is payable under an insurance policy on the life of the judgment debtor after the latter's death can be attached, or whether the payment of such monies to the nominee after the death of the assured can be restrained in a suit for recovery of monies borrowed by the latter, is the question in this appeal that gives rise and falls for my determination. So two things, Malad. This money that is lying with the wife today, it is a claim based on my deceased husband's claim. And they've also made me a party. So it can also be an independent claim against me. But this is the money I have received under a policy and is unattachable. That is why that's the argument. So it will cover both points. So paragraph 1. Now, my lord, we'll see paragraph 7. I'm not troubling my lord with the facts of that particular case. Paragraph 7. 7 I'll place in full and 8. This is which judgment? In Raja Ram versus Mata Prasad, a full bench of the Allahabad High Court held the view that the policyholder continues to hold interest in the policy till the moment of his death. And if the policy matures during his lifetime, then the benefit arising thereunder shall be his and not his nominee. Well, that is obvious that
correct, yes.
this doesn't apply. It further held that as the benefit secured by the policy forms a part of the estate of the deceased policyholder, his creditors can realize their loans from the monies paid to the nominee. The nominees in such circumstances would be the legal representatives of the deceased policyholder. This is an old case that had held this. This view was approved by the Supreme Court. Then, the Supreme Court observed that the summary of the relevant provisions of Section 39 of the Insurance Act established clearly that the policyholder continues to hold the interest in the policy during his lifetime, and the nominee acquires no sort of interest in the policy during the lifetime of the policyholder. If that is so, the Supreme Court further observed, on the death of the policyholder, the amount payable under the policy becomes part of his estate, which is governed by the law of succession applicable to him. Such succession may be testamentary or intestate, and there is no warrant for the position that Section 39 of the Act operates as the third kind of succession, which is styled as statutory testament. It is also observed that the provisions of Section 39(6), which say that the amount shall be payable to the nominee or nominees, does not mean that the amount shall belong to the nominee or nominees, and the language of Section 37 is not capable of altering the course of succession under law. So, Section 39 deals with what are the rights of the nominee. So, during the lifetime, they have no interest, and after the lifetime they are holding the money, but they are holding it for the heirs. That much is clear. Then, specifically, while disapproving the view of the Delhi High Court in Mrs. Uma Sehgal's case, my lord, the Supreme Court observed that the Delhi High Court had committed an error in placing reliance on the effect of the amendment of 61 KB CPC, which provides that all monies payable under a policy on a life insurance of the life of the judgment debtor shall be exempt from attachment from his creditors. It was observed that the High Court has equated a nominee to the heirs and legatees of the assured and proceeded to hold that the nominee succeeded to the estate with all plus and minus points. Having observed this much, the Supreme Court added that it is difficult to treat a nominee as equivalent to an heir or legatee, having regard to the clear provisions of Section 39 and the exemption of the money payable under the life insurance under Section 60. Instead of devaluing the earlier decisions which upheld the right of the creditor of the estate of the assured to attach the amount payable under the life insurance, recognizes such right in such creditor that which he could have exercised, but for the amendment. Therefore, this is the important part. Therefore, the court observed that in addition, that it is because the amount payable under the life insurance policy was attachable under the Code of Civil Procedure exempts it from attachment in further of the policy of Parliament in making the amendment. In view of the above decision, the Supreme Court in Sharbati Devi's case, it is no more possible to hold the view that the monies payable under an insurance policy do not become part of the estate of the deceased. However, the question before me is not whether or not the said monies become a part and parcel of the estate of the deceased, since the question is whether such monies are liable to be attached for the payment of a decree. Section 60 of the Code of Civil Procedure deals with the property which is liable to attachment and sale and execution of a decree, and its proviso lays down some items which are not liable to such attachment or sale. Clause KB speaks of all monies payable under the policy of insurance on the life of the judgment debtor and exempts such money from attachment and sale. Now, as already said, Mr. Perez Cardozo, that's the advocate, argued that since such monies are a part and parcel of the estate of the assured, the exemption of under clause 60 KB is not attracted. The reason behind this submission is that according to learned counsel, once the assured died, the money payable under the policy comes to his estate. Therefore, his heirs and legal representatives are appropriating the said monies, and as such, the monies are entirely outside the scope of KB. That was the argument.
Yes.
I am afraid that this reasoning of the learned counsel cannot be accepted. I say so because, first of all, one has to bear in mind the policy of the legislature that caused the exemption to be laid down. I am of the opinion, and I believe, that the legislature had exempted from attachment the monies payable under the policy of insurance of the life of the judgment debtor in order to give some security to the heirs and legal representatives of the deceased. This being the position, even though the said monies are becoming a part and parcel of the estate of the deceased, nevertheless, the exemption laid down in clause KB of the Civil Procedure Code follows the same money. I am fortified in this view by the observations of the Supreme Court in Sharbati Devi's case to the effect that the exemption was specifically laid down because the amounts payable under an insurance policy on the life of the person were otherwise attachable. In other words, the Supreme Court pointed out that had it not been for the specific provision of clause KB of section 60, the monies payable under the insurance policy on the life of a person would have become liable for attachment and sale for satisfaction of the decree. I am thus of the firm view that the monies payable under the insurance policy on the life of the judgment debtor are entirely exempted from attachment and sale by virtue of KB, irrespective as to the circumstance whether the policy matures during the lifetime of the assured or the monies become payable after his lifetime. The learned judge dismissed the application for injunction on the ground that since the monies payable to the respondent under the life insurance policy were not subject to attachment, it was not proper to restrain LIC from making payment. In light of the above discussion, I find no fault in the reasoning of the learned judge. So here also the learned judge had refused an injunction on LIC.
Insurance.
So this covers both points, that once even it does not lose the character. Even if this gentleman was alive and the policy matured, the money he would have got back, that would be protected because that is for his heirs. And so this is the first case, Bombay case. In fact, my lord, I should remind, I had cited a Andhra Pradesh judgment which had referred to this Bombay case. 2010 SCC Online AP 216.
Yes.
That covered all the. I did that first because it deals very succinctly with all the principles. So this is the Bombay case. Now I'll just cite two more judgments. One, Supreme Court. 2009 1 SCC 376. Yeah. This is just by examples, but it is not strictly on a life insurance matter. It's on retirement benefits, which comes under section 60, but I think G, not KB. This is just as an example I'm showing. My paragraph 33 and 35, just 2 paragraphs. Same principles will apply. As far as retirement benefits are concerned, section 60G would apply, not KB, but 33. 33, 35.
Yes.
And the conclusion paragraph I'll show 39, that's 1 line. However, 33. However, we are also of the view that having regard to proviso G to section 60, the High Court committed a jurisdictional error in directing that a portion of the decretal amount to be satisfied from the fixed deposit receipts of the appellant held by the bank. The High Court also erred in placing the onus on the appellant to produce the matador in question for the auction. That's not relevant. In other words, the High Court erred in altering the decree of the trial court and in its revisional jurisdiction, particularly, this is the part, when the pension and gratuity of the appellant, which had been converted into fixed deposits, could not be attached under the provisions of the Code of Civil Procedure. Then this decision is referred to, which had a contrary view. The decision in Jyoti Chit Fund has been considerably watered down in later decisions, which are indicated in paragraph 22 herein before. And it was held that gratuity payable would not be liable to attachment for the satisfaction of the decree in view of the proviso. Now 35, my lord. We also agree with Ms. Shobha that even after the retirement benefits, such as pension and gratuity, had been received by the appellant, they did not lose their character and continued to be covered by provision G to section 60. Except for the decision in Jyoti Chit Fund, which a contrary view was taken, the consistent view taken thereafter supports the contention that merely because of the fact that the gratuity and pensionary benefits had been received by the appellant in cash, it could no longer be identified as retirement benefits paid to the appellant. So that is rejected. They say it still retains its character. Paragraph 39, that's the answer. Let the fixed deposit receipts be released to the appellant. So they say that even though he had encashed his pension and gratuity, put it in a fixed deposit, he could identify it. So it was not liable to be attached. Then, if I may show, my lord, the Andhra Pradesh judgment I've shown, 2010.
Yeah, that is already there.
Yes. Then, this is the Madras. Not required. Well, there is another decision. I'll just show that. No. What's the citation? 2002, volume 3, LW. I don't know what that is. Weekly reports. 600. These were the. But this is an application under revision. It's also 60 KB, but here LIC challenged. They were injuncted from paying out the money.
Yes.
LIC challenged it. And if my lord comes to paragraph 5, and it was held that, and 7.1, paragraph 5, the only vital point for my consideration in the above revision is whether the policy amount payable by the third defendant, that's LIC, even though initially attached by an order before judgment on such and such, is attachable even after the suit. Namely, OS something is itself dismissed against the third defendant, and particularly whether the policy amount is exempted from attachment in view of section 60 KB. Then 60 KB is set out. And if my lord comes to the 7.1, or rather, my lord, paragraph 6, the next page, 602. So the same decision, the Bombay decision, was cited. While Mr. Subaya, learned counsel, appearing for the revision petitioner, placing reliance on Federal Bank, that's the 86 Bombay which I showed, strongly contended that the insurance policy amount cannot be attached as they are exempted under KB. Mr. Ramakant learned counsel for the first respondent resists the contention on the ground that proviso of KB is not attracted in the instant case, as the policy sought to be attached is not a policy of the judgment debtor, but of their father. So in our case, the husband. Then 7.1. KB of section 60 no doubt exempts all money payable under the policy of insurance under the life of the judgment debtor. But the policy amount under the insurance scheme only confers a right, not only confers a right not on the policyholder, but on his legal representatives. Therefore, the monies payable under the insurance policy of a judgment debtor are entirely exempt from attachment and sale, irrespective of the circumstances as to whether the insurance policy matures during the lifetime of the assured or the monies become payable after the death of the judgment debtor, as held by the apex court in Sharbati Devi. The legislative object behind the above exemption protected under section 60 KB is that the money payable under the policy of insurance of a life of a policyholder is intended to give some security to his heirs and legal representatives. Such legislative object, in my consideration, cannot in any way be diluted merely because the policy amount sought to be attached is that the judgment debtor or otherwise, as otherwise the intention of the legislature to provide security to the legal representatives of the policyholder would be defeated. If that be so, even though the instant case the decree holder proposed to attach the policy payable to the father of the judgment debtor, in my considered opinion, it would offend the legislative object enshrined under KB. And therefore, such policy amount of the father of the judgment debtor is also not attachable. Hence, the finding and reasons of attaching the policy amount of the judgment debt of the father of the judgment debtor is not justified and is opposed in spirit to the scope of section KB, and the revision was allowed. This LIC itself made this application. Then, yes, the Manu. Well, that's in a similar. In a similar vein, there are judgments of Karnataka. I'm not repeating; it's saying the same thing. The question is, the question that strikes me is, for how long? How long will this money remain? So once the money is invested by me for my personal gains, then perhaps it can be traced. But as long as it retains its character, here as far as the LIC amounts, I have not received anything yet, and that cannot be injuncted. That's clear, the provision. As far as the amounts I have received and they are lying in my account, those amounts also I respectfully submit cannot be attached. So this is on that point. And then the other two propositions that I wanted to cite, one was that the plaintiff knew from 2021 to 2024, he is accusing the deceased, the defendant's husband, of siphoning off money from his account. Now, this was as plain as daylight. It was reflected in his own bank statement. It was audited. So, non-vigilant plaintiff, my lord, is not entitled to any ad interim order or, in fact, any interim order at all. So that is why I'm, yeah. So then that is so a non-vigilant plaintiff who allows the property to be dealt with for a long period of time is not entitled to an injunction, which is an equitable relief. And then mere because of balance of probability, etc., is not enough to cover the delay aspect. So on that, just one decision, Manoj. And your lordship may recall, we had given we had given a letter to my learned friend, which was the last time I was arguing. Was that letter? Then I had handed over a copy asking for various details. And Mr. Chaudhary, Mr. Shobhushaji Chaudhary was appearing at that time. He said that we've just received it. We will take instructions. Yes, Manoj. That letter we wrote during the hearing.
26th March.
Yes, man. 26th March.
Yes.
Still now also we haven't got a response, but I will place this letter later to say that these are obvious documents that show me your bank statement, show me your income tax returns, were there any other transactions with my husband or not? Because they very subtly, my lord, and deliberately, I would say, they did not disclose these other transactions with my husband, which now by chance on one WhatsApp I got and one email I found that my husband is getting commission from this gentleman. So those two, on the basis of that, then we went through their accounts and it shows. I know. So one of that, this thing. So it also shows that I had advanced loans to the husband, to the plaintiff, my husband had rather, and the plaintiff had also given loans. And the interesting thing is there's no contract between and no privity between the plaintiff and my husband, because the husband used to work for a limited company. And he was an employee, and this gentleman was perhaps a director there. But as far as personal accounts, he himself has said, I've given him my phone number, the OTP, everything is the husband's number. So he's a trusted person. So when and if it comes to the suit, my lord, they will have to prove that A, B, C transactions were absolutely unauthorized and he got it. But whereas D, E, and F, which I disclosed in my affidavit, the response of my learned friends were that we have not asked for that money. Yes, 25 lakhs I had taken from him, but I have not asked for that money from him. But that's the last case I'll cite is you cannot pick and choose what materials you'll show the court. The court has to have a fair picture of all these dealings. Therefore, 2008 11 SCC page 1. This paragraph 21 and 22. This is for the proposition of a non-vigilant litigant. Justice S.B. Sinners. Well, the facts are not that relevant. It's just the principle which my lord knows very well. But anyway, 21, my lord, if my lord comes to 21. Because these are things that your lordship would not have known when passing the order.
22.
Yes, paragraph 21, 22 and 23. And also the last part of 25. Just from 21, I'll place one. The principles only. While considering an application for grant of injunction, the court will not only take into consideration the basic elements in relation thereto, that is, existence of a prima facie case, balance of convenience, and irreparable injury, it also must take into consideration the conduct of the parties. Grant of injunction is an equitable relief. A person who had kept quiet for a long time and allowed another to deal with properties exclusively ordinarily would not be entitled to an order of injunction. And from 2021, he has allowed me to even use my OTP, the PIN, even to use my telephone number as his operating account. So he has allowed another person to deal with his properties exclusively. The court will not interfere only because the property is a very valuable one. We are not, however, oblivious to the fact that the grant or refusal of injunction has serious consequences depending on the nature thereof. The courts dealing with such matters must make all endeavors to protect the interest of the parties. For the said purpose, application of mind on part of the courts is imperative. Contentions raised by the parties must be determined objectively. This court in M. Gurudas held, my lord, a finding on prima facie case would be a finding of fact. However, while arriving at such finding of fact, the court not only must arrive at a conclusion that a case for trial has been made out, but also other factors requisite to grant an injunction must exist. There may be a debate, as has been sought to be raised by Mr. Dhawan, that the decision of the House of Lords in American cyanamide case would have no application in a case of this nature, as was opined by this court in Colgate. But we are not persuaded to delve into that. Therein, however, the question in regard to a valid adoption of a daughter was in issue. This court held, that's not necessary if my lord comes to 25. 25. In Seema Arshad Zahir versus Municipal Corporation of Greater Mumbai, it is held, the discretion of the court is exercised to grant a temporary injunction only when the following requirement is made out. One is prima facie case. I'm not reading the whole thing. Two is when the need of protection of the plaintiff's right compared with or weighed against the need for protection of the defendant's rights or likely infringement of defendant's rights, the balance of convenience tilting in favor of plaintiff. So prima facie case, balance of convenience, and three, clear possibility of irreparable injury being caused to the plaintiff if the injunction is not granted. Then, in addition, the temporary injunction being an equitable relief, the discretion to grant such relief will be exercised only when the plaintiff's conduct is free from blame and he approaches the court with clean hands. So this is the fourth factor that must be kept in mind. And in this case, he has not disclosed that there were various other monetary transactions from the same accounts between the parties, which only a final, because I am really handicapped, I am not being accused of doing it myself. I have inherited this problem. So there. Now, as far as suppressing those facts are concerned, just to very quickly, my lord, I'll give the decisions. 2008 for SCC 127. Paragraph 13, just again, it's just reiterating the usual salutary objects, my lord. Paragraph 13.
Yes.
Suppression of material fact is viewed seriously by superior courts in exercising their discretionary jurisdiction. In SJS business, it was held, as a general rule, suppression of a material fact by a litigant disqualifies such litigant from obtaining any relief. This rule has been evolved out of the need of the courts to deter a litigant from abusing the process of court by deceiving it. But the suppressed fact must be a material one in the sense that it had it not been suppressed, it would have had the effect on the merits of the case. So here the suppressed fact is commissions and loans. We have also alleged fraud, no particulars of fraud. I'm not taking it that far. But as far as this suppression, then, my lord, the last few lines of that paragraph, my lord, the observation was quoted with approval by one of us in Orunima Borua's case, where the question which was raised, how far and to what extent suppression of fact by way of non-disclosure would affect a person's right to access to justice. The court notices that so as to enable it to refuse to exercise its discretionary jurisdiction, suppression must be of material fact. What would be material fact? Suppression whereof would entitle the appellant to obtain discretionary relief would depend on the facts of the case. So the material fact that I am stressing is the previous transactions between my husband and it shows that sometimes I gave him loan, sometimes he gave me, and it's reflected in their balance sheets itself, and they have not disclosed their balance sheets. And lastly, my lord, one decision, this reported in 2025 SCC Online SC 556. I'll be relying only on paragraph 9. Again, just on the principle, but the case itself, my lord, is on the history of Oroville and Pondicherry. It will be quite interesting, but I don't want to waste my lordship's time. But paragraph 9. And of course, this was to do with a writ petition, but the principles will apply to any civil litigation. It is no more res integra that the doctrine of clean hands and non-suppression of material facts is applicable with full force to every proceeding before any judicial forum. The party invoking the extraordinary jurisdiction of the High Court under Article 226 must come with clean hands and disclose all correct and material facts in his writ petition. If it is brought to the notice of the court that the petition has been guilty of suppression of material and relevant facts, or has not come with clean hands, such conduct must be seriously viewed by the court as an abuse of process of law, and the petition must be dismissed on the ground, that ground alone, without entering into the merits. As held in SGS, as a general rule, suppression of material facts by a litigant disqualifies such litigant from obtaining any relief. This rule has evolved out of the needs of the court to deter a litigant from abusing the process of court by deceiving it. Like that.
Yes.
On a lighter side, my lord, during COVID, it was necessary to come with clean hands. That was the court, especially. But SGS, which is quoted in both these decisions, I need not cite that, or I can cite it. 2004 7 SCC 166. Paragraph 13 again. Well, I just read that out. It's quoted in both those judgments. I don't need to read it out.
Yes.
As a general rule, suppression disqualifies a litigant from obtaining any relief.
Thank you.
So that. And then finally, one decision on that it is not for the plaintiff to decide what is material and what is not material. I have called upon them, my lord, to produce certain documents, but still they haven't done so. So this is 2013 11 SCC 531. Just one paragraph, 44. To 46, I'm sorry, 44. The topic is suppression of fact. This begins above 42. I'll start from 44. It is not for a litigant to decide what fact is material for adjudicating a case and what is not material. It is the obligation of a litigant to disclose all the facts of the case, leaving the decision making to the court. True, there is a mention of the order dated 2nd May 2003 in the order of 24th July. Passed by the JCC, but that is not enough disclosure. The petitioners have not clearly disclosed the facts and circumstances in which the order of 2nd May was passed or it has attained finality. So mere mention also doesn't make it correct. So if I have taken from his bank account, he should show his bank account. There are other transactions as well. Then 46, my lord, my turn. Page 40, paragraph 46. More recently, in Ramjas Foundation, the case law on the subject has been discussed. It has been held that if a litigant does not come to court with clean hands, he is not entitled to be heard, and indeed, such a person is not entitled to any relief from any judicial forum. It has been said, well, then, this is the, no. And the same thing, a person cannot come to court and get relief. I don't need to repeat this,
Yes.
Clean hands principle is very well known. Well, as far as if the allegations that have been made against my husband as on fraud, Your Lordship, I have already said that in my previous argument. I'm not citing a case on that. That fraud has to be got a higher standard of proof. Even in civil proceedings, it has to be beyond reasonable doubt, and particulars have to be particularly specifically stated. Well, just by saying that see my bank account, this money has come from X's account. That is not enough. I was authorized. He was to deal with this money. But if that money has come in, you must explain why this particular transaction and why not the other 25 lakhs. Those page numbers I had given, my lord, on the last occasion. Just, Your Lordship may just write them down just as an example. 592, 593 is the email where he is talking about my commission.
We got a 592.
And one is 25, that of the
98 of the AIU.
Yes, of the reply.
Of the AIR, 30 is the high-tech.
So all these particulars, my lord, I'm sorry, its time is up. All these particulars I have stated in my letter. So if my lord gives, I have more or less finished. I want to just highlight this. I can do it in my note. or my learned friends have not responded to this letter. So I can treat this letter as a part of my petition. The details are there. I've argued them at page 25. It's based on their documents. If my lord just sees this letter, then this will be my final argument. Well, we had initially asked them for their income. So may I just place this? We write to you in reference to your affidavit in reply. It's a how many volumes? 4 volumes. Many volumes, my lord, of the affidavit in reply. I didn't get a chance to deal with it. It is noted that in that annexure A of the said affidavit seeks to disclose income tax returns of the deceased, as also defendant number 1, whom we represent. Please disclose the source of your client's procurement of the income tax returns, which is a confidential document and could not have been. So my accounts have been revealed by them. They couldn't have got that. This, they have the common auditor, they must have got it. But be that as it may, we have asked them for their source, they have kept quiet. Then without prejudice to our client's objection with regard to the confidential document and without prejudice to the authenticity, we call upon, our client calls upon, it should be you, to explain the following particulars. At page 25 of the affidavit, a balance sheet of 31st March 2021 of Kirti Lunia, deceased, is disclosed, which is an unsigned document, and without prejudice to our client's objections, our client notes that in the asset side, under the item loans and advances, rupees 25 lakhs is shown as receivable from the plaintiff. I had pointed these out to my lord anyway. Then at page 30, similarly, under loans and advances, rupees 20 lakhs is shown payable to the plaintiff. So basically the next year, first year it shows that 25 lakhs he owes me, next year it shows 20 lakhs I owe him. So there must have been a transaction for 45 lakhs. That's what we've written. That this in effect means that there has been a total payout of 45 lakhs by the plaintiff to the deceased in the financial year 21-22. Between the period 1st April 21 to 31st March 22. Our client calls upon your client to produce full details and particulars of the aforesaid payout of 45 lakhs to the deceased, including date of payment, mode of payment, etc. Then further in the balance sheet, or again disclosed by them, the asset side shows a heading loans and advances, rupees 40 lakhs shown as advance to High-Tech Air Systems. This is a firm in which the plaintiff is a partner. And he alleges that I am the accountant of that firm. So if I am an accountant, why am I giving a loan to my master is not really explained. Our client calls upon you to furnish details, full details and particulars of the receipt of the aforesaid 40 lakhs during the financial year such and such, including date of receipt, mode of payment, etc. Then your client is also called upon to furnish the authentic balance sheet of the plaintiff, because they will also, if they have shown my accounts, unsigned accounts of my husband, then their accounts should reflect these also. So we have called upon them for their authenticated balance sheets for these 4 years. And they would, I'm surely it will show that this money has gone out from their bank account. Somewhere it will be reflected. So these are the real documents that from their own documents we could cull out and say that my lord, that these are the material facts that have not been shown to my lord when passing that order last year in September. Then 4, similarly drawn to page 592, where you have disclosed the year-to-year share profit and commission statement. You shall note that at page 593, a sum of rupees 25 lakhs was paid to the deceased in the year 2021. You are requested to produce details of all payments made to the deceased and commissions along with corresponding bank statements. It is for the submission in court was that we have not claimed this 25 lakhs from you in this proceeding. It is further evident that from the affidavit in reply that a dedicated email being Kirti Lunia at the rate of such and such was being operated by the said deceased. You are called upon to provide us access to the entire information and all the emails, because that was the account that was used to operate these bank accounts with his blessings. then this personal information is lying with you. And then again in paragraph 6 at page 25 of the affidavit in reply, where assets side, there is a payment receivable from Meho HCP Air Systems. We have found out on inquiry it is owned by the plaintiff company. So we want details of the master data of that company, which will show the connection. So, my lord, we are really clinging at straws. We have found these, but these documents itself, my lord, raise a triable issue.
Yes.
It shows that suppression was made, but of course, on the as far as the insurance money is concerned, either the ones that have already been encashed or not, my lord, those I was praying that the injunction be lifted or be vacated, because this is the final hearing. And if all else fails, my lord, I think it's a sound argument, but if all else fails, then before at least the vacations, there was leave was given to me to use 24 lakhs. I have a minor daughter, goes to school, etc. So if this money is released to me, then I'll be okay, and they can fight about the rest of it. And otherwise, I will be praying, my lord, for some money to be released so that at least they can continue their sustenance, my lord.
Okay.
So those are my submissions.
Thank you.
May I beseech your lordship to keep it on the 27th of August?
No.
Huh?
Yeah, I
On the
mean,
27th.
last week I'm not. Any other week.
Oh.
Sir, आगे होगा ना?
No, Gopal, the 27th है खाली আছে.
1st September.
1st September or something? Kindly bear with me for one day.
হ্যাঁ, পুত্রটাকে আগে করবো।
But second half, 1st September.
Need time.
Impossible for your lord.
345.
345. 2nd September, 345.
At the Leonard
345.
Dependent number 2, na? Mr. was 2.
I'm for the wife, daughter, and the HUF. The 1, 2, 3.
1, 2, and 3.
1, 2, and 3.
1, 2, and 3.
The others are the insurance companies. I don't know if
For
they've
the
been served.
petitioner pays for time to give reply. Let the matter appear on 2nd September at 3:45 p.m.
Wait, the interim order be extended is expiring on the 12th.
22nd.
On the 22nd.
Interim order?
Is expiring on the 22nd.
Interim order is extended till 10th of September 2025 or until further order.
I will, on that day, I'll pray. If it doesn't finish, pray for some release of some. That was the division bench order.
Yes.
That allowed me to take such.
Great.